in-law also is made a party. He is in an MNC, so he is about to lose his job. That's why, my lords, we had
2:30.
moved before vacation also. Unfortunately, it's not getting
2:30.
any day.
ನಾಳೆ ಆಗುತ್ತೆ.
ಯಾವತ್ತು?
Pending ಆ fresh ಆ?
Lords, it's pending matter which your lordships have granted a stay, so that's why I'm moving. Because now, my
What's the
lords,
problem now?
now, my lords, the father-in-law is also, the boy's father is also made a party. Boy lost his job. Now, my lords, because it's
Friday
also,
ಆಗ್ಬೋದು.
avattu,
Friday ಬರುತ್ತೆ.
please.
Pending ಆದ್ರೆ Friday.
Lords,
Friday.
my lord, the trial court has rejected the amendment application, in a suit for partition. I got the facts where how the property
Give it,
is
sir.
acquired.
ಎಲ್ಲ day after tomorrow.
CRP.
Give all the memos.
The office of the
CRP ಇದ್ರೆ ಕೊಡಿ.
Not CRP.
Give it Thursday. CRP Thursday. Give it.
The lordship,
Tomorrow.
my lords,
ಎಲ್ಲೇ ಬಿಡಿಯೇ ಎಲ್ಲರೂ ಒಟ್ಟಿಗೆ ಹೇಳಿದ್ರೆ ಯಾವ ಮೆಮೊ ಏನದು ಸ್ಪೀಚ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ? ಪೊಲಿಟಿಕಲ್ ಸ್ಪೀಚ್ ಇಲ್ಲಿ. ವೇಟ್, ನಾನು ತಗೊಂತ ಹೇಳ್ತಾನೆ ಇದ್ದೀರಾ? If all of you speak, what do I hear? Give it. Yes. Give, sir. ಎಲ್ಲ ಮೆಮೋಸ್ ಕೊಡಿ ಅಂತ ಇದೀನಿ. Why you want to mention?
my
It will
lords,
come.
my lords, in one of the GMCPC matter,
ನಿಮಿಷ. ಏನ್ ಹೇಳಿ ಅದು? All right. Give it. 2:30. Pending ಆ fresh ಆ? Pending ಆದ್ರೆ day after tomorrow. Give it. Tomorrow, day after tomorrow ಕೊಡಿ. Yes.
Lordship, this is a pending matter. A student has.
GMCPC?
No, my lord.
Then Friday.
306, my lord.
Friday.
My lord, GMCPC.
ಏನ್ stay ಕೊಟ್ಟಿಲ್ವಾ? Stay ಇಲ್ವಾ?
No, my lord has granted a stay.
Then what is the hurry?
My lord, charging has been filed. He wants to apply for masters right now and the visa problem.
He's a student, is it? All right.
My lord.
LABDA matter, lordships.
ಕೊಡಿ ಎಲ್ಲೇ ಬಿಡಿ ಎಲ್ಲ ಕೊಡಿ.
Tomorrow, lordships, we have filed an application.
Tomorrow or Thursday they'll come give it.
My lord, with permission, my lord.
ಮತ್ತೆ ಎಲ್ಲರೂ ಹೇಳ್ತಾರೆ. Wednesday. GMCPC.
My lord, with permission.
No tomorrow. Yes. Only Monday, Wednesday, Friday GMCPC.
It's a pending matter, GNCPC. Last week Wednesday was respected.
ಪರವಾಗಿಲ್ಲ ಕೊಡಿ.
My lord, with permission, my lord. Memo. Sir.
Friday,
Give it.
but Friday the matter did not come forward.
It will come, sir. Give it.
Wednesday is an extreme emergency.
We'll see. It will come. Give it. Yes.
School has to be reopened in this.
ಕೊಡಿ. Yes.
Last week night they reopened.
ಆಯ್ತು. We'll see. ಕೊಡಿ.
Wednesday, my lord.
Wednesday or Friday it will come. ಕೊಡಿ.
My lords, one BDA matter pending. It was heard by the.
Give it. Friday.
my lord,
Only Fridays.
my lords, they have failed to comply with the order of this honorable court. That is on GMCPC, my lords. Directed to deposit the 80 lakhs, my lords. But they have not done so, my lords. That's why I have filed.
Day after
Tomorrow, my lords.
Not
Yes,
tomorrow.
day
Day
after.
after tomorrow.
My lord, fresh matter, my lord, CPC. My lord, the urgency is, my lord.
ಕೊಡಿ. ನಾಡಿದ್ದೆ ಕೊಡಿ.
Lord,
ಏನು?
tomorrow is the last date.
For what, sir?
If union, I'm a bank, my lord, it's letter of credit. Under commercial court keeps its order in abeyance and directs Union Bank to pay. Then later modifies its own order. If I don't get the payment by tomorrow, my lords, I'll be forced to declare Union Bank as NPA. I am for Kotak Bank, my lords. I have nothing with the underlying.
2:30 ಕೊಡಿ.
Please.
One matter, my lords, before the suit for partition, my lords, before the trial court matter has been settled, my lords.
Settlement.
Settled matter.
ಮೇಡಮ್ ಅದು ಯಾವತ್ತು ಬೇಕು? Settlement.
This matter, my lord, matter was listed on Friday, my lord. And the matter was heard from the both sides, my lord.
ಯಾವ್ದು ಅದು?
Reserve or not.
ಸರಿ ಏನಾಗ್ಬೇಕು?
Further hearing, my lord.
Why?
Because they have filed objection, my lord, on the same day when the matter was heard, my lord.
All right.
Because we didn't have a opportunity.
All right. Friday.
Friday.
Serve the counter in advance. ಅದು ಫ್ರೈಡೆಗೆ ಹಾಕಿ. ಅದು ಮೊನ್ನೆ 6:30 ವರೆಗೆ ಆಯ್ತಲ್ಲ ಅದು. File is in the chamber. Give it, sir. Give it, sir. Give it.
My lord, with permission, my lord. GMCC for B group, my lord, 2005 suit, my lord, that's why they
Give it. Yes. Pending ಇದೆ ಅಲ್ವಾ?
pending ಇದೆ some.
Land acquisition matter, my lord. NHA is utilize the land without acquisition, my lord.
Give it, sir. Yes.
Lords,
Kindly, my lord.
Lords, one disposed of matter, my lords, the garbage matter which your lordship was.
ಯಾವ್ದು?
Garbage matter which your
All
lord-
right.
which your lordship had given liberty to not continue with the fresh tender that is now
Yes.
notified. Lords, they are not proceeding with that tender. Instead, they have notified one more tender, my lords, in spite of direction of this honorable court.
Lordship had granted liberty there from filing a review.
ಕೊಡಿ
230 minutes.
2:30 ಹೆಂಗಾಗತ್ತೆ ಫೈಲ್ಸ್ ಅಲ್ಲಿ
ಇಲ್ಲ ಪ್ರೀ ಬಿಡ್ ಮೀಟಿಂಗು ಆಗಿದೆ, ಬಿಡ್ ಸಬ್ಮಿಟ್ ಮಾಡಕ್ಕೆ ಹೇಳ್ತಾರೆ.
ಕೊಡಿ. ಎಸ್
Please.
ಪೂರ್ತಿ ಆಸ್ ದಿ ಅಡ್ವೊಕೇಟ್ ಜನರಲ್ ಟು ಕಮ್ at 2:30.
Much, please.
One matter on 13th, Friday, it was reserved. The better short synopsis.
Give it.
My lordship, serial number 93 with withdrawal.
My lord.
93, my lordship.
Any adjournment, madam, after preliminary hearing, correct. From orders. GMCPC na? Criminal appeal.
Shipping matter.
Friday, kodi.
My lord, this is a pending land acquisition matter.
Give it.
Then I wanted it.
No
for
date.
tomorrow.
Give it. Yes. Adjournment from 58 onwards. Correct.
For adjournment, page 7, 58, 59. Page 9, 60 to 62. Page 10, 63 to 67. Page 11, 68 to 74. Page 12, 75 to 81. Page 13, 82 to 87. Page 14, 88 to 93.
93.
88 in.
The parties are trying to settle the matter, my lords, kindly be for adjourned to 1 week.
Have you informed the other side?
Yes, ma'am.
Counsel for the petitioner.
Yes.
Counsel for the petitioner seeks adjournment on the score that the talks of settlement between the parties are afoot AF40. List the matter 2 weeks bit on date.
Serial number 93, my lordship. I withdraw the petition.
93 withdrawal in terms of settlement ಅಂತ ಇದೆ.
ಹೌದು ಸ್ವಾಮಿ, ಅದು ಸೆಟ್ಲ್ ಆಗಿದೆ, ಮೆಮೊನು ಹಾಕಿದೀವಲ್ಲ.
ಬಿಡಿಯೇ?
ಹೌದು.
Yes. Withdrawal memo in terms of the memo. Yes, call the
List 2, my lord. List 2,
List two.
list 2 ಏನಿದೆ?
Non-compliance plan.
43, my lord.
Serial number.
list 2 ಇದೆಯಾ ಮೇಡಮ್ ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀರಾ? ಇದೆಯಾ? ಎಷ್ಟಿದೆ?
And permission, my lord. List number 2, serial number 43, permitted to withdraw, my lord.
ಒಂದು ನಿಮಿಷ. First time matters.
List number 2.
1 to 22.
My lordship, serial number 17, my lordship.
Anybody wanting to withdraw there?
No, my lordship.
Serial number.
CRP to be converted into appeal, my lordship.
ಯಾವ್ದದು? Serial number?
Serial number 17. Appeal for petition.
Maintainability. The counsel for the petitioner submits that the matter has to be the GMCPC and not CRP. In that light, the office objection square maintainability stands sustained. The petitioner is permitted to convert the CRP into a GMCPC for the statistical purposes. So
My lord, serial number 24, my lord.
Serial number 11.
wait, in 11.
11 and they have raised the office of
Uh,
indicating that provision is not proper ಅಂತ.
ಮಾಡಿ.
Already proper ಇದೆ.
No problem. Yes.
Proper ಇದೆ.
ಅದ್ ಬರ್ಕೊಡಿ ಪ್ರಾಪರ್ ಇದೆ ಅಂತ.
My lord,
Serial number
2, 1 minute.
24.
1 to 22, except the ones I have said, 2 weeks' time is granted to comply with the office objections. In the event they stand complied, the registry to post the matter on the ensuing Monday without a memo being moved from the hands before this court. Yes.
Serial number 24, my lord.
Ensuing? CRP nadu? Thursday, sorry. Ensuing Thursday.
Seri-
1 minute.
Make a memo to convert it to writ petition.
Wait, sir. Yes. Serial number?
24, my lord.
ಏನು?
CRP converted to.
Same order. Madam, ಇದರಲ್ಲಿ 17 ಮಾಡಿದ್ನಲ್ಲ, same order. 24. Yes, next.
Much of.
ಇದು 2 week, second time ಇರೋದಲ್ಲ, 10 days time, same order.
ಇದರಲ್ಲಿ 33, serial number 33.
31 withdrawal ತಗೊಳ್ಳಿ ಅದು. In terms of memo.
Serial number 28. 33 ಅಲ್ಲಿ caveat respondent.
33?
33 and the respondent.
So?
ಇದರಲ್ಲಿ ಅವರು ಮೂವ್ ಮಾಡ್ತಾ ಇಲ್ಲ, ಅಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಬಂದು ಟೈಮ್ ಕೇಳ್ತಾ ಇದ್ದಾರೆ.
Thursday ಬರುತ್ತೆ. Yes.
ಸ್ವಾಮಿ, ಈ Thursday.
ಈ Thursday. Yes. Next.
See on the 33.
Next.
time matters. 38 to 47.
1 week, same order. Third, fourth, sixth, 1 week, peremptory order. In the event the office objections would not be complied, the petition would be dismissed for non-prosecution. ನಿಮ್ದೇನು? Serial number. Serial number. 35, same order. 17 ಹೇಳಿದ್ನಲ್ಲ ಜಯ, same order. Yes,
Number 43 permitted to withdraw.
43 memo kodi.
Serial number 14. Serial number 14.
Ah.
It can be converted to RFM, my lord.
14,
Second list.
maintainability, same order.
Yes, sir.
Yes. Call the case.
List 1 being spoken, still number 1.
Lords can permission,
Vijay.
my lords. Please. Pray for my lord's indulgence again.
After I finish all this, can I take today? You're ready?
Please, my lords, Monday, my lords. My lords,
Is it Monday?
My learned friend has been kind to give me another set, my lord, of papers.
All right, Monday. List the matter on Monday
Much obliged.
at 4:30 PM.
Please, please,
In the same-
much obliged.
Under the same caption. Yes.
Serial number 1. Number 6.
Preliminary hearing, still number 2.
This matter requires to be fully heard. It should take some time.
Files for amendment of application IA number 344 of 25. Subsequently, we cleared the objections. It has already been heard and it has been posted for orders on the 27th of June. Therefore, this IA is rendered instruction. We request that
But some time would take.
ಯಾವ್ದು ಏನಿದೆ?
Still number 2, WP relates to a trust matter. Where, Lord, I have invested about 47 crores in the trust. And they gave me the.
So what is under challenge?
Trial court's order, Lord.
What order?
Rejecting injunction, restraining them from permitting me to act as a trustee.
Apart from all other things, my lord, your lordship may kindly see page 151 for a moment.
In any case, it requires argument. If my learned friend
It
is
may
ready,
not,
then
it may
senior
not
counsel
require, my
is
lord, kindly see
ready,
page,
then we are ready.
kindly see page 151, my lord.
Yes,
Earlier application and the prayer,
same prayer, huh?
same prayer,
Rejected.
This is,
rejected.
Lord, there is a different context to this. What has happened is, this was in
ಈಗ Interim order
2015.
ಇದೆಯಾ ಇಲ್ಲಿ?
This was in 2015 by a court which did not have jurisdiction. This honorable court said that this is a Bangalore court which has no jurisdiction. You would have to approach the appropriate court. Then this same matter was shifted to the Shimoga court. In Shimoga court, before the district judge, it
ಅಲ್ಲ
was then
ಎಲ್ಲಾದ್ರೂ
shifted to the
ಆಗಿರ್ಲಿ, same
senior-
application.
Senior division.
Same application
not the same
came to
application.
high court, confirmed
It is
in
not-
high
it is
court,
not
they
the-
went in
it is not the same
SLP,
application.
SLP rejected.
ಮತ್ತೆ ಏನ್ ಹಿಯರಿಂಗ್ ಇದ್ರಲ್ಲಿ ಏನಿಲ್ಲ.
It is not the same application. There have been subsequent developments which have not been taken into consideration.
ಎಲ್ಲ trial court will decide everything.
No, my lord, there have been subsequent developments. Can I just argue, my lord?
If you want to, no problem. Or you want, let me finish the preliminary hearing.
ಇಲ್ಲ ನಾಳೆ 2:30.
ನಾಳೆ 2:30 ಆಗಲ್ಲ, 4 o'clock reference ಇದೆ. It is.
Or tomorrow
setting
morning
is-
itself we'll learn.
ಅಲ್ಲ, I'll take it day after tomorrow.
Day after.
ಬುಧವಾರ.
ಆಯ್ತು. ಬುಧವಾರ 2:30.
ಬುಧವಾರ 2:30 ಆಯ್ತು.
2:30 ಅಂತ ಹೇಳಿ ಏನ್ ಬೇಡ.
ಬುಧವಾರ
Morning I will finish.
ಬುಧವಾರ ಬೆಳಗ್ಗೆನೆ ಮುಗಿಸ್ಬಿಡಿ.
ಬೆಳಗ್ಗೆನೆ.
There's nothing in this.
No, Lord. Point is this. What has happened is.
ಈಗ ಬುಧವಾರ
Let me just clarify.
ಬುಧವಾರ
Let me just clarify.
ಬುಧವಾರ
After investing 47 crores, what they have done, they have made certain allegations against me and removed me as a trustee. And this 47 crores was invested to save the institution and to get them recognition.
No, the institution has gone somewhere.
The institution is there, but they removed me as a life
You are
trustee,
not there.
which could not have been removed. They could not have removed.
Where is the interference? Court ಮಾಡ್ತಾರೆ.
Angala, Lord, what has happened? See the injustice, Lord.
What?
In 2012, they roped me in as a trustee because I've invested this amount of money, and then within 6 months they remove me. They throw me out of the
6
trustee.
months ಅಲ್ಲಿ 47 ಕೋಟಿ ಖರ್ಚು ಮಾಡ್ಬಿಟ್ರ?
ಖರ್ಚು ಮಾಡಿದಲ್ಲ.
ಅಲ್ಲ, ಇನ್ವೆಸ್ಟ್ ಮಾಡ್ಬಿಟ್ರ?
They took that money. ಹೌದು. After I invested, after I gave
6
that money.
ತಿಂಗಳಲ್ಲಿ 47 ಕೋಟಿ.
6 ತಿಂಗಳಲ್ಲ. After I gave that money, they removed me. They, as far as they waited for me to invest this money in order to revive the trust and the medical college. After I revived the medical college, then they silently, casually removed me and took over the entire trust. And thereafterwards, they have diverted all these monies by forming a private partnership. But clear case of
We'll
fraud.
hear.
And when that order was passed.
adjournment ಆಗೋಗಿದೆ. ನಾಡಿದ್ದು. Yes.
ನಾಳಿದ್ದು ಮಾರ್ನಿಂಗ್.
ಆಯ್ತು, ಈ ಸ್ಟೇಜ್ ಅಲ್ಲೇ ಇರುತ್ತೆ.
Number 3.
Lord, amendment application to amend the written statement has been rejected.
When were the issues framed?
Lord, still evidence is yet to be commenced, Lord.
Anything else?
At that time, Lord.
Anything
One
else?
judgment, Lord, I am just
Oh,
relying
please,
upon.
sir, ಕೊಡಿ. ಇದೆಲ್ಲ ಹಳೇದಾಗೋಗಿದೆ. Anything else, sir?
ಅದೊಂದೇ.
Yes.
Now, Lord, what has happened is, they said, in the beginning, it was said, it is ancestral property. Then, Lord, I found that it is granted to my father. Then, my Lord, this application came to be filed.
No
Before commencement of trial, the application came to be filed.
No problem. Perfectly justified.
Lord, Lord, the
No,
trial
sir.
court has not gone into the
No,
judgment
no,
also. It just said, my Lord,
If it is before framing of issues and commencement of trial,
if it is before, it is before commencement of trial. Lord, that is one of the ground.
ಈಗ ಏನ್ ಚಾಲೆಂಜ್ ಮಾಡಿರೋದು ನೀವು? ಅಲೋಯಿಂಗ್ ಆಫ್
Rejection.
ರಿಜೆಕ್ಟ್ ಮಾಡಿದ.
Rejection of written statement.
When was the issues framed?
Issues framed date ಗೊತ್ತಿಲ್ಲ. But before commencement of trial, Lord, that I have mentioned in the, one of the grounds, Lord. Ground number 4, page 9.
I thought you were challenging the allowing of it. The petitioner is defendant number 8. Files an application under Order 6 Rule 17 seeking amendment of the written statement. The amendment of the written statement is preferred on the score that written statement was preferred by every other defendant and the petitioner had independent claims to be defended to and therefore had preferred a separate application seeking amendment of plaint. In that light, the amendment of plaint, all this has happened prior to the framing of issues. This, if it is prior to the framing of issues and the petitioner defendant number 8 had an independent claim, the court prima facie ought to have permitted such amendment. In that light, there shall be an interim order of stay of further proceedings before the concerned court list on 2nd July.
Correct.
Yes. Petitioner to, who is the contesting respondent?
Only first defendant, first respondent.
The petitioner shall serve on the counsel plaintiff here.
Plaintiff is.
Petitioner shall serve on the counsel who represents the plaintiff, the first respondent herein, and file an acknowledgement in the next 3 days.
Please.
List on 1st July. 2nd July, sorry, next.
4.
My lords, I am for the petitioner. Appeal was dismissed only on the ground of delay, my lords.
I'll see. Notice.
Yes, sir.
Emergent notice to the respondents returnable by the 9th of July.
Much obliged, my lord.
Next.
5.
For the petitioners, my lords, there are 2 petitions clubbed, my lords.
Order 26 Rule 9.
Please, my lords. 5.1 is for appointment of a court commissioner. Suit is for recovery of money and damages, my lords. Petitioner is a developer who entered into a JDA with the landowners who are the defendants.
All right.
As per the JDA, my lords, the obligation on the defendants was to provide plan sanction. Subsequently, the plan sanction was given to the plaintiff and the construction of 2 warehouses were carried on. Post construction, my lords, there was an issue with regard to the first warehouse. They were not letting me to occupy the first warehouse. Subsequently, the plaintiff became aware that the plan sanction which was given to the...
Both these petitions call in question Order 26 Rule 9?
No, my lords.
What is the first one?
First one is for allowing of the application filed by the defendant for production of additional documents.
All right.
Second one is dismissal of my application for appointment.
1817, first one, no?
Please.
Yes.
Please.
So it's 1817 and 26-9.
26.
All right, yes.
Subsequently, my lords,
You are now submitting the first one?
5.1, my lords, 27706, 26.
27706 is 5.
5.1. That is what the list. Please, 27706.
That is 5, sir.
5.
5.1 is 7748. Now, what is the challenge in this?
27706 is 26 Rule 9.
Right.
Dismissal of my application.
What is the stage of the proceedings?
It was at the stage of arguments, my lords, when this application was sought to be filed.
Why did you file this?
My lords, what had happened is, there was a kaludari which ran through the warehouse. There were 2 warehouses which was constructed in the property. One on the rear portion and one in the front portion. The dispute was that there was a kaludari which runs through the warehouses, through the first warehouse. But they were disputing that it does not run through the warehouse, but it runs between the 2 warehouses, which do not cause any...
Suit for?
suit for recovery of money and damages, my lords.
How is that relevant for a court
Because, my
commissioner to
lords,
go
my
and see
damages-
Kalda ellide adella?
Please, my damages is for the cost of construction that I have incurred in construction of the first warehouse, because I
ದಾರಿ
was-
ಮಧ್ಯದಲ್ಲಿ ಹೋಗುತ್ತೋ ಆಚೆ ಹೋಗುತ್ತೋ how is it relevant for recovery of money?
warehouse ಮಧ್ಯದಲ್ಲಿ ಹೋದ್ರೆ I can't use the warehouse, my lords.
So warehouse ಮಧ್ಯದಲ್ಲಿ ಹೋದ್ರೆ you are not using the warehouse.
I can't use the warehouse.
All right.
And this was misrepresented, and I was not I was not aware of this fact that the Kaludari runs through the warehouse and not between the warehouse.
Recovery of money for what purpose?
Recovery of money is for the security deposit that I had paid at the time of JDA,
Joint development.
Joint Development Agreement.
That's cancelled now?
No, my lords, that is not cancelled.
Then what is the suit
Construction
for?
was complete.
Only for that. All right, yes, sir.
My lords, sequentially ತಾವು ನೋಡಿದ್ರೆ
And one minute, what are, you are the petitioner. 1817 lane, what did you want to produce?
My lords, 1817, I want some time, my lords. We are planning to withdraw that petition.
Which is 5.1.
5.1.
So you are only submitting in 5.
Submitting in.
Yes, sir.
Let's see if I'm permitted to, let's produce the documents, because let's, the reason is this. They, a photocopy, a Xerox copy of a certain plan which they say was, my lords, sought to be produced, which was rejected by the trial court. My lords, this matter came before.
11 o'clock, 2 minutes silence, I'm told.
The entire controversy, my lords,
Yes.
is they wanted to produce a Xerox copy of a document which the trial court did not permit. My lords, they came in writ petition before this honorable court. That writ petition is pending. By way of an interim arrangement, Lineage permitted them, okay, the Xerox copy be marked. So in the, my lords, that photocopy was marked. Now in the set circumstances, my lords, how that document is a created document, I need to, my lords, prove my contentions. And I applied for a certain copy when the application was made to the BBMP and the like few of these applications. And my lord, that was shown to the witness, and I can't expect defendant to accept whatever I confront him. My lord, defendant, he pleaded ignorance. My lord, I made an application to produce production of those documents, and that application trial court rightly allowed.
That is what is challenged. He wants to withdraw it. So
if it is consenting it,
I will grant that time and post this on Friday. We'll pass orders on Friday on 26/9 application.
both the applications.
No, both ಅಲ್ಲ. ಅದು withdraw ಮಾಡಂಗಿದ್ರೆ ಅದ್ರ ಮೇಲೆ ಯಾಕೆ?
ಅಲ್ಲ, ಆರ್ಡರ್ ಅವತ್ತೇ ಆಗ್ಬೋದು ಸರ್.
ಅದೇ, see, ಅವ್ರು withdraw ಮಾಡಬೇಕು ಅಂದ್ರೆ ಮಾಡ್ಲಿ. How can you come there? Your application is allowed.
Yes, please.
Yes.
Now
26/9 we'll see.
Please.
Yes. That's 26/9. They are also not in cross examination. They said they have no issue in appointment of court commissioner.
ಅದು ಕೇಳಿ ಆಗೋಂಗಿದ್ರೆ ಆಗ್ಲಿ, ಇಲ್ಲಾಂದ್ರೆ ವಿಲ್ ಪಾಸ್ ಆರ್ಡರ್ಸ್.
Yes, if they are okay, you can pass.
Application. No. In a different context, like, a question was asked to the witness, commissioner appointment parvagilla. The witness said, ನನಗೆ ತೊಂದರೆ ಇಲ್ಲ. That's what the apply. Now that can't be solved. That's it. That's.
ಅಲ್ಲ ಪರವಾಗಿಲ್ಲ, ನಿಮಗೇನ್ ತೊಂದರೆ ಇಲ್ಲ ಅಂದ್ರೆ ಹೇಳಿ. ನಿಮಗ್ ತೊಂದರೆ ಇದೆಯಾ?
ತೊಂದ್ರೆ
ಇಲ್ಲ.
ಸ್ವಾಮಿ,
ರಿಕವರಿ
fact,
ಸೂಟ್
it will
ನಲ್ಲಿ
help both the
ಕಮಿಷನರ್
parties.
ಅಪಾಯಿಂಟ್ ಮಾಡಿ ಸ್ಪಾಟ್
we'll see.
ಇನ್ಸ್ಪೆಕ್ಷನ್ ಮಾಡ್ತಾರೆ.
Will answer whether it's necessary or not. Friday.
Please.
Yes, list the matter on, interim order ಇದೆಯಾ?
Please.
List the matter on Friday. I will not record anything. The other petition you want to withdraw, you withdraw. Yes, interim order subsisting will continue.
And if it is for orders on that day, I have one submission in so far as commissioner's application is concerned. Commissioner application, commissioner, if at all, assuming, I don't want to say, assuming if it's allowed, commissioner shall consider all the records, revenue documents and conduct an inquiry.
ಅದು ಈಗಲೇ ಮಾಡ್ಬಿಡ್ತೀನಿ.
ಮಾಡ್ಬಿಡಿ.
ಸರಿ, ಅಷ್ಟೇ.
The relief is
We'll see. ಇನ್ನೊಂದು withdraw ಆಗ್ಲಿ ತಾಳಿ. We'll take it on Friday anyway. Yes.
Obligement. If a commissioner is appointed, commissioner shall consider all the materials.
We'll pass it on. List on Friday.
Bill number 6.
This case, my lord, I am appearing for petitioner, my lord.
ಇದನ್ನ allow ಮಾಡ್ಬೋದು ಅಂದ್ರಲ್ಲ?
Please, my lord. Parcel.
Yes, only insofar as your claims are concerned. Disposed.
Disposed and maybe directed trial court to record the compromise.
That I will.
Please.
There is one judgment of Justice R. Nataraj.
No, judgment, my lord,
What is-
partial decree is permissible. Para 59, my lord.
Yes.
Para 59.
ಅಲ್ಲ ಇದನ್ನ ಫಾಲೋ ಮಾಡಿ, ಜಸ್ಟಿಸ್ ನಟರಾಜ್ ಅವ್ರದ್ದು ಒಂದಿದೆ, ಆರ್ ನಟರಾಜ್. We'll see, we'll find it out.
I'll.
Yes.
7.
Seek for a pass over. Seniors and Lex in the other court, my lords.
Then vacating stay na? ಏನ್ ಇಷ್ಟೊಂದಿದೆ ಎಲ್ಲ not unserved.
Lords, we have filed a memo for dispensation of notice to respondents. This is the matter in which 400 respondents are there.
400 dispensation ಕೇಳಿದ್ದೀರಾ?
I have already filed it, my lords. It's on record.
Only few respondents they have sought for the dispensation.
What about the other respondents?
Those respondents.
Anyway, the contested respondent has filed an application for vacating stay.
Yes, please.
Yes. Suit for?
Partition, my lords. The challenge the order passed in FDP proceedings.
We'll take it on Friday. Please, list on Friday.
Interim order, my lord.
Interim order subsisting. List on Friday under the caption hearing on interlocutory applications. Interim order subsisting would continue to the next date of hearing.
Yes.
This is
Interim order ಇದೆಯಾ?
This is a matter where the other side has argued the matter. This honorable court was about to dismiss the writ petition.
About the dismissal.
They took time to argue the matter today.
ಇದ್ರ ಜೊತೆ ಸೇರಿದೆ.
Matter was heard.
ಏನಿದೆ?
ನಾಲ್ಕು ಕೇಸು.
ಇದೆ.
ಒಂದು ಕೇಸ್ ಇತ್ತು, ಅದು ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ಸ್ 4 ಇತ್ತು.
ಸರಿ,
ಅದು
ಅದಕ್ಕೆ
ಇವತ್ತಿಗೆ ಅಂತ ಪೋಸ್ಟ್ ಆಗಿತ್ತು ಸರ್. In the meanwhile, the other side, ಇವರಲ್ಲ, the trial court advocate, ನಮ್ಮ ಪಾರ್ಟಿ ಹತ್ರ ಏನೋ ಸೆಟ್ಲ್ಮೆಂಟ್ ಏನೋ ಮಾತಾಡೋದಿದೆ ಅಂತಂದ್ರೆ
ಇಲ್ಲೇ ಇದ್ದಾರೆ ಅದರ್ ಸೈಡ್ ಅಡ್ವೊಕೇಟ್.
ಈಗ ಇವ್ರ ಹತ್ರನು ಮಾತಾಡಿದಾಗ ಇವರು
ಡಿಸ್ಮಿಸ್ ಆಗುತ್ತೆ ಅಂದಾಗ ಇದು ಸೆಟಲ್ಮೆಂಟ್.
ಮೊದಲೇ ಇತ್ತು.
ಇಲ್ಲೇ ಇದ್ದಾರೆ ಅದರ್ ಸೈಡ್ ಅಡ್ವೊಕೇಟ್.
Day after tomorrow. If you not, the learned counsel for the petitioner seeks time on the score that there are talks of settlement. The concerned advocate who is appearing for the respondent before the trial court is present and submits that there are no talks of settlement. List the matter day after tomorrow. ಅಷ್ಟೇ. ಮೊನ್ನೆ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತಾ ಇದ್ದೆ. Yes.
9.
For the petitioner. The fifth defendant seeks her husband to.
SPA hold. I'm filing a memo return.
Wait, sir.
Last time already given.
Interim order ಇದೆಯಲ್ಲ?
Interim order ಇದೆ.
Counsel for the ಯಾರು ಶೇಷಗಿರಿ ರಾವ್?
Yes, sir.
Who has entered appearance? Where is the acknowledgement of communicating?
Last you have filed given NOC along with entire file.
ಎಲ್ಲಿ ಸಿಗ್ನೇಚರ್ ಇದೆಯಾ ಪಾರ್ಟಿದು?
I filed. ಇಲ್ಲ ಕೊಟ್ಟಿಲ್ಲ.
Get that. List the matter on 1st July, 2nd July. Interim order subsisting will continue. This is to be allowed. Yes. Next.
10.
ನೀವು ಅಪೇರ್ ಆಗ್ತಿದ್ದೀರಾ? BBMP?
ಇಲ್ಲ.
I'm for R4. R4 is a individual.
Alexa K, madam. Wherein the honorable trial court dismissed my application, which is filed under 6 to 17 for amendment of plaint. Yeah, the application is at page number 60.
On the ground that no due diligence.
Please.
No, my lord. The application was filed after completion of trial, after completion of arguments. When the matter, ನನ್ನ argument ಮಾಡಿ like judgment ಕೊಟ್ಟು so not maintainable ಅಂತ ಹೇಳಿದ ಮೇಲೆ they come up with this application.
Anything else, sir?
Kindly grant liberty to file the comprehensive suit for declaration.
If you have a right to do it, sir. Yes. The learned counsel for the petitioner, after arguing the matter at length, would seek leave of this court to withdraw the petition and file an appropriate suit in law. If the petition is disposed on the aforesaid submission, reserving such liberty if available in law. Ordered accordingly.
11.
To seek for 10 days time.
Valuation slip ಇದರಲ್ಲಿ ಏನಿದೆ?
The issue is arguing counsel ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು.
ಎಲ್ಲಿದಾರ? ಚಂದ್ರನಾಥ್ ಇಲ್ವಾ?
Bereavement in his family.
Alright. Learned counsel for the petitioner submits that there is a bereavement in the family of the arguing counsel, therefore seeks 10 days time. List after 10 days.
Please, oblige me.
12.
Present respondent in this matter.
Recall of witness.
Recall of witness.
At the stage of argument.
What has happened? It is posted for judgment on 19th. Sufficient opportunity has been
My
given.
application came to be rejected at the time when the
When did you file it, sir?
When the matter was reserved for, when the matter was posted for defendant's evidence, my lords.
When, date?
The date, my lords, may kindly see the application one.
How many times you have cross-examined?
Only one time I have cross-examined. The second
Twice.
time.
3 times.
Only one time, my lords. My lords may kindly see the date, my lords. I filed this application on 12th of March 2025, my lords. You may kindly see at page number 30, my lords, the affidavit what I filed.
Yes.
Paragraph number 2, my lords. I submitted the above matter was posted for further cross-examination on 1st of March 2025. I submit that since my counsel.
Now what is the stage?
Now the matter is reserved for the
Iವಾಗ
judgment arguments. The suit for declaration, my lords, my declaration declaring that my seal deed is cancelled as null and void anta. But my contention is that prior to their agreement, there was already an existing agreement. That agreement had supposed to be marked by, I had to get the certified copy also, my lords.
Order sheet speaks.
It may be allowed on payment.
Adjournment has been taken. Now the matter is posted for judgment. It's a remand matter. RFA is filed by him. And the matter is remanded.
Where is the order of this court?
RF.
Kodi. No, sir.
Specifically, the court has made an observation directing him to present before the court on 18/12.
Anything else?
The reason, my lords, the application.
Not,
I could not be
not at
present
the
on
stage when it is reserved for judgment. And as a direction.
I filed
Division
an
bench.
application also for extension, my lords, in the.
Extension for what?
Before the registry, before in the RFA matter.
I think I dismissed it.
Extension of time.
I have not extended it.
Not here, my lords. In the RFA, my lords.
RFA court ಹಾಕಿದ್ದೀರಾ?
Application.
ಯಾರು ಹಾಕಿದ್ದಾರೆ?
Registration ನಾನೇ ಹಾಕಿದ್ದೀನಿ.
ಅದು ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿಸ್ಕೊಂಬನ್ನಿ ಆಮೇಲೆ ನೋಡೋಣ.
In the meantime, my lords.
No meantime. You move the division bench immediately.
In the meantime, my lords.
List the matter on Friday.
Friday itself the matter
Division bench is already directed, matter is reserved for judgment. I will not permit recalling of witnesses now.
Earlier, my lords.
ಕಾನೂನಲ್ಲಿ ಆಗುತ್ತಾ ಹೇಳಿ ನೀವೇ. You tell me.
Only on the score, my
ನೀವು
lords.
ಮಾಡ್ಬೋದು ಅಂತ ಹೇಳಿ. ಯಾರು, if you are on this side, tell me. Judgment reserve ಆದ್ಮೇಲೆ recalling of witnesses.
When the matter, when they file the application itself, my lords may kindly see the.
And there is a direction by the division bench. You take time from the division bench, then we will see. Friday. List on Friday.
Stay may be granted until further proceedings.
No, sir.
Or
You
payment
take
of-
it on Friday. If you don't get any order from the division bench on Friday, we will dismiss this.
In the meantime, at least till Friday, my lords, I may be protected.
Then immediately move on to division bench. That you should have done before filing this. Yes. Next, list on Friday.
13.
Interim relief sought in this petition, all that is sought is directions.
Now they are represented there.
They are represented.
Then we'll send it back, let the court hear both of you and pass orders in 15 days.
I'm sought for directions for speedy disposal, that is it.
ಅಷ್ಟೇನಾ? Disposal ಯಾವ ವರ್ಷದ suit?
2016, issues were framed in the year 2020, my lord. No, the difficulty is suppressing this title suit, they have
The
converted.
petitioner is before, you are the defendant.
Defendant.
The petitioner's defendants are before this court seeking the following prayer. The prayer, the learned counsel for the petitioner submits the suit is of the year 2016. Issues are framed in the year 2020 and injunction, na?
Declaration, title.
Yes. The issues are framed in the year 2020 and the trial has not progressed for the last 5 years and therefore has filed a subject petition seeking a direction to the hands of the concerned court to dispose the OS 1855 of 2016 within a time frame. In the light of the suit languishing for the last 9 years and the suit being one for declaration, I deem it appropriate to direct the concerned court to dispose the OS 1855 of 2016 with an outer limit of 6 months from the date of receipt of the copy of the order.
Great.
Next.
14.
For petition. My lord, petition is a plaintiff. The suit for partition and separate possession. But there are defendants 1 to 13. All of them have filed written statement. But every stage they dragged the proceedings. In fact, relationship is admitted, nature of the property is also admitted. But the 10 to 13, the defendant, they engaged in new counsel and subsequently they filed an application for additional written statement seeking permission.
Nothing wrong. Partition?
Suit for partition. But they are
Absolutely
purchased,
correct.
they are not even joint family members.
Oh, no, yes.
My lord, they are, in fact, they have committed contempt of court.
It is allowed, right?
It's allowed. Against
Correctly
that,
allowed.
No, my lord, my submission is.
Sir, every defendant will have a right to submit whatever the claim is.
No, my lord, your written statement already filed, my lord.
No.
Subsequently, they're
It is common that is filed and separately now wanting to
under
be
order
filed.
8 rule 9, seeking permission to file additional written statement, my lord. At the stage of evidence, dates of cross-examination. Written statement is already filed. My lord, they have not even filed additional statement. Only application seeking permission to file additional statement. It's not accompanied by any additional statement. My lord, every stage, my lord, they are prolonging the
All right,
proceedings.
you are the plaintiff anyway.
No, my lord.
Who is the contesting defendant?
Well,
All.
1 to 6 are, all are
The
appealing.
petitioner shall serve on the counsel who represents the respondent, the contesting respondents in the trial proceedings and file an acknowledgement in the next 3 days. List the matter on 2nd July. Till such time, the order so and so shall remain stayed.
Much obliged.
Next.
15.
And pass on, madam.
Nothing, sir. 2001 suit ali 2025 ಅಲ್ಲಿ order 6 rule 17. Nothing doing.
Argument ಮಾಡಿ.
Pass over.
Tomorrow, madam. Request for tomorrow.
ಸುಮಾರು ಆಗಲ್ಲ. ಯಾಕೆ? Pass over. ನಾಳೆ ಎಲ್ಲೇ ಬಿಡಿ. ಏನಿದೆ ಇದರಲ್ಲಿ?
This is the second amendment, my lord. and
ಅದು
this
ಪರವಾಗಿಲ್ಲ,
amendment is
ನೀವೇನ್
not-
ಬರ್ಬೇಕಾಗಿಲ್ಲ. Yes.
16.
No representation. List after 4 weeks.
17.
I'm petition, Lord. Lord. I'm challenging, Lord. I'm
Section
challenging-
10 order
Awesome.
rejected. Correct ಆಗಿದೆ ಇದೆ.
My lord,
Both suits
no, my
are
lord.
totally different.
No, my lord, no, my lord.
Is for injunction, another one is
No,
for
my lord.
partition.
My lord, I make small submission, my lord.
ಹೇಳಿ ಸರ್.
My lord, something ಏನಾಯ್ತು ಅಂದ್ರೆ, my lord, earlier suit filed by the partition suit. Earlier partition suit. Who is, my lord, here in, my lord, the respondent here in is the dependent number 1 in their suit. Earlier suit. My lord, my lord, she has filed a WS and my lord, my lord, and my lord, kindly peruse, my lord, kindly peruse, my lord, deposition of, my lord, that is annexure, my lord. My lord, annex G, my lord. Some annex G. My lord, that
Both suits are figuratively and literally
my lord,
different.
no, my lord, my lord, my lord, my lord. On the ground that rejected in their application, one, both suits are parties are separate. On the ground that, but is but my lord, but parties are same, my lord.
ಅದು ಒಂದಾಯ್ತು. Only one component is satisfied.
But
To arrest another suit under section 10,
my lord, here,
there
my
must
lord,
be 3 compliances. That is not there.
My lord, both suit.
Relief sought must be same. Parties must be same.
Yes, my lord.
Yes.
My lords, if I establish possession, I'll be able to succeed in the injunction suit. Another suit is for the relief of partition, substantially different from each other. At best, they may file a transfer
It may be
petition.
a consequence of the partition suit, but doesn't mean that that suit should be arrested.
They may file a transfer petition before
No,
the
section
principal court.
24 Aki to club both the suits and hear it together. That's a better option.
That's what the
Instead of
trial court
arresting a
infers.
suit, it is better. File an application in 24.
No, until, ಸರಿ,
Until ಏನು application ಹಾಕಿ application consider ಮಾಡಲಿಲ್ಲ ಅಂದ್ರೆ ಇಲ್ಲಿ ಬನ್ನಿ. That's the best way. Conflicting decisions ಬರ್ದೇ ಇರ್ಲಿ ಅಂತ.
moreover, my lord, the respondent here in voluntarily admit, my lord, both my lord, here in both suits are involved in the same subject matter.
Section 10 ಕಷ್ಟ ಇದೆ. 24 ಗೆ ideal case. File a section 24 application.
And liberty given, my lord.
That I will give.
And liberty given.
The petitioner is before this court seeking the arrest of a suit for injunction on the score that suit for partition between the parties is pending. The learned counsel for the petitioner, after vehemently arguing the matter at length, would submit that he would seek liberty to file an application for clubbing of the suits, reserving such liberty, the petition stands
They may be
disposed.
posted before the same court. Clubbing may not be necessary. is what-
The post before the clubbing of the suits,
Club ಯಾಕಂತಂದ್ರೆ
or
ನಾವು
transfer of the suit.
transfer
of the suit to the same court, yes.
My lord, no, I mean, my lord, ಇದನ್ನ, my lord, section 24 ಅಲ್ಲಿ ಬರೋದಿಲ್ಲ sir. My lord, section 24 ಆಗ್ಬೇಕಾದ್ರೆ district court ಹೋಗ್ಬೇಕು, ಅಲ್ಲಿ ಬರೋದಿಲ್ಲ. Section
ಅಲ್ಲ ಆಯ್ತು,
24 my lord, ಬರೋದಿಲ್ಲ.
transfer of the suit at part. Transfer of the suit to be heard together. The petitioner is reserved liberty to approach the appropriate fora in the event of need in future.
Grateful.
Yes. Therefore, said observation, petition stands disposed.
18.
Who are the passover? Who are the impleading applicants? Order 1 rule 10 ಅಲ್ಲ? Who are the impleading applicants?
Striking of suit, my lord.
Striking of what?
Suit is filed by the plaintiff seeking enforcement of agreement of sale with D1. D2 19 are the joint family members who are neither signatories
Oh,
to the
you
agreement.
want to be deleted as
Want to. For
defendants.
deletion, they have filed the application. We are not signatories to the agreement, my lord. This law is settled.
You are signatory.
We are not signatories. None of
You
them
have
are-
filed the application.
Yes,
I have filed the application, respond number 1.
Deletion of 2 to 19.
2 to 19.
You are the only contesting respondent.
Yes.
my lord.
ಯಾಕ್ ಬೇಕು ಎಲ್ರು?
Senior wants to convince the court on their proper parties. They are not necessary parties, but they are proper parties.
All right, either of the two, order 1 rule 10 will survive, we'll see.
Kindly pass on.
Pass over, madam, day after tomorrow.
My lord, a senior is on leave for a week, so
On
however, there
leave,
is no interim order.
Who is your senior, sir?
Uday Prakash.
Aaytu, sir.
Pass over.
Pass over.
Matter is listed on 2/7.
Pass over, sir.
19.
Apply.
No, vacant. Yes.
My lords, I appear for the petitioners, my lords. I pray for 2 days time, my lords.
I'm sorry, I oppose any adjournment. my lord.
Oh, yes,
Writ petition
sir.
is not maintainable.
My lords,
As
there is
against
some
the ex parte
inconvenience,
order
my
of
lords.
injunction.
Kindly, my lords, 2
We have
days.
got two options.
First appellate court ಗೆ ಯಾಕೆ ಹೋಗಿಲ್ಲ?
ಹೋಗಿಲ್ಲ.
My lords,
Okay.
the trial court has, my lords,
We will
they have
vacate
not
the
followed the
interim
mandatory
order.
procedures of
David,
interim.
Allah ಹಾಕಿದ್ರು.
ನಾವು ಹಾಕಿದ್ವಿ, bypass ಮಾಡಿ ರಿಟ್ ಹಾಕಿದ್ದಾರೆ.
ಅಲ್ಲ,
Clear
follow
abuse of
ಮಾಡಿಲ್ಲ
privilege.
mandatory procedures, my lords. It's a non-compliance of order
faster
passed
to
by
bypass.
on dishonorable court, my lords. ಅಲ್ಲ, ಅದಕ್ಕೆ it has to be heard, my lords, 2 days time.
He claims converted land, mine is the agriculture land.
Day after tomorrow in the same stage.
Grateful, my lords.
It's made clear no further adjournment will be granted in the matter.
Great,
Next.
grateful, my lords.
20.
Application is
Counsel
allowed
for the
for,
petitioner shall serve on the counsel who represented the respondent in the trial proceedings. What's the next date there?
the date is this month itself.
All right, so there shall be an interim order of stay of further proceedings before the concerned court till the next date of hearing, 9th July. Yes, next.
21.
Dependents writ petition.
Hmm,
Trial court may not refuse to grant the
divergent.
diversion.
Ah. But 2 ವರ್ಷ ಆದ್ಮೇಲೆ
ಇಲ್ಲ 2 ವರ್ಷ.
immediate ಆಗಿ.
ಇದು ಈಗ immediate ಆಗಿ.
Suit for what?
Suit for permanent injunction. The trial court rejected
Petitioner
the
to same
application.
order. Shivakumar ಮಾಡಿದ್ನಲ್ಲ, same day, yes.
Much.
Next.
22.
Here for the petitioner, my lord. Plaintiff's petition, my lord. Suit for partition, I file an application under order 6 rule 17. My lord, that comes to be dismissed, my lord. On the ground.
To withdraw
Illa.
admissions.
No, my lord. No, I'm not withdrawing the admission.
Then what?
There is a fraud played upon us. I'm bringing it to the light of the notice of the court. In fact, I had already mentioned that in the earlier plaint at para 6, my lord. And what has happened is that general power of attorney, my lord, I have produced, which
Come
is
to
not.
page 26.
Yes, sir.
You want to replace what?
Lord, I have clearly said, my lord, in the earlier plaint that there is I have not executed any GPA. Now, your lordship may kindly come to, my lord.
Yes.
My lord, annexure E at page 61, my lord.
What's the stage of the suit, sir? 2013.
Trial has not yet commenced, my lord. Trial has not yet commenced.
Issues ಯಾವಾಗ frame ಆಗಿದೆ?
Issues were framed in 2016, my lord.
And trial has not yet commenced.
Not yet commenced, my lord. And what has happened is, your lordship may kindly see page 61, my lord. Now the pendulum would shift, my lord, if this GPA is, my lord, executed by me, my lord, my suit goes. My lord, this is not my signature.
What were you doing for the last 10 years, sir?
My lord, what has happened is, my lord.
You have filed your WS in 2013.
My lord, I am the plaintiff.
Plaintiff, sorry.
Yes, I am
WS was filed in 2013.
Yes, they only say there is an unregistered general power of attorney, my lord. This I get it from the purchaser who gives a copy to me. My lord, annexure E at page 61, my lord. This is not my signature. Now they say in the written statement there is an unregistered general power of attorney. They don't even refer to the dates anywhere, my lord.
Come to paragraph 12 at page 30.
Yes, my lord. My lord, I am not resiling from any admissions, my lord. I am not. My lord, if your lordship sees the para 6 of the amended plaint, I have clearly said I have not executed any GPA. My lord, that is the reason I have produced it myself at annexure E.
What's the next date?
Next date it on 4/7, my lord, 4th of July.
Serve on the respondent.
My lord, what is happening is dates are not being given now. They are fast tracking the matter, my lord.
Dates are given, right? 4/7 ಅಂತ ಹೇಳಿದ್ರೆ ಈಗ. The petitioner shall serve on the counsel who represents the defendants, contesting defendants at least before the concerned court. List the matter next Monday.
Obliged.
In the same stage.
23.
Application challenging the order of 6 rule 17 rejected by the trial court. It's a suit for partition, my lords. I am the defendant. I had filed an application seeking to insert certain pleadings, saying that the gift deed which has been executed by my father in favor of me, the issue has been framed, my lords, on the month of June 2024, wherein
You have immediately filed it.
immediately has been filed. The
Petitioner to serve on the counsel who represents the respondent, which defendant?
Lords,
The plaintiff.
respondent,
Plaintiff. Respondent number 1 plaintiff, and file an acknowledgement. List on 2nd July till such time further proceedings before the concerned court shall remain state. Next.
Please.
24.
ಇದು ಇನ್ಫ್ರಾಸ್ಟ್ರಕ್ಚರ್ಸ್ ಆಗಿದೆ. ಪಾಸ್ ಓವರ್ ಮಾಡಿ. ಇಲ್ಲ next week ಹಾಕಿ. List on 2nd July. No representation, we have the petitioners. Next.
25.
Now they are represented?
No.
ಇನ್ನೂ ಇಲ್ವಾ? ಅಪೀಲ್ ಯಾಕೆ ಹಾಕಿಲ್ಲ?
ಅದು ಎಕ್ಸ್ಪರ್ಟ್ ಆರ್ಡರ್ ಇಟ್ ಇಸ್
ಕೊಟ್ಟಿಲ್ಲ ಅಂತ.
ಎಕ್ಸ್ಪರ್ಟ್ ಆರ್ಡರ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ.
ಹಾ. Learned counsel for the respondent submits petitioner. Plaintiff submits the defendants are not yet represented before the concerned court. In that light, status quo be maintained by the parties till the next date of hearing. List on 27th. Petitioner to serve ilvala in represent model. Emergent notice to the respondents returnable by 27th. Yes, next.
26.
For petitioners, what's the amendment, my lord? The plaintiff wants to add 4 paragraphs, my lord. They want at the stage of cross exemption of PW1, my lords. Suit is
It definitely changes the nature of the suit.
Prayer
change, ma'am.
Prayer change. The prayer, my lord.
No, sir.
Prayer is only to declare, my lord, the perfected title by adverse possession. They want to.
Your prayer was that you have perfected the title by adverse possession.
please.
What do you want to contend?
Lords, they want,
What do you want to contend now?
Lords, they want to say it's their ancestral.
Yes. Does it not change the nature of the suit?
Please.
ನೀವು ಹೇಳ್ಬಿಡಿ.
Please, my lord.
ಹೌದೋ ಇಲ್ವಾ?
ಹೌದು. But sir, in fact, Salo.
ಎಲ್ಲದಕ್ಕೂ ಒಂದು ಪೆಟಿಷನ್ ಆಗ್ತದೆ.
ಇಲ್ಲ, my lords. Notice my wish.
No notice, sorry. Adverse possession claim ಮಾಡ್ಬಿಟ್ಟು it goes up to the stage of evidence. Now you want to change it to say that ancestral property.
Pleadings ಸ್ವಲ್ಪ ಚೆನ್ನಾಗಿಲ್ಲ.
ಚೆನ್ನಾಗಿಲ್ಲ, ಕೇಸು ಚೆನ್ನಾಗಿಲ್ಲ.
Notice.
Not at all. ಆಮೇಲೆ ಅಲ್ಲಿ ನೋಟಿಸ್ ಮಾಡಿದ್ದಾರೆ ಅನ್ಬಿಟ್ಟು ಅಲ್ಲಿ ಟ್ರಯಲ್ ನಡೆದೇ ಇರೋದು.
ಆ ತರ ಇಲ್ಲ.
ಇದು ಚೇಂಜ್ ಆಗುತ್ತೋ ಇಲ್ವೋ ಅಷ್ಟೇ.
Let's even while preparing, Lord, I am also not.
ಮತ್ತೆ
I should not trouble my lords with this.
It does change. Your prayer itself is different now.
ಇಲ್ಲ, amendment ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ನಮಗೆ ಒಳ್ಳೇದಾಗುತ್ತೆ. So if it is rejected, it's helpful for us.
ಮತ್ತೆ and what is there? Don't withdraw it. I will pass an order.
Next week on the first time ಬಂದ್ರೆ they will just.
ಆಯ್ತು ಸರಿ. Let's next week in the same stage. ಏನಿಲ್ಲ ಇದರಲ್ಲಿ.
Please, my lord.
27.
Yes, succession certificate, your lordship. In this matter.
Who are you?
I am the mother of the deceased.
Deceased government servant.
He is not a government servant.
Then what? Death benefits ಯಾವ್ದ್ರದ್ದು?
ಅಲ್ಲ, ಇದರಲ್ಲಿ ಏನೇ second respondent. The death benefit is given by your lordship.
Who is the person who dies?
My son.
The P&SC case.
P&SC.
Who dies?
My son.
Your son dies.
My son.
Son is not married?
He is married. The first respondent. Who is first respondent?
First respondent.
First respondent.
In law, what will you get, sir?
So 50% because your lordship have no.
MFN ಅಲ್ವಲ್ಲ?
ಅಲ್ಲ, P&SC.
ಯಾವ್ದ್ರದ್ದು ಅದು ಗೊತ್ತು.
P&SC. What happened, your lordship? So I'm seeking 50%.
So what was your insurance 50% back?
50%. So already this was because your lordship, I have issued a notice in the year 2022 and the very authority says you get a probate. So then we have filed a suit and pendency of the suit, your lordship, they have disbursed the amount. So what I'm seeking, your lordship, to deposit anta.
What do you mean?
So to deposit the amount anta I'm seeking, your lordship. That's it, your lordship.
They
My
cannot,
prayer is very
only
limited.
we'll see, let the mother come, wife come.
Wife.
Petitioner to serve on, ಅಲ್ಲಿ represent ಮಾಡಿದಾರಾ?
Please.
Petitioner to serve on the counsel who represented the first respondent before the trial court and file an acknowledgement. Next, that's the matter on 2nd July. Yes,
Object.
28.
Will direct the court to hear you and pass orders.
Lords,
ಅಷ್ಟೇ.
it is an execution proceeding.
Correct, execution proceedings ಅಲ್ಲಿ ನೀವು time ಕೊಟ್ಟರು ಅವತ್ತು ಮಾಡಿಲ್ಲ.
It was only for appearance. That day was
Correct,
declared
sir.
as a holiday. Lords, the appellate court will have to hear me. Lords, I filed an appeal before
Appellate
the High
court
Court.
hear ಮಾಡಕ್ಕೆ we will send. ಈಗ where did you file the where do you enter appearance?
Lords, I had to enter appear in the execution proceedings. Execution proceedings was listed on a day which was declared as a holiday.
Correct.
It was called the next day. My lord, service was held sufficient.
Executing an arbitral award, right?
Yes.
Yes.
My lords, I was not even permitted to grant a time to file objections. My lords, an attachment warrant is issued for mobiles. I move the court the very next
All
day.
right, you serve on the petitioner to serve on the counsel. Serial number 28. The petitioner to serve on the counsel who represented the respondents in commercial OS.
In commercial execution petition
commercial
744.
Commercial execution petition 744 of 2024 and file an acknowledgement in the next 3 days. List the matter next Wednesday. Till such time further proceedings before the concerned court in execution, commercial execution.
Order has to be stated. Further,
Which order?
If the warrant is already issued.
Other movables.
Yes.
The till such time the
E8 pillars, page
impugned order shall
165.
remain stayed. Next.
Great.
For the petitioner.
Why do you want handwriting experts, sir, for this?
My lords, because exhibit P1, I have denied the document itself. That, my lord, will be the best evidence to prove it. After the completion of evidence, I filed this application. Only for that reason, I'm seeking for expert, my lords, to determine
No,
whether it is my signature or not. If it is not
The
my
court, it's court will decide.
lords,
No,
it may not
right.
be My lords, it may not always be possible for
No,
the court.
no,
It will
sir.
only aid the court in deciding the issue
What,
at
the
hand.
court does not want the aids.
Lords, because the document, the foundation of the case is founded on this sale deed. Only for that reason, my lords, I am asking for examination only of that one document.
Suit for?
Suit for permanent injunction.
Yes, adralle ಏನ್ ಬೇಕು? Yes.
Lords, but I have denied it, and my lords, I should have mentioned this in my pleadings. I have not done so. There is a subsequent suit for declaration which I have filed saying that
Where
the
is
sale deed is not.
Where is that?
I have not produced it. I'll produce it 3 days, my lords, or. only
You
for
withdraw
that
this
purpose.
and file a petition. Separate, mentioning everything.
I'll just file that with a memo, my lords, in.
No, no, sir. Make it a part of the record.
With a memo, my lords, I'll place it on the record.
Yes, all right, list next week.
My lords, date.
Meantime, no
No,
meantime.
no, date.
Next day, Monday. Yes.
30.
I am appearing for the.
Interim order is there.
Interim order is there. Copy serve ಮಾಡಿದ್ದೀನಿ.
ಯಾರು MJ Alva?
ಆಳ್ವ ಅವ್ರಿಗೆ ಮಾಡಿದ್ದೀನಿ.
No representation. We have the fifth respondent.
And for the respondent.
Ready?
Lord, he has furnished the copy today. Now your lordship may kindly consider.
ಯಾವತ್ತು ಹಾಕ್ಲಿ?
ಅಲ್ಲ ನಾನು ಇವತ್ತೇ ರೆಡಿ ಆಗಿದ್ದೀನಿ because your lordship may kindly consider there is one RFA pending before this, the
Interim
division
order,
bench of
ಅದನ್ನು
this honorable
ಕೊಡ್ತಾರೆ.
court, wherein an interim order is passed not to draw the final decree. Now my lord, the trial court has appointed the court commissioner. That appointment order has not been challenged. Subsequently, my lord, the assistant executive engineer of the BBMP has
How
been
can
appointed.
he be the court commissioner?
ಅವ್ರನ್ನ ಅಪಾಯಿಂಟ್ ಮಾಡಿದ್ದಾರೆ, ಅದು ಸರಿ ಇಲ್ಲ ಅಂತ ಹೇಳಿ.
ಅದೇ ಸರಿ ಇಲ್ಲ ಅಂತ ಹೇಳಿ ಬಂದಿರೋದು.
Because
simple.
Because my lord, all the records pertaining to these, now they have drawn.
ಅವ್ರಿಗೆ ಕೊಡಿ, ನೋಡ್ಬಿಡಿ ಅದು, day after tomorrow.
Please.
It has to be allowed. Very prima facie.
Please, my lord.
Section
If
54
that is the
amendment
case,
ಕೂಡ
if there is any ruling to that, certainly I will go down before your lordship. That
Yes. List day after tomorrow in the same stage.
Judgment ಕೂಡ ಕೋಟ್ ಮಾಡಿದ್ದೀನಿ ನಾನು.
List day after tomorrow in the same stage.
Very well.
Interim order subsisting will continue to the next date of hearing.
Interim order may kind.
ಈಗ ಹೇಳದ್ನಲ್ಲ.
Please. Wednesday may.
ಹ್ಞೂ ಸರ್.
Lord, the.
Delivery warrant.
Lord, abusing the process of.
ಏನ್ ಅಬ್ಯೂಸ್?
Lord,
2009 suit.
Lord, that suit is for partition and separate possession.
Execution is of the year 2009.
Yes, my lord, there is no order for delivery of possession at all. There is no order for eviction of property.
Who are you?
I am the objector. They are removing now my property. Kindly see the photograph, my lord. There is no property at all in between my property and the temple. Now they want to.
Serve on them, yes.
Lord, now delivery warrant is issued. Lord, the reason is, if nothing will survive, my lord, because for the simple reason.
I'll take it day after tomorrow, servant come.
My lord, delivery warrant is issued. My lord, kindly see one page, my lord. Only one submission I will make. Kindly see, my lord, the decree that is, my lord, page number, my lord. Page number 16, my lord, paragraph B in the second paragraph.
16?
Page number 16. That is a compromise between the decree holder and her brothers. In that, the decree holder was given option to seek eviction or any other legal proceedings to take the
Eviction of whom? You?
No, not me,
Then?
lord. There was some tenant. They say that they are under him. That particular tenant, legal heir has deposed that she was not a tenant under her, but she was tenant under me because it is my property. You lord, kindly see that the entire suit should, may I just read, my lord? That is item number 3.
Who is the contesting respondent?
My lord, the first respondent, my lord, they have appeared before the appellate court, my lord, without any caveat.
The petitioner to serve on the counsel who represents the first respondent. List the matter day after tomorrow.
Lord,
Day after tomorrow.
till then, my lord.
Till
because
then,
they-
ನಾಳೆನೇ ಏನಾಗಲ್ಲ.
ಅಲ್ಲ, ಕೈಯಲ್ಲಿ ಇಟ್ಕೊಂಡಿದ್ದಾರೆ ಸುಮ್ with police protection and break open the lock because my property will be delivery will be taken.
No, there shall be no precipitative action pursuant to the delivery warrant hanging on the head of the petitioner.
Please, my lord, bless.
Till the next Friday ಹಾಕಿದ್ದಾರೆ.
Please.
Serve ಮಾಡಿ Friday ಇಲ್ಲ ಅಂದ್ರೆ then I will vacate it.
I will do it.
Yes.
32.
For the petition of notes, application and order 41 rule 27 came to be allowed during the.
Documents at the appellate stage.
Appellate
ಏನು?
But it came to be allowed by the trial court, first appellate court notes without assigning any reason. No reason.
Where is the order?
But the page number 31 notes dated 11/4/2025. Page
30?
number 31. there is a decree in my favor. First defendant alone will not preferred an RA. After filing, when the matter is posted for arguments, he filed an application for along with certain documents.
But order 4127 permits if there is reasonable cause that could not be produced, then
There is no explanation in the affidavit also, my lords.
where is the affidavit?
Lord, kindly see, my lords. Affidavit, my lords, at page number 76, my lords. IA is at page number 75.
70?
All mutation entries and revenue records sought to be produced, which were available, my lords, during the
With
course.
these many documents for the first time.
First time, my lords.
The petitioner is we are the plaintiff, huh?
I am the plaintiff.
The petitioner is the plaintiff. And secures a decree which is challenged by the defendants in RA 500 of 2019.
Defendant number 1 alone.
Defendant number 1 calls that in question in RA 500 of 2019. During the proceedings at the time of arguments, it transpires that an application under order 47, rule 27 is filed by the defendant seeking to produce about 10 documents. A perusal at the affidavit would indicate that all the documents that the defendant is now wanting to produce were available at the hands of the defendant even before, to be produced before the trial court. That having not been done, unless there is reasonable cause shown for having not placed those documents before the trial court, the concerned court could not have allowed the application. In that light, there shall be an interim order of stay of the order dated so and so till the next date of hearing.
Document number 1 to 6, my lords, are available. The other documents, my lords,
Most of the documents. No, we'll see.
500/18, my lords. It is not
19 antidalle?
19 our mistake matter. Order sheet is.
All right,
18.
yes, next.
Okay.
33. Petitioner, my lord, I have served the copy to the respondent, my lord. I have
Served?
served the copy.
Why have you not filed the acknowledgement? Huh? List next Wednesday. Interim order learned counsel submits, needful has been done, office to verify. List next Wednesday. Interim order subsisting will continue to the next date of hearing.
34.
There is a amendment application was allowed to amend the return. That was recalled within 6 days. And that was challenged.
Before your
Why all this said?
Kindly see the.
Why is it recalled?
It's a eviction suit, my lord. They take their sweet time to file the WS.
24.
Recalled under what provision?
I'll give the background before the order was passed, my lord. They take their sweet time to file the WS.
All right.
Then they take 5-6 adjournment to cross-examine the PW1. After all that, they come with this amendment application. Kindly see the amendment they have sought.
They have given no objection to allow that application. Accordingly, it is allowed.
We had filed the objections. Then it was discussed in the court that if you file objections, then hearing, then passing the order, you withdraw it. I'll allow it. It's a simple amendment. We withdrew it. I don't have any problem amending the. Kindly see the amendment they have sought.
If you have no problem, then
one line amendment, my lord.
Permit it and.
The time was given to amend the written statement.
ಆಯ್ತು 6 ದಿವಸದಲ್ಲಿ ಅಮೆಂಡ್ ಮಾಡಿಲ್ಲ ಅದು ರೀಕಾಲ್ ಮಾಡಿ
ಅವತ್ತು ಬಂದ್ಬಿಟ್ಟು ಕೌನ್ಸಿಲ್ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. ನೆಕ್ಸ್ಟ್ ಡೇ ಟೈಮ್
ಆಯ್ತು ಈಗ ಅಮೆಂಡ್ಮೆಂಟ್ ಹಾಕಿದೀರಾ?
ಅಲ್ಲ ಹಾಕಕ್ಕೆ ಹೋದ್ವಿ. ಲಾಸ್ಟ್ ಡೇಟ್ he made a submission that I am not unaware about the order passed by this honorable court.
I am not unaware.
ಅಂದ್ರೆ ನಾನು ಇಲ್ಲಿ ಆರ್ಡರ್ ಮಾಡಿರೋದು ಏನು ಅಂತ ಗೊತ್ತಿಲ್ಲ. I will look into it and make proper submission. ಇವತ್ತಿಗೆ ಹಾಕಿದ್ದಾರೆ. Today it is.
So one line amendment ಒಂದು ದಿವಸದಲ್ಲಿ
ಇವತ್ತು ರೆಡಿ ಇದೆಯಾ? ಮತ್ತೆ ಟೈಮ್ ಕೇಳಿದ್ರೆ ಕೊಡಲ್ಲ. ಅಮೆಂಡ್ಮೆಂಟ್ ಅಪ್ಲಿಕೇಶನ್ ಅಮೆಂಡೆಡ್ ಪೆಟಿಷನ್ ಏನದು? ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ರೆಡಿ ಇದ್ರೆ ಹಾಕಿ.
ಆಯ್ತು.
ಯಾವಾಗ?
ನಾಳೆ not any date may be fixed.
Last time itself they have produced. They can file
next date without fail next date we will file.
Next date ಇಲ್ಲ. List tomorrow. The concerned court shall accept the application seeking interim order ಇದೆಯಾ ಇಲ್ಲಿ?
ಇದೆ.
But how is the court proceeding?
ಇವತ್ತೇ ಇದೆ. Let them file it.
The learned counsel for the petitioner undertakes that he would file the amended written statement. We'll dispose it then.
Yes, please.
The petitioner is before this court seeking the following prayer. The issue in the list revolves around an amendment application under Order 6, Rule 17, at the outset being allowed by the concerned court and directing filing of the same, ಎಷ್ಟು ದಿನ time ಕೊಟ್ಟಿದ್ರು?
4 days.
Directing filing of the same within 4 days.
Sorry, 6.
6 days.
Please. 6
On the 6th day, the matter was listed, and on the score that the petitioner has not filed the amended written statement, recalls the said order. Recalling of which is called in question before this court. The learned counsel for the respondent Kaushik had would submit that before the concerned court also they had not objected to the amendment to the written statement. In that light, if it would not be a ruse to drag the proceedings, they have no objection to grant reasonable time to file the amended written statement. Therefore, the amended written statement shall be filed before the concerned court by the petitioner on or before Friday. Date hakpudi madam. In the event it is not filed, the concerned court shall proceed to pass necessary order.
Last time itself, they have presented the amended WS. Let them file it today. Today is the matter.
ಇವತ್ತು ಫೈಲ್ ಮಾಡಿ ಮತ್ತೆ.
I am not representing.
One line is the amendment.
Give a call.
ಅವರು ತಂದಿದಾರೋ ಇಲ್ಲೋ ಗೊತ್ತಿಲ್ಲ. If it is
Thorough
there,
ಹೇಳಿ.
if it is there, I am asking. Otherwise,
We'll take it.
by Friday.
ಅದ್ ಬರ್ಕೊಳ್ಳಿ. The learned counsel for the parties would submit that the matter is listed today. The concerned court shall take the matter day after tomorrow.
Yes.
The petitioner shall file the amended written statement by tomorrow afternoon. Yes, with the aforesaid observations, the petition stands
Petitions
disposed.
been already 1 year.
2024
There be a time bound manner.
Order sheet ನೋಡಿ ಸ್ವಾಮಿ.
Suit ಈಗ? Suit is of the year 2013, right?
24 though.
24 suit.
ಪ್ರತಿ ದಿನ
ತಿಂಗಳಲ್ಲಿ ಒಂದು
ಕೊಡ್ತಿದ್ದಾರೆ. every second day the matter
Yes.
will be listed.
Next.
Please some time bound manner.
A 24 suit ಅಲ್ಲಿ ಯಾವ time bound, sir?
It's eviction suit. They don't have any admitted. I had already filed judgment before trial application. ಸುಮ್ನೆ drag ಆಗತ್ತೆ ಅಂತ ಇದು ಮಾಡಿದ್ರೆ. There are admissions.
No. Not 24 suit alla kelbedi. Whatever kind of suit it is. Yes.
35.
And for petition.
Order 7, Rule 11.
Yes.
Why?
This is not a commercial suit, Your Lordship. We are relying upon the judgment of this honorable court, division bench of this honorable court.
Learned counsel for the petitioner shall serve on the counsel who represents the respondent in the trial proceedings and file an acknowledgement list on 2nd July. Further proceedings in commercial OS 665 of 24 shall remain state till the next date. Serve ಮಾಡಿ ಬರಲಿಲ್ಲ ಅಂದ್ರೆ ವೆಕೇಟ್ ಮಾಡ್ತೀನಿ.
Please.
Yes.
36.
Injunction suit sought for appointment of a commissioner.
The petitioner is before this court, calling in question an order passed answering an application under Order 26, Rule 9 of the CPC, seeking to appoint a court commissioner for an assessment as to whether the petitioner has violated the building bylaws or otherwise. The order on the face of it is erroneous, as the power vested with the BBMP cannot be exercised by the court commissioner. The learned counsel submits that the BBMP has initiated proceedings.
Yes, ma'am.
The learned counsel submits that the BBMP has already instituted proceedings, and therefore the appointment of court commissioner, allowing the application for appointment of court commissioner is erroneous. The submission merits acceptance, albeit prima facie. Yes, there shall be an interim order of stay of the order so and so. Past date another?
Order dated 3/4/25.
Order date 3/4/25. It is made clear that there is no stay for the continuance of the trial. Yes.
37.
Merchant notice to the respondents. Petitioner to serve on the counsel who represents the
Declaration and injunction.
1817. ಆರ್ಡರ್ ಮಾಡಕ್ಕಾರ ಬಿಡಿ. 37 ತಾನೆ?
ಹೌದು 37.
ನೀವು ಪೆಟಿಷನರ್ಗಲ್ವಾ?
ನಾನೇ ಪಿಟಿಷನ್.
ಸರಿ, ಬೇಡ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಬೇಕಾ?
ಇಲ್ಲ ಬೇಕು.
ಮತ್ತೆ ವೇಟ್ ಮಾಡಿ. Petitioner defendant number 8 is before this court calling in question an order that is passed on an application under Order 18, Rule 17 of the CPC. Prima facie finding the order contrary to law, I deem it appropriate to stall all further proceedings before the concerned court till the next date of hearing. Petitioner shall serve on, who is the contesting defendant? Plaintiff 1 to 5, Petitioner should serve on the counsel who represents the plaintiffs before the concerned court and file an acknowledgement in the next 3 days. List the matter on
1 to 8.
1 to 8, 2nd July. Inna ಹೇಳ್ಬೇಕಾಯ್ತಾ? Yes.
38.
The matter was on 2/6. What has happened? 2/6 ಗಿತ್ತಲ್ಲ ಏನಾಯ್ತು?
ನೋಡಿ ಸರ್ ಅದೇ ನೋಡಿ 2 ವಾರಕ್ಕೆ ನೋಟಿಸ್ ನೋಟಿಸ್ ಆಗಿದೆ.
ಅಲ್ಲಪ್ಪ 2ನೇ ತಾರೀಕಿಗೆ ಮ್ಯಾಟರ್ ಹಾಕಿದ್ರು.
2ನೇ ತಾರೀಕು ನೋಟಿಸ್
ಈಗ ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡಿದಾರ ಡಿಫೆಂಡೆಂಟ್ಸ್ ಇಲ್ವಾ? ಇನ್ನು ಮಾಡಿಲ್ವಾ?
ಇಲ್ಲ ಸರ್.
ವಾಟ್ಸ್ ಯುವರ್ ನೇಮ್?
ಉಮೇಶ್.
So and so submits that the represents are the defendants are not yet represented before the concerned court and there is a need to protect the construction. In that light, parties to maintain status quo.
ನಮ್ದಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಆಲ್ರೆಡಿ the petitioner has a construct the compound wall towards
All right, there shall be an interim order of there shall be an interim order as spread for till the next date of hearing. ಅದು ಬೇಡವಾ? ಸ್ಟೇಟಸ್ ಕೋ ಅಲ್ಲ, ನೀವು ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಕೇಳಿರೋದು ಕೊಡೋದು ಬೇಡವಾ? ಅದನ್ನೇ ಕೊಟ್ಟಿರೋದು. ಅದು ಬೇಡವಾ?
ಆಗ್ಬೋದು ಸ್ಟೇಟಸ್ ಕೊಂಚಗೋಸ್ಕರ ಆಗ್ಬೋದು.
ಲಿಸ್ಟ್ ಸರ್ವ್ ಮಾಡಿ, ಸರ್ವ್ ರೆಪ್ರೆಸೆಂಟ್ ಆಗಿದ್ರೆ ಸರ್ವ್ ಮಾಡಿ.
ಸರಿ ಸರ್.
ಇಲ್ಲ ಅಂದ್ರೆ the learned counsel shall serve on the counsels for the defendant if they are represented before the trial court. If not, emergent notice returnable by 2nd July. Yes, next.
39
I prefer petition. But this is a suit for specific performance decreed and then again I filed a execution petition. In both the cases, summons were served on the respondents. They are not appeared in spite of service of summons also. Then this honorable court ordered to issue warrant against the respondents for execution of the sale deed. Then execution of the sale deed, at the stage I have produced the draft sale deed. The honorable city civil court is ordered to issue notice to the on the draft sale deed. At this stage, respondents have appeared and filed the application, 2 applications. One is for section 47 of CPC, another one is 2129 of CPC. In both the applications, hearing at a time, then again impeded order passed at page number 155.
I'll let you serve on the counsels for the JDRs. The petitioner shall serve on the counsel.
The illegally granted the stay order against the execution petition.
1 minute. The petitioner shall serve on the counsels representing the judgment debtors, if any. They are represented there.
They are represented. Now they have filed miscellaneous
and file an
petition.
acknowledgement. I know. File an acknowledgement before this court. List the matter next Monday. Till such time, the impugned proceedings shall remain stayed. Yes, next.
Impugned dated order dated 21/3/2025.
ಕೇಳಿರೋ stay ಏನು?
I sought for only stay of the order dated.
There shall be an interim order of stay of order dated 21/3/2025. Yes.
Much less.
Till the next date of hearing.
40.
Now represented.
No, my lord, not yet, my lord.
Emergent notice to the respondents returnable by the 2nd of July. Respondent, defendant till the 2nd of July. A parties to maintain status quo till the next date of hearing. Yes, next.
41.
My lord, I'm for the petitioner, my lord.
54, 41 ಒಂದೇ. Serial number 54.
Please,
Correct?
please. Please.
Yes, sir.
54 and 41, same.
ಹೇಳಿ.
My lord, the petitioner is challenging the OS question, my lord, OS number 3/6/2025. Earlier, the petitioner had filed OS number 388 of 1988 for declaration injunction in respect of the property in question. The suit of the petitioner was decreed on 1st April 2000. Again, that will respondent's father, they were going up had filed a area number 19 of 2004. It was in 2001. It was dismissed. Again, that will not favored in appeal. After 13 years, the son of the respondent had filed his OS number, my lord, 65 of 2022, 17. He withdrawn the suit, my lord. Can you see one where in the annexed fee, page number 133? 133, operative portion, 134.
Tag both 50, 20, 41 and 54. Petitioner to serve on the counsel representing the plaintiff in both these cases before the concerned court. Common plaintiff, both these cases before the concerned court. List the matter on 9th July till such time further proceedings before the concerned court shall remain stayed.
Wait.
Yes, next.
42.
This case,
617.
yes, my lord.
Ah.
Amendment application came to be filed and rejected on the ground that, my lord, the stage of the suit is
Arguments.
arguments.
Yes.
My lord, I'll just read one line, my lord, in the impugned order at page.
ಯಾವ ಇಂಪ್ಲಿಮೆಂಟ್ ಆರ್ಡರ್ ಏನಿಲ್ಲ ಅಂದ್ರೂ ಕೊಡಲ್ಲ.
Hello.
Stage of arguments, no sir.
I'll just read one line, my lord,
Yes,
in the impugned order, which starts from page 31, page 35, my lord. And sixth line, without having proper documents with regard to grant made by the government, simply has mentioned the number of grant certificates. The seal of the Tahsildar and signature disclose that the certified copy of grant certificate obtained on 12/12/20.
Have you produced those documents here?
My lord, it's not produced here.
Then?
It is part of the amendment application which has been
Why have
obtained
you
on
not produced,
12/12/24.
why have you not
and
produced all that here?
I'll produce, my lord.
Produce it.
I'll produce, my lord.
Next date in.
9/7 is,
List next Monday. The counsel for the petitioner to place on record the documents that are found fault with in the impugned order.
please.
Yes, next.
Mancho.
43.
Appearing for petitioner, not pertains to my lord rejection of application.
43, 44, same.
Please, my lord.
Why not maintainable before the commercial court?
My lord, section 2C. subclause
Here, what is the
1,
transaction between a Kodi
My
madam?
lord, I was a tenant
Commercial court, sir.
in respect of my lord ground floor and first floor. My lord, on monthly rent, I had also paid advance amount. My lord, after I vacate, after a lapse of my lord more than 2 years, he files a commercial suit. My lord, claiming arrears of my lord
Rent.
rent from me. My lord, please see, my lord, the plaint is produced. My lord, page 27, my lord, in the first petition.
Yes.
The relief, my lord, is at the bottom, directing the defendant to pay the plaintiff a sum of rupees 11,50,000 with current and future interest from the date of suit till realization. My lord,
You're on delay?
not on delay,
Then?
my lord. He does not place, my lord, the so-called agreement, what he, my lord, makes a mention in the entire plaint governments. Nowhere, my lord, he has, the mandate of, my lord, Commercial Courts Act is, my lord, all the documents are required to be placed
Correct.
on record. He
Correct.
does not, my lord, produce the so-called lease agreement. My lord, what he says is, my lord, what the trial court, my lord, comes to a conclusion is that, my lord, that there might be a oral agreement as well. And the TPA Act does recognize with oral agreements. My lord, it is not even his case that, my lord, that there was a oral agreement. He specifically at para 4, 5 and 6, my lord, in the plaint, he states that there is an agreement, but he fails to produce that. And, my lord, with regard to the cause of action, my lord, he only places reliance on some email communication. And he says that, my lord, there was a cause of action which gave rise to, my lord, filing of the suit.
Serve on the plaintiff.
Please, my lord, I'll serve the
Petitioner to serve both 43, 44. Petitioner to serve on the counsel who represents the plaintiff before the concerned court in commercial OS 1292 of 2024. Recovery of amount 11,50,000.
Please, my lord, in the first petition. Again, my lord, in the second petition, he has made a claim of, my lord, 4 lakhs.
And file an acknowledgement. List on 3rd July. Till such time further proceedings before the concerned court shall remain stayed.
Obliged.
Next.
45.
Therefore, the application came to be filed for sending the documents for handwriting expert.
Yes, sir.
And the trial court has stated that I should have exercised that right much soon after filing of the plaint itself.
2014 suits.
Only after evidence I have to file this section 45 application.
When did the evidence commence?
The evidence immediately after the evidence, I have filed this application.
When is the
Completion.
evidence? 2017 is the evidence commencement.
Al avurdu 2020.
The ANR, evidence
20.
commenced in the year 2017. Application is filed in 2025.
After evidence, completion of evidence, I
No,
have-
no.
Your Lordship may kindly see that their evidence completed in 2022.
Anyway, you serve on them, that's all.
Now, they say that I have put my signature.
Petitioner to serve on the counsel representing the defendants in the trial proceedings. List next Wednesday.
Arguments.
No, nothing, yes.
Court
Yes,
has
sir, illa.
stated that 73, section 73.
We'll see, yes. Next.
46.
Yeah, for the petitioner, please. In execution proceedings. my
Why do you want JDR to be added?
Lord, I am the abstractor, please.
You are the obstructor.
Lord, I filed two.
Propose JDR 2.
Certainly.
Ah.
The reason is I filed an application under order 21 rule 97 that came to be rejected. Subsequently, I filed two applications, one under one rule 10-2 and other is under section 151.
No, was
seeking
he,
6 months time.
was he a party earlier?
No, please.
Then
Lord, 21 rule 97 obstruction application came to be rejected.
your application is rejected.
Yes, my lord. I filed an appeal, that apart.
Why do you want to come in?
My lord, my claim is under one Mr. Sharif, please. He is my landlord. He has taken 10 lakhs as advance. Put me in position.
File a separate suit against him.
At least I have prayed for 6 months' time. I have filed my application. That is also rejected, please.
No.
Lord, kindly see the order.
Nothing.
At least for me to vacate, I need some breathing time.
File a separate suit against the judgment debtor
shall.
1.
I
If
shall.
you have any claim against him, why do you want to come into this and
Not against judgment
trouble
debtor
the
1.
decree holders?
Not against judgment debtor 1. Judgment debtor has already vacated the property in the year 2022. In the year 2017 itself, property is sold to one Mr. Sharif. Sharif leases out the property.
That's
to
a
me.
separate suit.
Certainly. At
Not
least,
in this at all.
Lord, I have sought for some reasonable time to vacate. That can be considered. Trial
No,
court has
no.
rejected that also. 25 lakhs stock is there in the premises, please. I cannot remove it abruptly.
You have an agreement with whom?
Mr. Sharif, please.
Who is Mr. Sharif?
He is the purchaser of the property from the decree holders.
Which defendant was he?
He is not a party in the present proceeding.
Then file a suit against Sharif.
I shall, my lord. I
Please
shall
do that.
certainly. Lord, at least my.
You should have done that first.
It's-
Not entering into this.
My lord, this matter came only for writ purposes. I am not handling the matter in the trial court, my lord.
If
That
he is
is my
not, if he
difficulty.
is not Sharif, you will have to file a separate suit.
I understand. At least the other application for granting 6 months time can be considered.
No.
Lord, I can't, my lord, I can't vacate the property abruptly. Now, police help is ordered and delivery warrant is issued.
File
Break
a
open
suit
law.
immediately, sir, against Sharif.
I understand, but
See,
I can't.
You have an agreement with Sharif.
Certainly. I can't stall the delivery warrant unless my lord grants some time.
No,
for me
no,
to
no,
vacate, my lord.
nothing, nothing.
Lord, kindly see the application file. By me, Lord. It is at
It's a collusive effort
Page 15,
of
yeah.
Sharif and you. We will not entertain this. Absolutely.
I have sought for 6 months time to
No,
vacate.
sir.
Kindly see annexure C, my lord. That is the application filed by me. Not 25 lakhs worth stock is.
ಏನ್ ಮಾಡಕ್ಕಾಗತ್ತೆ?
ಅಲ್ಲ, I can't take it abruptly. ಅದು ರೋಡ್ ಹಾಕಿದ್ರೆ it will be of no use.
Sharif is not a party to the suit.
Sharif
You
is
are not a party to the
I
suit.
am not a party.
Decree holders have a decree.
But
You
they
want
have-
to object, that
they
is
have
an
already
object
sold the
or
property to
order
Sharif.
21 rule 97. No, sir. Yes.
Some breathing. To vacate at least. Not warrant is already issued.
Warrant is
They
issued
throw my
against,
articles on the road.
warrant is issued against whom, sir?
Against the JDR was already vacated. With police help and break open.
No, sir. It's a different cause of action. If you want to file a separate suit.
No, I certainly. That is my next recourse of action against.
That is the
Mr.
only
Sharif.
course of action.
Against Mr. Sharif, certainly will not. But as against protection of my interest in the property.
That's why I said, if he is not Sharif, you'll have to take him to court. Yes.
Not. I am Sharif at least.
No, no problem. You are Sharif before the wrong forum.
with some protection attached.
No, no, sir.
Some reasonable.
No, sir.
Lord, I am not saying.
Decree holders' rights, I will not
Lord, I have
trample
undertaken.
upon those rights like this. A collusive effort from Sharif and you will not take away the right
Lord,
of
I have
yes, sir.
undertaken, I will vacate. It is
No,
not.
sir.
ಅಲ್ಲ ತಾವು annexure C ನೋಡಿ.
ಅಲ್ಲ ಅಲ್ಲೇ ಕೇಳ್ಕೊಳ್ಳಿ ಸರ್.
ಅಲ್ಲ ನಾನು ಅಲ್ಲಿ ಕೇಳಕ್ ಆಗಲ್ಲ.
ಅಲ್ಲಿ ಇನ್ನೊಂದು ಸೂಟ್ ಹಾಕ್ಬಿಟ್ಟು ಕೇಳ್ಕೊಳ್ಳಿ.
ಹಾಕಿದ್ರು ಪ್ರಾಪರ್ಟಿ will not be the
ಶರೀಫ್
subject.
ಮೇಲೆ ಹಾಕಿ ಸರ್.
Property will not be the subject.
No.
I can only ask for recovery of my 10 lakhs.
No, sir.
Lord, I will be remedial.
No, no, I will not enter.
Sought for 6 months, some reasonable time at least.
You are not the, you have nothing to do with the decree holder. You have not, you have something to do with someone stranger to the decree, and you file an 2197 to come in as judgment debtor. No, sir.
Some reasonable.
Strange case. Yes. Nothing.
ಅಲ್ಲ ಸ್ಟ್ರೇಂಜ್ ಕೇಸ್ ಅಲ್ಲಿ ತಾವು oblige ಮಾಡಿ. I come under the strangest of the strange case ಅಲ್ಲಿ.
Strangest of the strange entertainment. Rarest of the rare. ಇದೆ.
Some
No,
protection at least.
Not in this. You know it well.
Lord,
Knowing well, you have just come here. It's a mercy petition. Allah. Decree holders' rights, I will not trample upon it all.
no, I will vacate.
You have, when vacate, you have nothing to do with the decree holder.
I will have to shift my items. ಅದಕ್ಕೆ ನಾನು writ ಹಾಕಿ.
ಅಲ್ಲೇ ಕೇಳಿ. File a separate suit.
At least an observation to that.
ಏನು separate suit ಅಂತಾನೆ.
So that I can get a benefit of interim order by the trial court. Not otherwise I will be remedial.
It's a collusive
ಇಲ್ಲ,
effort on the
collusive.
part of Sharif and you.
ಇಲ್ಲ, kindly see, my lord, the sale has already happened, please, my lord.
Yes.
Decree holders have lost their right in the property. They can't execute also. That is the,
That's up to them.
I am a bona fide person who has entered on.
Problem
lease.
is you have nobody in the scene there.
I understand, but
Then if you understand, you can't. We'll only observe that you have a right to file a separate proceeding. Counsel for the petitioner. The petitioner is before this court calling in question an order of the concerned court rejecting an application filed by the petitioner under order 21 rule 97.
1 rule 10.
1 rule 10. ಅದು ಇನ್ನೂ
ಅದು ಇನ್ನೂ
order 1 rule 10 of the CPC seeking to implead himself as a judgment debtor number 2. The petitioner, the respondents are decree holders. The petitioner does not have any privity of contract with the decree holder, nor has a contract with the judgment debtor, but claims to be in possession of the property, which is the subject matter of the suit, and further submits that the decree cannot be executed as the property has already been sold by the decree holders. All these factors would become fulcrum of a separate suit to be filed and not the petitioner to implead himself into these proceedings under order 1 rule 10. He is neither a proper nor necessary party, and the concerned court has appropriately rejected his application, reserving liberty to the petitioner to take recourse to law, if available in law, the petition stands disposed.
Till then at least.
Not.
I can only request. please.
ಇದೇ ಜಾಸ್ತಿ ಆಯ್ತು ಹೇಳಿದ್ದು. Yes.
Please.
Next.
47.
There's a case, my lord, where I file a succession application for succession certificate of my cousin sister. And
Cousin sister? Why?
My lord, sir, I'm the sole surviving legal. She was my father's.
ಈಗ now they have come in saying that they also have.
No, they are the nominees. They say they are the nominees of bank accounts which were held by. That, my lords, the judgments of the Supreme Court and dishonorable court are clear.
Nominee will not take away the right of
yes,
the legal heir.
Yes,
correct.
So they can't be impleaded. That is the. That
can't be impleaded. Kashta. Contest ಮಾಡಿ.
My lords, contest. May I just point out. My lords, the last.
Can't be impleaded ಅಂತ ಒಂದು judgment ತೋರಿಸಿ.
My lords, the last judgment, my lords,
Order 1 rule 10 na?
Order 1 rule 10. No, but my lords, it's been converted to a suit. Kindly see the order of the judgment, trial court, my lords. Order of the trial court, my lords, converts it to a suit. May I request, my lord, to first see.
P&SC is converted to a suit.
Yes, my lords.
All right. Yes.
May I request my lord to kindly take the application for a minute, my lords. The application filed by them. Application, my lords, will find at page 34, my lords.
ಈಗ ನಿಮ್ legal hair, then what have you produced?
My lords, I have produced the family, it's not,
Because
I have produced
father, mother, ಯಾರು ಇಲ್ಲ.
everybody, my lords, I
Everybody have-
conducted the last rites of my Dodappa.
Correct.
Then thereafter, my lords, mother was the sole surviving heir. Mother passed away during COVID. Then, my lords, she passed away in 2023. my lords. There is nobody else. My lords, I have produced the family tree, my lords. I have produced the, it's not disputed by them, my lords. They don't dispute the fact that I am the sole.
My humble submission is this, my lords. The lordship may kindly see. There are only two issues, my lords. Even I have spoke to Ajay otherwise. My lords.
That is the third issue.
No,
Why did you speak to him?
No, yes, Ajay is a friend, my lord, because to put an end to this
All
list,
right,
I have spoken.
tell me, yes.
Here, my lords, the deceased Sujata was a spinster. She was serving in a bank. She is retired.
Yes, sir.
And since she was living with her mother because her father died in 2014. And the four persons, two of them are before lordship, they were her friends and they were her family also. Hence, my lords, she has expressed that she would want us to, do from the property, we should do certain philanthropic.
ಆಯ್ತು, ಏನ್ ಸೆಟ್ಲ್ ಆಗತ್ತಾ?
ಅಲ್ಲ, ಸಿಂಪ್ಲಿ ನಾನು ಒಂದೇ ಒಂದು ಸಬ್ಮಿಷನ್ ಮಾಡ್ತೀನಿ ಸ್ವಾಮಿ. ಅಲ್ಲಿ ಕೆನರಾ ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ ಒಂದು ಲಾಕರ್ ಇದೆ ಫಾರ್ ವಿಚ್ ಐ ಆಮ್ ಎ ನಾಮಿನಿ. ದೇರ್ ಇಸ್ ಒನ್ ಲಾಕರ್ ಇನ್ SBI. ಆ ಎರಡು ಲಾಕರ್ನ ಕೋರ್ಟ್ ಕಮಿಷನರ್ ಓಪನ್ ಮಾಡಿ ತಗೊಂಡ್ಬಂದ್ರೆ, ಇಫ್ ದೇರ್ ಇಸ್ ಎ ವಿಲ್, ಬಿಕಾಸ್ ಇಟ್ ಹಸ್ ಬಿನ್ ಸೆಟ್ ಟು ಅಸ್, ಶಿ ಹಸ್ ಸೆಡ್ ದಟ್ ನಾನು ಇದನ್ನ ಐ ಹ್ಯಾವ್ ಎಕ್ಸ್ಪ್ರೆಸ್ಡ್ ಮೈ ಇಂಟೆನ್ಷನ್ಸ್, ಪ್ಲೀಸ್ ಡೂ ಅಕಾರ್ಡಿಂಗ್ಲಿ ಅಂತ ನಮ್ಗೆ ಹೇಳಿದ್ದಾರೆ.
ಯಾರು?
ಸುಜಾತ ಡ್ಯೂರಿಂಗ್ ಹರ್ ಲೈಫ್ ಟೈಮ್. And we have said that. So, ಈಗಲೂ ಇಷ್ಟ ಹೇಳ್ತಿರೋದು ನಮಗೆ, we don't want, we know as a nominee, we know our limitations. We are not here to knock off anyone's property. I am making it very clear. This may be recorded.
It's recorded.
Yes, our only submission is, we as her friends, we would like to give effect to her intentions. And she has expressed that she has given certain directions, and we assume because there are lockers, otherwise it is not found. What happened? She died in an unnatural circumstances. Ratri malagdor ಬೆಳಗ್ಗೆ ಎದ್ದಿಲ್ಲ.
Unnatural ಏನ್ ಬಂತು?
ಅದೇ ಆಕ್ಚುಲಿ ಆಗಿದ್ರಿಂದ ಏನಾಯ್ತು, ದೆನ್ ಒಂದು ಅಲ್ಲಿ UT ಎಲ್ಲ ರಿಜಿಸ್ಟರ್ ಆಯ್ತು, ಪೊಲೀಸರು ಬಂದ್ರು. ಪೊಲೀಸ್ ಬಂದು ಅದೆಲ್ಲ ಅಲ್ಲಿ ಇದ್ದಿದ್ದು ಏನೇ ರೂಮಲ್ಲಿ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇನ್ನೊಂದು ಮತ್ತೊಂದು ಎಲ್ಲ ತಗೊಂಡು ಹೋದ್ರು. ಹಾಗಾಗಿ ವಿ ಡೋಂಟ್ ನೋ
ತಗೊಂಡು ಹೋದ್ರ ಎಲ್ಲ.
ಹೌದು, ದೇ ಹ್ಯಾವ್ ಡನ್ ಆಲ್ ದಟ್. Then all these has happened, my lord. So the only thing is, I have instructions to say this: if those lockers are opened with the court commission in our presence, if there is no instructions, if there is nothing, we will withdraw. We will not even contest this matter. That I have told Ajay long ago, but they don't want to do that because they suspect that if they have even made submission before court. ನಾವೇ ಹೋಗಿ ನೋಡ್ತೀವಿ, ನಮ್ಮ ಮೇಲೆ ಯಾಕೆ ನಂಬಿಕೆ ಇಲ್ಲ, ಇನ್ನೊಂದು ಈ ತರದೆಲ್ಲ submissions were made in the court. That's why we are contesting, and even now it is all that are premature. Now we have made out a case that we have interest in the case. Even otherwise P&D case, any public can come and raise objection. That's why they call for a public
converted
notice.
to a suit.
Yes, now it is converted into suit. Now I can say, I can file my interest. ಇವರು ಅಣ್ಣನೋ ತಮ್ಮನೋ ಏನೋ ಅಲ್ಲ. ನಮ್ಮಲ್ಲಿ ಹೇಳ್ತಾರೆ ತಿಪ್ಪಾರಳ್ಳಿ ಬರೋಣವ್ರು ಅಣ್ಣಂಟಿ ತಮ್ಮನ್ ದೊಡ್ಡ ಮಗ ಅಂತ. ಹಂಗ ಎಲ್ಲೋ ಬಂದ್ರೆ they will also come.
That is not correct. That is the last my first cousin.
GP ರಾಜರತ್ನಂ ಹೇಳ್ಬೇಕಾಗಿತ್ತು.
ಹೇಳಿದ್ದು ಆದ್ರೆ ಹೇಳ್ತಿರಲ್ಲ ಅಂಡರ್ section 15 also, if my instruction is that there are other legal heirs also. Anyhow, that's their headache. I don't want to get into all that. If there is a will, if that will has any direction, because we were made nominees, it is not a general case of nominee. Here in this peculiar case where she had nobody and she has nominated.
Where is the family? Who are you?
My father's sister. My father's sister is the deceased mother. She was my first cousin. Andre my chikam
ಎಲ್ಲಿದೆ?
My lords will find page number 6 is the description. My lords wants the family tree. Just 1 minute.
Where is the family tree?
I'm very sorry, my lords. I have not produced the family tree. My lords, I'll produce it.
Produce it.
My lords, I'll produce. No difference.
Produce it, in the meantime, talk, we'll see. Wednesday I'll take it. Produce the family tree.
Yes. My clients only, what has happened is that the only
Only
reason.
Allah, you are a stranger, they are also
No,
strangers.
I'm not strange.
yes.
I'm
We'll
not.
see, produce mine.
I'll produce.
As of today, you are a stranger, no family tree.
No, not dispute. He doesn't dispute that she's my first
I
cousin.
said, let me get satisfied.
My lords, I'll produce. Next Wednesday.
Want it on Wednesday or Friday?
My lord,
Or
not
next
Wednesday,
Monday?
no, Friday, my lords.
Friday, all right. 20th.
Yes, much.
48.
Petitioner, please. It is suit for partition, please.
Aitu, are they represented now?
No, my lord. 20th is the next date of hearing.
20th.
Please, my lord.
But emergent notice to the respondents. Returnable by the 2nd of July. Till such time status quo.
But not to alienate.
Till such time the respondents shall not alienate the property, the subject matter of the suit.
Please.
Next.
49.
It's a dependent filed an application order, 9 rules, section 9 of the CPC to reject.
Section.
Property is already.
7 rule 11.
Section 9 ಅಲ್ಲಿ.
The petitioner is before this court calling in question an order dated 3/12/2024 passed by the concerned court rejecting an application filed under section 9 of the CPC in OS 1417 of 2020 seeking rejection on the score of want of jurisdiction. What is called in question before the concerned court is the acquisition proceedings for the purpose of formation of Dr. Shivram Karant layout. It is trite that the civil court has no jurisdiction to consider acquisition proceedings or adjudicate upon them. In that light, the application so filed was appropriate and this suit ought to have been rejected. In that, notwithstanding the same, IA 8 filed by the petitioner, the fourth defendant comes to be rejected. Therefore, further proceedings in OS 1417 of 2020 shall remain stayed till the disposal of the petition. Emergent notice to the respondents, returnable.
2 to 4 dispense with.
Learned counsel files a memo seeking dispensation of notice to respondents 2 to 4.
2 to 4.
Emergent notice to the first respondent. Yes, date. Next.
50.
Writ petition page number order.
Lord's page number order, my lords, at 148, my lords. 148 and 149.
Earlier GMCPC.
Please, my lords.
Dispose ಆಗಿದೆಯಾ?
Dispose ಆಗಿದೆ, pending ಇದೆ, where in a connected suit, an application for production of documents were rejected by the trial court. Against that,
proceedings are stayed there.
entire proceedings of all connected matters are now stayed. The trial court says.
Learned counsel for the petitioner is before the court calling in question an order dated 14/3/2025 rejecting an application filed under.
Rejecting the prayer.
Rejecting the.
Consider IA number 13 and 14.
To consider IA 13 and 14 filed under order 39 rule 4. The learned counsel takes this court to the documents appended to the petition with particular reference to an order passed by the coordinate bench in writ petition 2863 of 2022. The order reads as follows. The coordinate bench has also stayed further proceedings in OS 8345 of 2010 pending between the parties. In that light, the application ought to have been answered. There shall be an interim order of stay as prayed for.
Stay, alas. I have to consider my application. Court says in the connected matter, this honorable court has stayed the proceedings. Therefore, I cannot proceed with this matter also.
Correct.
That application was in respect of a different suit, not between the same parties, different parties. What happened, my lords? This is a layout developed by Bemel Society, my lords.
Correct.
Now that dispute is pending. Now in one of the suits were filed by the site owners, if wanted to produce some documents, that document was not.
See, OS 8345 of 2010 is stayed.
Please, my lords.
Correct.
Please.
Now, the order passed by the court is that pending, the suit pending ಇದೆ, so see, WP pending ಇದೆ, so will not grant ಅಂತ.
That says since that suit is in, there is a stay order, all the connected matters get stayed. That's the interpretation of the London's trial court.
Not be correct, but who are respondents here?
ಅವರು ಆ suit ನಲ್ಲಿ ಅವ್ರ party ಇಲ್ಲ. This is an independent offshoot dispute.
We'll see. List day after tomorrow in preliminary hearing.
Yes.
51.
Application for production of.
Order 18, Rule 17. You are the defendant.
I am the plaintiff.
Defendants produced, filed application by whom?
Application was filed by the plaintiff to produce a subsequent document which has been discovered. That throws light on not only on the fraud played by the subsequent purchaser who has filed a written statement that he is a subsequent purchaser without.
But at that filed stage of arguments.
No, immediately we filed.
Yeah, immediately in the 2015 suit.
Immediately after the evidence, Lordship may kindly see, I was afflicted with all the ailments. I could not lay my hands on this particular document. My wife, she discovered it. And all the medical documents are in the realm of the records, court records. I was severely affected and problems came in battalions that my heart was, I was operated.
Heart was?
Allah. It was not good and cardiac arrest was there and.
Cardiac arrest was there.
Cardiac arrest and he was almost dead. He was almost dead. He was almost dead and he was in ICU. He was hospitalized and subsequently knee injury was there.
ಏನು ಉಳ್ದೇ ಇಲ್ಲ ಮತ್ತೆ.
ಅಲ್ಲ ಹೌದು ಅವ್ರು ಏನು ಉಳ್ದೇ ಇಲ್ಲ ಅವರು. All these things have been brought on record. And my wife, she discovered this document. Your Lordship may kindly peruse this document where the subsequent purchaser says that I am a bona fide purchaser without notice and he has appended his signature. He brokered the piece and subsequently the apartments were constructed and he purchased the property. This document is very much necessary that where I can cross-examine the subsequent purchaser.
Matter is at the stage of arguments, nothing.
Allah, ಇಲ್ಲಿ ನಾನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಲಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ I am barred. Is a substantive suit.
You serve on the respondent. Yes.
Because it also throws on the light of limitation.
Let's see. Yes. 1 to 4 petitioner to serve on the counsel who represents the respondent. We'll take it on Friday. Ivatte serve ಮಾಡಿ. List on Friday. Yes, next.
52.
I appear for the petitioner, my lords. The petitioner had filed an application under Order 19, Rule 5 and Rule 6B, which came to be dismissed by the Honorable Trial Court. But the Honorable Trial Court went on to post the matter for judgment without giving me an opportunity to go ahead with the next stage, my lord, for arguments.
Arguments ಹಾಕೇ ಇಲ್ವಾ?
ಆಗಿಲ್ಲ.
Order sheet.
Fortunately, I don't have the order sheet with me right now, my lords.
Get the order sheet.
But it has been mentioned in the order itself.
Get the order sheets.
Please, my lords.
Day after tomorrow.
Please, my lords. Please.
Yes.
Certified copy may not be sought for.
No problem.
At least I should.
Whatever copy you have.
I'll do that. Please.
Next.
Much obliged.
53.
Petition and discernment. The dispute between the petition and respondent is 3 feet common passage, my lord. 3 feet common passage, my lord. Dispute between the petitioner and respondent is only 3 feet common passage, my lord. Petitioner and respondent filed the suit for the declaring that B scheduled property is not a common passage and is taken contention, my lord. Injunction order is not granted, my lord. Being agreed by the 13th, my lord, respondent and petitioner both are prefer the MFM, my lord.
What happened in the MFM?
MFM, my lord, both parties maintain status quo, my lord. I produced the order copy.
ಸರಿ ಈಗೇನಾಗಿದೆ?
Annexed
page
79, my lord. Page 77, my lord. This court has approved, my lord. Kindly see page numbers.
All right, both parties are directed to maintain status quo. ಇಬ್ರು ಯೂಸ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
ಇಬ್ರು ಯೂಸ್ ಮಾಡ್ತಾ ಇದ್ದೀವಿ.
ಸರಿ, ಈಗೇನ್ ಪ್ರಾಬ್ಲಮ್ ಆಗಿದೆ?
ಇದು ಡ್ರೈನೇಜ್ ವಾಟರ್ ಕನೆಕ್ಷನ್ ತಗೋಬೇಕು ಅಂದ್ರೆ ಬಿ ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿ ಯೂಸ್ ಮಾಡ್ಬೇಕು ಸ್ವಾಮಿ. ಅದನ್ನ ಕೊಡ್ತಾ ಇಲ್ಲ, ಅದಕ್ಕೆ ಪರ್ಮಿಷನ್ಗೋಸ್ಕರ ಫೈಲ್ಡ್ 151 ಅಪ್ಲಿಕೇಶನ್ ಮೇಲೆ. ಬಿಲ್ಡಿಂಗ್ ಆಲ್ರೆಡಿ ಕಂಪ್ಲೀಟೆಡ್ ಮೇಲೆ.
ಏನಾಗಿದೆ?
ಬಿಲ್ಡಿಂಗ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಹ್ಯಾಸ್ ಕಂಪ್ಲೀಟೆಡ್, ಬಟ್ ನಾವು ಕಾಮನ್ ಪ್ಯಾಸೇಜ್ ಯೂಸ್ ಮಾಡಿ ನಾನು ಡ್ರೈನೇಜ್ ವಾಟರ್ ಎಲೆಕ್ಟ್ರಿಸಿಟಿ ಕನೆಕ್ಷನ್ ತಗೋಬೇಕು. ಅದನ್ನ ಪರ್ಮಿಷನ್ ಐ ಫೈಲ್ಡ್
I
ಅಪ್ಲಿಕೇಶನ್.
can only continue the status quo. Stay of suiting. You have sought stay of all further proceedings there.
I'm not.
And what order is it?
Trial court has rejected 151 application. I my
For what did you file that?
my prayer is stay the impugned order interim order operation of the order.
Which order, sir?
Section 151 my lord. Annexed J my lord. Trial court has rejected the application IA number 5 my lord. IA number 4. Trial court has rejected the IA number 4 my lord.
You serve on the council.
Please.
The petitioner shall serve on the council who represents the respondent in the trial proceedings. List on 27th.
Please.
Yes, next.
Before adjourn 55.
For the petitioner, my lord. Tenant's petition, my lord. The tenant
Then
is.
you want to drag ಅಷ್ಟೇ ಬೇರೆ ಏನು?
ಇಲ್ಲ ಏನು ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಏನಿಲ್ಲ, ನಂದು ಇನ್ನ ಲೀಸ್ ಪೀರಿಯಡ್ ಇದೆ ಸ್ವಾಮಿ.
ಎಲ್ಲಿವರೆಗಿದೆ?
39/2026 ತನಕ ಇದೆ. He has not initiated any proceedings for eviction. On the other hand, I want to vacate the property. ನಾನು ಡೆಪಾಸಿಟ್ ಕೊಡ್ತಾ ಇಲ್ಲ.
Emergent notice to respondents 1, 2 and defendants 1, 2 and 3.
ನಂದು ಎಲೆಕ್ಟ್ರಿಸಿಟಿ ವಾಟರ್ ಎಲ್ಲ ಡಿಸ್ಕನೆಕ್ಟ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಫೋರ್ಸಿಂಗ್ ನಂದು ಅಲ್ಲಿ ನಾನು ಬಿಸ್ನೆಸ್ ಮಾಡ್ತಾ ಇರೋದು ಐಸ್ ಕ್ರೀಮ್ಸ್, ಬಬಲ್ ಟೀ, ಅದ್ರದ್ದು ಜ್ಯೂಸ್ದು ಅದೆಲ್ಲ
Bubble tea.
ಹೌದು ಸ್ವಾಮಿ. ಅದು ದಟ್ ಈಸ್ ವಾಟ್
Bubble tea ಅಂದ್ರೆ ಏನು?
ಇಟ್ಸ್ ಅ ಟೈಪ್ ಆಫ್ ಟೀ ವೆರಿನ್ ಇಟ್ಸ್ ಅ ಲಿಟಲ್ ಫ್ಯಾನ್ಸಿ ವೆರಿನ್
ಫ್ಯಾನ್ಸಿ.
ಹೌದು. ಬಬಲ್ ಟೀ ಅಂದ್ರೆ ಅದು ಈ ತರ ಇದಾಗುತ್ತೆ, ಅದು
ಬರೇ ಬಬಲ್ಸ್
ಇದಾಗುತ್ತೆ,
ಬರೇ ಬಬಲ್ಸ್ ಇರುತ್ತಾ?
ಹಾ ಎಸ್. ಜ್ಯೂಸ್ ಅದೆಲ್ಲ ಫ್ರೀಸರ್ಗೆಲ್ಲ ಎಲೆಕ್ಟ್ರಿಸಿಟಿ ಇಸ್ ವೆರಿ ಎಸೆನ್ಷಿಯಲ್. ಅದು ಡಿಸ್ಕನೆಕ್ಟ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ, ವಾಟರ್ ಡಿಸ್ಕನೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ.
Petitioner to serve set of papers upon the council who represents the respondent.
ಇಲ್ಲ ಅಲ್ಲಿ ಕೌನ್ಸಿಲ್ ಅಪಿಯರ್ ಆಗ್ತಾ ಇಲ್ಲ ಯಾರು ಇನ್ನ.
ಹಂಗ್ ಮಾಡಿ. Emergent notice to the respondent returnable by second. Petitioner shall also serve the defendants by way of hand summons. List the matter on 9th July. Till such time there shall be an interim order as prayed for.
My lord, also IA number 1 is also there, my lord. I have sought for temporary injunction, my lord.
So IA number 1 ಮೇಲೆ ಆರ್ಡರ್ ಮಾಡ್ಬಿಡಿ. Granted. Next, yes.
Please.
56.
Petition, my lord.
670.
Application for amendment, my lord.
What stage,
Written
sir?
statement, my lord.
What stage?
Argument, my lord. My lord, the issue was framed in the month of July 2024, my lord. Thereafterwards, further cross-examination held, my lord. My lord, I was impleaded in the matter in the year 2021, my lord. I filed written statement in the year 2021. My lord, I am only seeking for one particular word, my lord. Earlier, my lord, in written statement, I had stated constructed, my lord. Now, it is admitted by the plaintiff himself that the staircase is not yet completed. Even plastering work is pending, my lord. That is the only amendment, my lord, I am seeking now, my lord.
Constructed ಬದಲು constructing.
Constructing anta. My lord, it is in the plaintiff itself, my lord, in the plaint, page number 29.
Petitioner to serve on the council who represents the respondent, but that carries a lot of meaning. Construction ಅಂದ್ರೆ ಆಗೋಗಿದೆ.
Alla, he himself admitted, my lord, plastering work.
Learned the petitioners are defendants. Calling in question the rejection of an application filed under Order 6 Rule 17, seeking amendment of the written statement, the words from construction, quote unquote, to constructing. The learned counsel further takes this court through the deposition of the plaintiff, who admits that the construction had not yet completed. In that light, there shall be an interim order of stay of further proceedings before the concerned court till the next date of hearing. List on 9th July. Emergent note, petitioner to serve on the counsel who represents the respondent in the trial proceedings till the next date of hearing. Trial proceedings actually. Next.
57.
So I appear for the petitioner, my lords. Plaintiffs, my lords, appeal under my lords order 39 rule 1 and 2, my lords, which is confirm, my lords, the order of rejecting my temporary application,
Correct.
temporary injunction. Lords may see annexure G, my lords, page 63. The complaint, my lords, that is given by the defendant to the Tehsildar, my lords, as well as the ADLR, whereby, my lords, he says that there is, my lords, encroachment, my lords, ಸರ್ಕಾರದ ಜಾಗದಲ್ಲಿರೋ ರಸ್ತೆ ಗೇಟ್ ಅಳವಡಿಸಿ ತೊಂದರೆ ಮಾಡುತ್ತಿರುವ ಬಗ್ಗೆ. Lords, I am in possession, lords, of my property through a valid sale deed, my lords,
Dated.
Lords, the sale deed, my lords, dated 12/8/1993. Thereafter, my lords, RTC is entered. I am in possession of the property.
What is the suit for?
Suit for injunction, my lords. Not to disturb, my lords.
Who is the defendant?
Lords, defendant is my neighbor who says, my lords, that I have been interfering with his road, my lords, which is using from time immemorial. Lords,
So the question is with regard to the road.
please, my lords. I am, my lord, seeking injunction in my property not to disturb my possession and not to form any road in my property. Lords, where he does not have a right, my lords, over my property. He is not challenged, my lords, that also.
The petitioner is before this court calling in question dual orders, one passed by the trial court and one by the first appellate court, both of which concurrently declines to grant temporary injunction in favor of the petitioner. The learned counsel for the petitioner submits that the application under order 39 rule 1 and 2 ought to have been answered in favor of the petitioner, as the petitioner is in his property pursuant to a sale deed of the year 1993 and the respondent is his neighbor. Owing to the disturbance with peaceful possession, the petitioner had to knock at the doors of the concerned court seeking an injunction. In that light, the prohibitory injunction ought to have been granted by the concerned court. The learned counsel would further submit that the petitioners are not wanting to trouble the neighbor, but the issue is with regard to passage of the road, the passage which both of them are using. In that light, will only say status quo.
Lords, we are not using, my lords. I am seeking my property to be protected. That's it.
In that light, the petitioners, the respondent, the defendant shall not interfere with the possession of the petitioner till the next date of hearing. Placed on 9th July.
Please.
Petitioner to serve on the Helena, counsel represents us. Yes.
Great.
Orders 58.
Withdrawal.
Withdrawing the petition, my lord, it is.
Very good.
Respondent for 2 and 3, my lord.
Yes.
59.
In terms of the memo.
In this, my lord, may I make a submission?
Rectification of office objection.
I appear for the. I filed an application to vacate the interim order, my lord.
What's the matter, sir?
Your lordship may kindly appreciate. This is a defendant number 3, did against the order of the court. He has filed counterclaim, claiming 10 properties as his self-acquired properties. Now, he filed IA 36 for allowing him to lead evidence. And that has been rejected by the court by order dated 9/6/23. So I have questioned that order because I have been prevented from leading my evidence in respect of my counterclaim in the plaint note.
There's an interim order here?
There is an interim order, my lord. Cell number 59, there is an interim order, my lord. The stage is a pronouncement of judgment, my lord. At that stage, the application, the opportunity was given. On perusal of the order sheet, it clearly reflects, my lord.
Yes, sir.
And
we'll take it on Wednesday.
Pardon?
List the matter on Wednesday under the caption hearing and
contesting is the defendant number 1 and 3, my lord.
Well, it's Friday. Yes.
Friday. Public.
Next, interim order subsisting will continue to the next date.
60.
Let's appear for respondent number 1. My lords, the notice with respect to the other respondents may be dispensed with. I am the plaintiff, my lords. I am okay with allowing the writ petition, my lords, with the time bound fixed. Because the earlier writ petition, there was time bound fixed by the this honorable court.
My lord, whatever the address given in the plaint, that same has been furnished, my lord. We have already taken steps.
There is no objection to allow the petition.
They may be permitted to
Other
file the written
defendants,
statement.
dispensation.
Will file, my lord.
You are the contesting defendant, is it?
I am the contesting defendant. I am the plaintiff, my lords.
You are the contesting respondent here.
I am the contesting respondent.
The petition is preferred by the
Defendant number 7.
defendant number 7. The plaintiff is, the learned counsel appearing for the plaintiff submits that he is the only contesting respondent in the case at hand and has no objection to allow the petition only with, but would submit that a time limit be fixed for conclusion of the suit as the suit is of the year 2008. What is called in question is an application.
To condone the delay in filing WS, my lord.
Filing?
And to permission to file the written statement.
The issue that has driven defendant number 7 to this court is the rejection of an application seeking time to file the written statement. ಎಷ್ಟು ದಿನ ಆದ್ಮೇಲೆ ಆಗ್ತಾ ಇದ್ದೀರಾ?
Of 9 years.
9 years ಆದ್ಮೇಲೆ.
And in the meantime, the suit was stayed by lord.
Where?
In the High Court.
Which is that?
My lords, writ petition number 50178 of 2015.
2015.
And disposed on?
Page.
They have not produced it.
It was not produced, my lord. In the first instance, my lord, he was not made as a defendant number 7. Later he filed impleading application.
1 minute. Defendant number 7 was here, there. Either. The petitioner, defendant number 7, is before the court calling in question an order dated 7/6/2023 by which the concerned court rejects the application seeking extension of time for filing of the written statement from the defendant number 7. The learned counsel for the petitioner submits that the defendant number 7 was impleaded by an application under order 1 rule 10. When was the date?
27/8/2013 it was allowed.
Which comes to be allowed on 27/8/2013 but had not filed the written statement. The entire proceedings was challenged by the plaintiffs in writ petition.
Not by the plaintiffs, my lords. Defendant number?
By other defendants in writ petition 50178 of 2015, which comes to be disposed by the order of the coordinate bench on 2nd January 2023. After the disposal, the petitioner files an application seeking extension of time for filing of the written statement on the score that the proceedings were stayed at the hands of this court and the stay was operating for close to 8 years. In the cause shown by the petitioner was attributable to the pending proceedings before this court. Therefore, the court ought to have considered the application and granted time to file the written statement. When do you file now?
It is already filed.
The learned counsel submits that since it is filed, the learned counsel for the respondent submits the written statement is already filed and they have no objection for it to be taken on record. In the light of the aforesaid circumstance, the concerned court shall take the written statement on record and regulate its procedure in terms of the order passed by the coordinate bench which had directed the conclusion of the trial within 1 year from 2nd January 2023. In the light of the pendency of the proceedings, even after expiry of 1 year, I deem it appropriate to direct the concerned court to conclude this suit, which is of the year 2008, within 3 months from the date of within 3 months from today, if not earlier. It is needless to observe that the parties to the list shall cooperate with the disposal of this suit as observed herein above.
Much obliged.
61.
2 weeks' time is granted to do the needful. Next.
62.
For respondent in this petition, I filed application for vacating interim order, my lordship. The interim not been served, my lord. The interim order granted by this honorable court, staying the further proceedings in first appeal, my lordship. And they are alienating the properties. I have filed application, IA number 1539 rule 1 and 2. That application was rejected by the first appellate court, holding that it is not maintainable in view of the interim order granted by this honorable court.
It's all right.
Lord, can you
Now,
have it in the next week?
Maintain status quo and will direct the court to decide. ಈಗ ಹೆಂಗೋ interim order ಇದೆ.
Interim order may be modified so that the final judgment in the first appellate court may be stayed, my lordship. The further proceedings may be continued.
Lord, kindly have it in the next week. I'll file detailed objections, my lord.
For what, sir?
For the IA for vacating
ಯಾವಾಗ
stay.
ಕೊಟ್ಟಿದ್ದು ನಿಮಗೆ IA for vacating stay? ಒಂದು ವರ್ಷ
Copy has been
ಆಗಿದೆ.
not
Copy
served.
not served.
Not served, my lord.
ಇಲ್ಲ ಸರ್ವ್ ಮಾಡಿದ್ದೀನಿ
ಇಲ್ಲ sir.
Counsel for the
ಅಲ್ಲ
respondent to
ಸರ್ವ್
serve.
ಮಾಡಿದ್ದೀನಿ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಇದು.
Counsel for the respondent to serve set of papers of the application seeking vacation of the interim order upon the counsel for the petitioner forthwith, list on 25th.
It is served, my lordship.
ಅದೇ, if not already served, yes. Next.
My lord, interim order may be extended.
Interim order subsisting would continue till the next date of hearing. Yes, next.
63.
Petitioner, Lord, I have served the copy. The counsel was on record for trial court, Lord.
Well, acknowledgement.
It's there on 2nd of June.
What is the order?
My lord, here, my lord, this is a petition. This is a defendant's petition, my lord, and it's.
Notice ಆದ್ಮೇಲೆ in addition to ಅಂತ ಹೇಳಿರೋದು. Notice ಯಾಕೆ ಕೊಟ್ಟಿಲ್ಲ?
ಅಲ್ಲ,
You have not furnished PF at all.
if that is case, I'll pay.
Apart from that ಅಂತ ಹೇಳಿರೋದು.
Okay, in that case.
A week's time to do the needful.
Lord, the counsel was representing before the.
ಇಲ್ಲಿ ಇಲ್ವಲ್ಲ ಸರ್.
ಅಲ್ಲ, ಅವರಿಗೆ ಸರ್ವ್ ಮಾಡಿದ್ದೀನಿ, ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ಆರ್ಡರ್ ಆಗಿತ್ತು, ಸರ್ವ್ ಮಾಡಿದ್ದೀನಿ ಅವ್ರಿಗೆನೆ. But for the same counsel, again, the court has.
Apart from that ಅಂತ ಹೇಳಿದ್ರು. Take out notice.
64.
Yes. It's memo submitting death of R1.
For petition in this case. Permanent injunction law, so for permanent injunction.
Memo R1 ಯಾರು?
R1 died, my lord. So for permanent injunction, court permits.
Permanent injunction?
Dispense ಮಾಡ್ಬೋದು R1.
R1 ಯಾರು?
ಸಂಜೀವ್ ಕುಮಾರ್.
ಅವರಲ್ಲ ಸರ್. ಈ ಕಂಟೆಸ್ಟ್ ಬೇರೆಯವರು ಇದಾರಲ್ಲ.
Other parties are.
The petitioner has filed a memo reporting the death of first respondent. The no representation on behalf of the caveator, respondent number 3. Since there are other defendants, list this matter on Monday in preliminary hearing. Next. Post immediately after service of notice upon the first respondent. Interim order continue.
appear for the petitioner.
Interim order idea?
ಇಲ್ಲ, interim order.
65 or 66 ah?
ಇಲ್ಲ, 65, my lord.
Post immediately after service of notice upon the respondent.
A date may kindly be given, my lord. 60. ತಗೋತಿದ್ದೀರಾ?
You are appearing?
ಅಲ್ಲ,
You are
copies
appearing.
ಕೊಟ್ಟಿದ್ದೀವಿ, ನಿಮ್ಮ ಹೆಸರು ತೋರಿಸಿಲ್ಲ ಅಂತ ಅಷ್ಟೇ.
Counsel Raghu submits that is entered appearance for
Respondents, my lord.
the respondent. There 1 to 10, huh?
Lords, only respond number 2, 3, 2, only 2, my lords. One second.
Other respondents?
Respond number 1A, B, C, D, and 2.
Contesting respondents yaar?
Contesting respondents
Ten, huh?
ಅವರೇನೇನೆ. My lord,
Other respondents are not required?
my lord, I think the fifth defendant, that is
Was
respondent
being
number
set
8 is
up
also
by-
required because she is the subsequent purchaser. She might be required, my lord.
My lord, so that is not required. The amendment application was filed on two contexts. One, there was an injunction suit was already being
Let
disposed.
it come in preliminary hearing. The counsel so and so.
ನಾಳೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಗಿದೆ.
ಇರ್ಲಿ ಮಾಡಿ.
ಅಲ್ಲ ಮಾಡ್ಲಿ.
This day after
ನಮ್ದು ಆಗೋಗಿದೆ, ಅವ್ರದ್ದು ಮಾಡ್ಬೇಕು, ನೆಕ್ಸ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಟ್ಟೋಗುತ್ತೆ. ಶಾರ್ಟ್ ಡೇಟ್ ಮೇಕ್.
This day after tomorrow.
Yes.
And preliminary hearing.
Pleasure.
Yes.
66.
Yeah, for the petition. Idರಲ್ಲಿ the persons who it is shown it is not served anta, they appeared on the last date. Only against the ones who did not appear. Adene. So that is why I had dispensed as against others.
ಎಲ್ಲರಿಗೂ
No, my lords, I appear for respondent two. My learned friend appears for. My lords, others, I think notice would have to go.
I may be permitted to serve the counsels who are appearing before the trial court.
learned counsel.
My lords, I appear for respondent number 21 in FDP 120, my lords, in the trial court proceedings. On the last occasion, this court had directed that the petitioner may serve as copy
Which
as well.
respondent, madam? First tell me that.
My lords, we are not part of the writ petition, my lords. We had appeared on the last occasion and made submissions. The petitioner was directed to take steps, my lords.
Petition FDP. I will make them a party by the next date of.
Allow ಆಗಿದೆಯಾ ಅದು?
ಆಗಿದೆ.
ಮತ್ತೆ ಯಾಕೆ party ಮಾಡಿಲ್ಲ?
Ali, it was missed out because of a previous amended petition cost title. I will amend it on the. By the
My lords, and I'll have to bring one point to your lordship's notice, my lords. On the last occasion, my lords, many of the, of course, he is the dominus litis. I'm not disputing that. Many of the respondents were deleted. Now, my lords, this is a case where he seeks to add certain properties in a FDP of 2004. My lords, certain properties have already fallen to the shares of the parties who now are sought to be deleted. It is at his risk, my lords, he has to take that call. But
dispensation hakiva purpose ಏನಂದ್ರೆ they did not contest my application. The ones against whom I have sought dispensation, they did not
at your risk.
At my risk ಅಂತ ಹೇಳಿ ಮೆಮೊ ಹಾಕಿ ಅಲೋ ಆಗಿದೆ. That I don't think
ಅಲ್ಲ
should
ಈಗ
be
at
his
your
risk.
risk ಅಂತ ಅಲೋ ಆಗಿದ್ಮೇಲೆ ಮುಗೀತು.
ಅಲ್ಲ,
I need to bring it to your lordship's notice, sir.
Now you implead those two.
Please, I will implead a respondent 21 and I will serve the counsel appearing before the trial court as against others. Because 45 is already there as a caveat.
45 is a caveat.
47, 48 gu are same
Gautam,
advocate
maybe
before the
ಯಾರಿಗೆ?
trial court appeared.
Whom are you appearing, Gautam?
my lords, I appear for two, my lords, only two.
R2.
R2. 2, 3, and
Registry
5
to print the
only
name
two.
of Gautam
Petitioner
Bharadwaj
two.
Okay.
appearing for the second respondent.
Please.
The learned counsel, what's your name, madam?
My lords, Deepa S. my
So-and-so
lords.
would submit that respondents 21 and 22. Alli defendant.
21, my lords.
Ali respondent 21.
Respondents 21 and 22 who were
Only
before
21, my
court
lords.
are not made parties in the case at hand. The learned counsel for the petitioner submits that appropriate steps would be taken to implead the respondents 21 and 22 before the concerned court by the next date of hearing. The list them.
As against our 47 and 48, 45, 47, 48 together contested. Or by our 45 caveat ಹಾಕಿದ್ದಾರೆ.
ಮೂರಕ್ಕೂ ಹೇಳ
47, 48. 17 A, C and D.
Counsel who represents the caveator, respondent number 45, undertakes to accept notice for respondent
7 and 48.
47 and 48.
17 A, C and D.
17?
A, C and D before the trial court. ಒಟ್ಟಿಗೆ objection ಹಾಕಿದ್ದಾರೆ.
47 and 48. Registry to print the name of Chandrasekhara. Chandrasekhar is appearing for 47 and 48 as well.
R30, 31 and 33, I may be permitted to serve the counsel appearing before the trial court.
R30?
31 and 33.
R30, 31 and 33, the counsel for the petitioner is permitted to serve on the counsel who had represented them in the subject proceedings and file an acknowledgement. Thus completes,
Please.
serve agli. List on,
Second or fourth, my lord?
no, 9th.
No, interim order may continue.
List on 9th, interim order subsisting will continue to the next date of hearing.
Obliged.
67.
For the respondent 1247, my lord.
Respondent number.
I for vacating
3, my
application.
lord.
1 to
1 and 4 to 7, my lord.
you are appearing.
Please, my lord.
You have filed the application.
Please, my lord.
What's the interim order?
Injunction.
Not to alienate the property, not to create any third party.
Order-
Suit for injunction.
Partition and declaration, my lord. I have a file for temporary injunction filed, my lord. Meanwhile, I file application for jurisdiction, my lord. Then they.
Why jurisdiction?
Lord, it has not been decided. Lord, counsel on record is not in town, my lord. Today, the matter has been listed before the trial court. This is the.
All right, list under the caption hearing an interlocutory application. ಅದರಲ್ಲೇ ಇದೆ ಈಗ.
Address ಅಲ್ಲಿ ಬಂದಿದೆ ಸ್ವಾಮಿ. Preliminary.
Interlocutory application on next Wednesday, 20.
Lordship,
Could be disposed, my lord, with the direction, my lord, to the trial.
Lordship,
Consider
it
the
can be
application on
referred to
merits.
mediation.
Mediation.
Mediation,
After
because
39
again,
to
ಇದರಲ್ಲಿ
application.
almost 400 acres property involve ಆಗಿದೆ ಇದರಲ್ಲಿ.
ನೀವು ಅಪೇರ್ ಆಗ್ತಿದ್ದೀರಾ ಸರ್?
ಇದು IA ಕನ್ಸಿಡರ್ ಮಾಡೋದು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಡೈರೆಕ್ಷನ್ ಕೊಡಿ.
There is a, I would only point out one aspect, my lord. There is an abuse of process of the court. A suit is filed in which there was a caveat. A valuation slip served on the caveator shows that it was not maintainable in the court of the junior division.
All right.
Orally, he raises the objection saying, kindly take up tomorrow. According to this, it will not come up before this court. We are filing objection for IA as well as this. Matter was called on the next day. An application in writing was filed raising the objection of jurisdiction. By that time, we came to know that in the court copy, some amendment has been made showing the valuation differently. But along with the plaint, they have produced the sale deeds in which the value is available. It would not be maintainable in that court. When that was pointed out, court said, you file objection with regard to this maintainability, I will take up the case. Now, on that order, they have come before this court. There cannot be a
We have filed
entertaining
objection.
of
Even the
writ
notice
petition.
has not been issued, my
Considering
lord.
the
I
application
will
is
take some
altogether
instruction. I will take
different.
some instruction.
There
There is
cannot be an order of injunction.
Take some
There is an
instruction.
Writ petition. It's
interim order.
actually abuse
Interim order
of
has
the
been
process
granted,
of court.
Interim order also is there?
Yes,
my
my lord. That's why I said it's a.
The two sale agreement, my lords. Some of the properties they are trying to alienate.
Not really.
There are more than 400 acres of property.
ಮತ್ತೆ ಇವರು ಕನ್ಸಿಡರ್ ಮಾಡಕ್ ಹೇಳಿ ಅಂತ ಇದಾರೆ.
Consider ಮಾಡೋದು ಬೇರೆ ಈ interim order.
Your lordship, I will take some instruction.
This interim order may be vacated. Let the applications be considered. Valuation as well as injunction.
By next week, I will take some instruction. Today, the same matter has been listed before the trial court on Kadur, my lords.
I appear on behalf of respondent number 11 in this matter. I am also one of the daughters of the propositor, so I would be interested in this as well.
Lords, my senior colleague is in.
No, the issue is whether the court can entertain that or not.
At this stage.
That's all.
Writ petition.
So who is there, who is not there?
Next week.
No, next week, sir. The plain and simple, whether it is entertainable there or not, valuation slip change ಮಾಡ್ಬಿಟ್ಟು ಇಲ್ಲಿ.
No, we have not.
Or valuation change ಮಾಡಿ ಅಲ್ಲಿ, you can't do that.
Your lordship, it may be have it on day after tomorrow, my lord.
Day after tomorrow, finally.
Please.
List the matter, day after tomorrow under the caption, interlocutory, hearing on interlocutory applications is made clear, no further adjournment will be granted in the matter. Al ಮೇಲ್ಗಡೆ heard so and so, Leonard Senior Counsel Jaykumar S. Patil ಅಂತ ಹಾಕ್ಬಿಟ್ಟು
Interim order to be extended.
interim order subject to the aforesaid condition stands extended till the next date of hearing.
Please.
68.
I seek a password, please, my lord.
No
Senior
password.
Bursar.
ಏನಿದು peremptory order? ಕೊಡಿ ಇಲ್ಲಿ. Office objection is not complied?
Complied, my lords. On the last date, I had made submission on that regard.
ಆಗಿದೆ.
ಅದು
ಈಗ ಸಾಯಂಕಾಲ ವೇಳೆ ಕಂಪ್ಲೈ ಮಾಡಿದ್ರೆ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತೇನೆ.
My lord,
ಈವ್ನಿಂಗ್.
one submission, my lord. The last date of hearing, I had made a mention that it cannot be complied for the.
Cannot be complied?
Please,
Why?
my lord, for the reason that, my lords, ಇದು ಚಾಲೆಂಜ್ ಮಾಡ್ತಿರೋದು 1998 ಡಿಗ್ರಿ. ಅದರಲ್ಲಿ petitioner ಯಾರಿದ್ರು, they have got expired, so I have made their Rellas as respondent, my lords. That's all the objection, my lords.
Office objections overruled accepting the submission of the counsel for the petitioner. List on Monday.
My lord, there's one urgency, my lords. That is, ಇದರಲ್ಲಿ ಏನಾಗಿದೆ, there's an order of this honorable court directing the Tahsildar to mutate RTC in my favor. And I filed a
Day
complaint.
after tomorrow. Yes.
Obligement.
This day after tomorrow in preliminary hearing.
59.
For the petitioner, my lord. Lord, I tried to locate the office of my learned friend who is appearing for respondents. It was closed twice, please, my lord.
Closed?
Closed, yes, please, my lord. Matter is listed on 19th day after tomorrow.
What's the matter?
Lord, my application for further evidence is rejected by the court below, holding that whatever evidence I have given is sufficient.
ಯಾವಾಗ ಫೈಲ್ ಮಾಡಿದ್ರೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಸ್ಟೇಜ್ ಅಲ್ಲ.
ಇಲ್ಲ, immediately after completion of my evidence.
Application date ends.
18/6/2022, please.
That order is passed after 2 years, after 1 year.
After 1 year.
Anyway, let him come. List the matter on 9th July till such time further proceedings before the concerned court shall remain stayed.
Obliged.
List in preliminary hearing on that.
Please.
Yes, next.
Petition
70.
ನೀವು
seeking
ಇದ್ದೀರಾ?
directions. Well, my sale deed is in the year 2003.
My lord, subsequently, despite my lords, the sale deed that was executed in my favor, my vendor, my lords, would execute another sale deed in favor, in the year 2006. My suit is in 2009. Since 2009, my lords, my.
Where have you served a copy, sir?
My lord, your lordships may permit me to serve. it, my lord.
29/4/25 itself.
Council phone ಐತಲ್ಲ.
Issue notice ಆಗಿದೆ. Steps ತಗೊಂಡಿಲ್ಲ.
ಇಲ್ಲ, steps ತಗೊಂಡಿದ್ದೀವಿ. Steps has been taken.
You were also directed to serve a copy on the council.
Council is not answering the call.
Not?
Not answering the call.
Answering the call. Yes, anyway, post immediately after service of notice upon respondents
Lordships may
1
kindly
to
fix
4.
a date, my lord. I shall.
The
try to-
petitioner shall serve the respondents 1 to 4 by way of hand summons as well. List immediately after service of notice upon the respondents.
I'm so very grateful.
Yes, next.
21.
In this case, my lord, the respondents are refusing to receive the copy. I am filing the affidavit, my lord, except R6 is served, my lord.
Affidavit ಹಾಕಿದ್ದೀರಾ?
ಹಾಕ್ತಾ ಇದ್ದೀನಿ.
Counsel for the petitioner files an affidavit narrating that counsel is refusing, is it, or what? The counsels have refused acceptance of notice as is directed by this court. Therefore, further proceedings, therefore, till the appearance, emergent notice to the respondents, till the appearance of the respondents, there shall be an interim order of stay of further proceedings before the concerned court. Next.
72.
Respondent number 2 in this case, my lords. I take time to find objections to the main petition.
today, Your Honor, in counter.
Interim order ಇದೆಯಾ? Stay ಇದೆಯಾ?
No, stay is not there, lordship. Some evidence is going, if they'll not press the evidence there in the trial court, it may be given.
I have filed my wakalat today, Your Honor. I may be permitted some time to file my objections to the.
The learned counsel for the, then we'll stay further proceedings there.
Yes, Your Honor. In fact, there is a suppression of facts which I wanted to bring about because the order. has
My
already
learned
been
friend want to
passed.
submit, then I may be permitted to make submission of first.
There is an order which is already passed in
One
IA
minute.
number 17 in.
1 minute. The learned counsel so-and-so submits that he has entered appearance for
Respondent number 1.
for the first respondent. Registry to print the name of so-and-so is appearing for the first respondent. Thus completes the service of notice. Office objections.
Is complied, lordship.
Learned counsel submits office objections have been complied with. List on Friday.
Oblige.
Friday. Yes, next.
73.
This case, my lord, I have served copies for appearing advocate and record.
R8 to 17.
Yes, ma'am. I have served. This case, my lord, is not framing issues, my lord, as per the contentions taken by the written statement, my lord.
What's the order and challenge?
I have challenged, my lord.
Next date and.
They rejected, my lord, 14 rule.
Next date and.
Right?
Next date.
Trial court, my lord. Next month.
List on Wednesday in preliminary hearing. Next.
I have taken notice, my lord. I have already.
Day after tomorrow we'll see. Interim order ಬೇಡ ಅಂದ್ರೆ next week ಆಗ್ತದೆ.
Take back.
Next.
74.
My lord, appearing for petitioners. Office is directed to put up, my lord, already served and acknowledgement ಹಾಕಿದ್ದೀನಿ ನಾನು. Put up ಮಾಡಿಲ್ಲ.
ಆಯ್ತು ಮಾಡ್ತಾರೆ. Yes, next. Next.
My lord, appearing for the petitioners. Here before this court for crashing the.
74. You have not taken steps?
We have served this one, personally, we wanted to serve and they did not take it and we have sent it.
Notice issue ಮಾಡಿ. Why did you want to serve it personally?
Notice issue
A week's time is granted to do the needful. If the needful is not done by the next date of hearing, the interim order would stand automatically vacated. List on 2nd July.
ಅವರಿಗೆ ರಿಜಿಸ್ಟರ್ಡ್ ಪೋಸ್ಟ್ ಕಳಿಸಿದೀವಿ ಅವರು
ಬರ್ಲಿ ಅದೇನು ತೋರಿಸ್ತಾ ಇಲ್ಲ. Yes, next.
75.
Post immediately after service of notice upon respondents 1 to 9. Interim order ಇದೆಯಾ?
Interim order.
Subsisting shall continue. Next.
Grateful.
76.
Same order.
77.
My lord, I appear for the petitioner. I have served the copy on the council.
File wakalat for respondent.
Learned counsel so-and-so undertakes to enter appearance for the respondent. Registry to print the name of so-and-so is appearing for the respondent, thus completes the service of notice. List on interim order ಇದೆಯಾ?
ಇದೆ ಸ್ವಾಮಿ.
List after 2 weeks, interim order subsisting will continue to the next date of hearing.
Date, my lord, date.
77.
2 weeks, 2nd July ಅಂತ ಹಾಕಿ. Next.
Grateful, my lord.
70?
77.
ಯಾವ್ದು madam? 77 ಅಲ್ವಾ ಆಗಿದೆ ಈಗ?
78.
Kindly pass over, my lord.
Pass over.
Senior is come just.
Where is the acknowledgement?
Acknowledgement is here just.
3 days time is granted to do the needful. Next. 78, 9.
79.
79. This is a case where I suggested to my colleague, complaint given to the registrar, first he has to withdraw.
ರಿಜಿಸ್ಟ್ರಾರ್ ಕಂಪ್ಲೇಂಟ್ ಏನ್ ಮಾಡಿದ್ರು?
Cross examination ಗೆ ಅವಕಾಶ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ.
ಅದಕ್ಕೆ ಯಾಕೆ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ರು ರಿಜಿಸ್ಟ್ರಾರ್?
No, in fact, I told him, don't appear in the suit, give the NOC, there will be again confrontation. But complaint given as against the judicial officer should be withdrawn.
What is the problem?
Sir, the problem is, my lord, he went to the Malur by the time he came, my lords,
Went to Malur?
for attending some other matter. The matter got passed over. There is a delay in reaching the court, 10 minutes. The officer said, we are discharging the further
Cross examination. Heard the learned senior counsel V. Lakshminarayan appearing for the petitioner. Should I record that he would withdraw the complaint?
Yes.
The
And I will also told him,
counsel
don't
on
appear
record
in the suit.
submits that he would withdraw the complaint registered before the vigilance, before the registrar of vigilance of this court against the presiding officer. The submission is placed on record. The learned senior,
We will also, my lord, withdraw the wakalat.
that's all right. That's,
Again,
I will not
I'll
record
come.
all that. Yes, the learned senior counsel submits that the counsel on record reached the court on the same day fixed for further cross-examination with a delay of 10 minutes. On the score that the counsel on record is not present for the cross-examination of the PW1,
Yes, DW.
of PW1 is set,
DW1.
DW1 is said to be closed. In the light, on the said submission, further proceedings before the concerned court shall remain state. Emergent notice to the respondents. Petitioner shall serve on the counsel, advocate on record shall serve on the counsel who represents the respondent defendants before the concerned court and file an acknowledgement to that effect. Yes.
It may be listed next week.
List on 27th. This office objections in.
Name
Counsel.
is not complete. There is a
Office
small
objection,
objection.
office objections to be complied with by the next date. Yes, next.
Hearing on IA, number 80.
For the respondent in this matter, my lord.
Vacating interim order.
Please, my lord.
Petitioner is not there.
Impugned orders dated 29/1/24. However, it pertains to FDP 1 of 97, my lord.
Correct.
Please, my lord. They are usually there, my lord. the
Pass
other
over.
side. Please.
Yes, pass over.
81.
To the respondent, your lordship. Your lordship may kindly pass over the matter.
ಇವ್ರು ಯಾರಿಲ್ವಲ್ಲ? Pass over.
Great.
82.
You for the respondent.
Filing my objections to the application or vacating interim order.
Objections to vacating interim order.
Lord,
ಏನ್ interim order?
I am the landlord of the property in question. I file a suit for ejectment. The only defense taken by them is that you have surrendered possession of the property. Lord, I state that I have not received possession. It's a registered lease deed. There is no surrender deed also which is executed. Not up to the date of vacating the property, I am entitled for rent. My learned friend says he has already vacated. I was talking to my learned friend now outside. I said, I am not able to use my property. You are in possession. I don't have the keys of the property. I am at loss for almost 1 crore, 80 lakhs, please, my lord. Can I request this honorable court to appoint a commissioner for inspection of the property if he is able to break open the lock and hand over
Break
possession?
open the lock. Why?
Because it is under
I have
lock
handed
and
over.
key. It is under
I can
lock
use
and
the-
key.
Hand over possession.
ಅವ್ರು ಹೇಳ್ತಿಲ್ಲ ಅದು. I have ಅಂತಾರೆ ಅವರು.
I have already, in 5 years back, I have already.
5 years back.
Please.
Oh,
And my lord, see the photographs which I have produced along with my application for vacating stay. All his name boards and stickers are already still available. If he has handed over possession, he should have removed all those things.
Name board and
No,
stickers
what
are
is
there,
it,
but
what is it?
It's a, my lord, an interim order wherein the honorable court directed him to deposit rents from the date of suit till surrender. It's only deposit of rents also, not to
Once
hand
an-
it over to me also.
he wants an affidavit. I'm ready to file affidavit saying that I am not going to file any.
Because
criminal case
tomorrow,
for
if I
trespass.
go and break open the lock or I open the premises, he will file a criminal case against me for trespass.
I'm ready to file it.
File an affidavit, we'll close it here.
Please me.
Yes.
At least I'll utilize my property.
Monday,
Monday, next Monday.
interim order may kind.
Interim order subsisting. The issue in the list revolves around the landlord and the tenant. The tenant, the petitioner, is said to have vacated the premises 5 years ago. The respondent landlord submits that there is no indication of vacation of the premises, as all the nuances of the tenancy being present is still present in the premises. The learned counsel submits that the tenant would file an affidavit and would have no objection for the respondent to take over the property, take possession of the property. List the matter on Monday, the next. Interim order subsisting will continue to the next date of hearing. Yes.
83.
Respondent number 8,
My
9,
lord.
10, 12, 13, 14 and 15, your lordship.
ಏನು 1 2 3 4 ಹೇಳ್ತಾ ಇದ್ದೀರಾ?
Sorry.
My lord, for unserved respondents, my lord, I'll take hand summons.
ಈಗ ನೀವು ಯಾರಿಗೆ ಸರ್ ಮತ್ತೆ ರಿಪೀಟ್ ಮಾಡಿ ನಿಮ್ಗೆ
8, 9, 10, 12,
ಬರ್ಕೊಂತ
13,
ಇದ್ದೀರಾ?
16.
ನಾನ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇದೆಯಾ ಆಲ್ರೆಡಿ? ಮೋಹನ್
Behalf of one.
ಮತ್ತೆ ಯಾಕೆ ಹೇಳ್ತೀರಾ? ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇದೆಯಲ್ಲ ಬಿಡಿ. ಅನ್ಸರ್ವ್ಡ್ ಯಾರು?
Unserved ಬಂದು respondent number 4, 6 and respondent number 11 are unserved.
A week's time is granted to do the needful.
My lord, I'll take hand summons, my lord.
Do the needful. Petitioner shall serve, adbaribedi, shall serve the unserved respondent 4, 6 and 11 by way of hand summons.
Obliged. My lord, and note number 3, my lord, respondent number 7 is stated to be expired, my lord. Respondent number 8 and 9 are the LRs of respondent number 7.
ಅವ್ರಿಗೂ ಸರ್ವ್ ಮಾಡಿ ಅಷ್ಟೇ.
ಅಲ್ಲ, ಅವ್ರು ಸರ್ವ್ ಆಗಿದೆ ಆಲ್ರೆಡಿ.
They are already on record.
All right. So, yes.
And my lord, there is unclaimed respondent. Respondent.
Respondent number 1, 2, 3 unclaimed.
Yes, my lord. It may be
The
taken as
postal shara indicates that respondent 1 to 3, the notice sent to respondent 1 to 3 are returned unclaimed. In that light, the registry is directed to print the name of respondents 1 to 3 as served and show their name and print them as served. Yes.
Obliged.
So bless.
Next.
54.
The impeachment order is challenged before his honorable court regarding the rejection of my clubbing application. Start for clubbing.
Section 24 application.
Section 24 does not come because clubbing against section 24 does not cover. It's under section 151.
151. Yes.
So all these 18 cases are before the same court. And the plaintiff in all the cases are one and the same. And she claims title and the issues to be tried within all the 18 defendants is one and the same.
Respondent filed 22 suits, my lord. In that, 18 suits are contested by petitioner. And in each suits, defendants are different. Even scheduled property measurements, documents are different.
What is the impleading application here?
Impleading application, there was an office objection that let all the remaining defendants also on very 733 of 2018.
ಈಗ
In one
ಮಾಡಿದ್ದೀರಾ
case.
ಅದನ್ನ?
I've already implemented them also. I filed wakalat for them also.
But all the impleading applications.
Yes, yes.
In 2023, if evidence completed.
List day after tomorrow in preliminary hearing.
There were an interim order and because it is and then the cross examination of PWN has taken as the different evidence is also has taken.
Day after tomorrow. Yes.
55.
Next.
I appear for the petition. This matter would have become infructuous. Kindly post it tomorrow. I'll just take instruction and.
Your lordship, we have sold the property. The property in contention was the property belonging to the respondent, for which the petitioner had executed a JDA. Now, your lordship.
Infructuous ಆಗಿದೆಯಾ?
It is infructuous.
Then close ನಾಳೆ
Have it tomorrow, up the list because I have to take the party instruction. That is the only.
On 7/2 we have sold it. On 7th of February 2025, we have sold the property.
I'll just file his memo, that's the reason.
I'll take it day after tomorrow.
Let,
Day after
till then
tomorrow
the
in preliminary hearing, we'll close it.
interim order may be extended till then.
The learned counsel for the respondent, Anjana CH, submits that the petition is rendered infructuous as they have sold the property in the year in the month of February of 2025 itself. The learned counsel for the petitioner seeks a day's accommodation to secure instructions and make submissions. List day after tomorrow.
Interim order may be
In preliminary hearing, interim order subsisting would continue to the next date of hearing. Yes.
great.
86.
For the petitioner. Suit for injunction against the third party.
80,
86.
Trespasser came into.
vacating interim order. No representation on behalf of the respondent.
There are trespassers, my lord, no.
List the matter on 9th July. Interim order subsisting will continue to the next date of hearing. Next.
87.
That's, I appear for the petitioner. That's one request.
Number 92, my lord.
Yes, ma'am, that's,
Tenant's petition.
I may make one request. Before I see, suit is of the year 2022. IA number 92 is before my lords. That's one
2002.
indulgence. 2002, I'm sorry.
2002. 22 in the year 92.
It's a 2002 suit, my lords. That's one indulgence. There's an extra L, my lords, passed by the coordinate bench.
Page,
my lords, 147. That, my lords, has been sought by me for a review and a notice has been issued and the matter is listed on Thursday. My lords, that matter, my lords, if it gets decided in my favor, my lords, this petition may not survive for arguing or consideration.
which matter, sir?
Yes, my lords. My lords, an extra L, my lords, 147.
Correct. I am at 148, the operative portion of the order.
Yes, that's our petitioner in challenge ಮಾಡಿದ್ ನಾವು that a document has been marked
Correct.
without a person entering into the witness box, which is contrary to order 13 rule 4.
Petition is dismissed.
Petition has been dismissed. That's what we sought for and what has been given, so rather what happened at the final order was completely different. The learned judge, the court went ahead to issue notice to the respondents. That matter is coming up on Thursday. I may request, one day on request, may have it on 24th. We'll finish that matter. I'll finish that matter with the respondents. And I've requested them, and I sent a mail on Saturday itself. They said they'll consult the senior and come, not of course.
Senior is here.
No, not sir, not sir. They're senior.
Lord, the defendant tenant wants to summon the plaintiff as his witness. This honorable court already, my lord, please come to page 87 of my objection statement. There's already, my lord, held that you can't do that. In the light of that, my lord, IA 92, my lord,
page 87.
87 of my objections.
That's
IA for vacating, my lord.
IA for vacating.
WP 52330 of 2019. Please come to my lord, running page 91. 91, paragraph D. Summon ಮಾಡೋದಕ್ಕೆ ಆಗೋದಿಲ್ಲ ಅಂತ ಅವರೇ
ಯಾರನ್ನ summon ಮಾಡ್ಬೇಕು?
I'm summoning the plaintiff. I have a line of judgment. It is not so. This relies upon a 1938 Privy Council judgment to arrive at a conclusion.
It is between the same parties.
It is between the same parties. I want it.
This has become final.
Yes.
May make this request.
Has this become final?
Yes, become final. May make one submission. Idnali, I wanted to summon the GPA holder.
Howdರಲ್ಲಿ?
E case what my lords are looking at page number 87. My lords, after that, my lords, 2022, the petitioner, the plaintiff demises, my lords. Legal has come on record. My lords, they, my lords, without entering into the witness box, mark a document which they are saying that no, it is only a change in the nomenclature. That goes.
What judgment you have, sir? Could you?
Let's make one request.
If you have no judgment, take my judgment. We'll dismiss
I have it. Yes. We will. That's one request is.
How nice division made judgment.
We have a series of judgments to prove my point. Yes, my lords, across the court, my lords, where I can summon the plaintiff.
59 Mysore, apart from PV Council, 59 Mysore. And then, my lord, Justice Krishna Dikshit's judgment has become final.
That's that, my lords, I can factually, my lords, I may take my lords to page number 87 for a moment of statement of objection. That's, I'm only requesting, my lords, I'm not going back and arguing the matter. I'm only saying that, my lords, assuming for a moment, my lords, my petition gets allowed on Thursday before the coordinate bench.
Coordinate bench, ಯಾವ್ದಿದೆ?
Annexure ಎಲ್ಲಿದೆ? I told you, my lords, I filed a review petition.
Not in respect of this.
In a review petition. My lords, assuming, my lords, I'm just taking assumption in my favor, my lords. Then, my lords, the witness has to come, the order marking the document would be set aside. The witness has to come, mark the documents, my lords. I would consequently get the right to cross-examine that particular
We will
witness.
not trouble any witness, sir. We close this.
One nimsha. My lords may see the entire series of petition, my lords, how it has gone about. My lords, if my lords want me, I mean, if my lords say that my lords have to argue, I'm ready to argue.
I guess you're the petitioner.
That's Angala. I've requested them. It was a request, my lords. If they say, my lords, okay, my lords, I would put it this way. If my lords, if the respondents, my lords, insist that I have to argue the matter, my lords, I will argue the matter.
Don't worry about the respondent. Court is insisting. You have to. Yes,
That's
sir.
my lords may consider on
90
24th.
IA number 92.
Yes, my lords. My lords, I knew that,
Suit
my
of
lords,
2002.
respondents would start with that, my lords. Suit is of
Tenancy
2002.
admitted. Tenancy admitted. Is the tenant have the
My
landlord?
lords, suit is of 2002. IA number 92 is before my lords. IA number 92 has been impugned on 3 different counts. My lords, before that, I may bring my lords.
What is the IA?
Yes, my
To
lords.
summon the plaintiff for GPA holder.
No. The plaintiff.
All right.
Who are the legal heirs today on record, not the plaintiff, my lords. The legal heirs of the plaintiffs who are contesting the
Correct.
suit as of today.
You virtually the plaintiff. Yes.
Yes, my lords. My lords, the facts of the case, my lords, if I may take my lords to the facts. 2002, my lords, they filed a suit saying that I am a tenant and I have to be evicted of the property, my lords. Number one. Number two, my lords, 2014, after 12 years of filing the suit, they present 2 documents before the court saying that, my lords, these are my title documents, which is unregistered, unstamped. That's, I object to the admissibility of the document. The court says that let us refer it for the arguments. That's, I bring that order to this court, my lords. This court, my lords, may take my lords to my writ petition, my lords.
Page.
Yes, my lords. That's annexure C, my lords, page 59.
Page?
Page 59. That's page 59, my lords. What has happened? Paragraph number 6, page number 63, my lords. The entire controversy boils down to that in this particular case. May I read, my lords? Paragraph 6. The controversy in this case is in a very narrow compass and can be decided bearing in mind. Perhaps I would read that on perusal of the order passed by this court, in the earlier petition, it is noted that those documents which are sought to be marked by the respondent plaintiff and objected to by the petitioner, herein were ordered to be marked for the purpose of identification. The trial court has completed with that direction and it has not given the controversial documents.
That was a consent order.
It was an order which came to be passed. When this court has already stated that those documents have been marked only for the purpose of identification, it would be necessary to imply that those documents are not admitted in evidence by the trial court. This becomes further clear from the fact that this court is on the aforesaid writ petition disposed of so and so.
You are the tenant, is it?
Tenant
I'm not the
admitted.
tenant.
Written statement will admit
I
ಮಾಡಿದ್ದಾರೆ.
would
Page 47
come
and
to that.
48.
That may not have any bearing on my application today, my lords, for the reason.
112 of the Evidence Act.
ಅಲ್ಲ,
Hold, ನೀವು ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀನಿ.
Yes.
maybe.
ಹೇಳಿ.
Sorry.
The documents were only, my lords, identified for the, as it was produced before the court, and it was not marked as evidence at all. Now, my lords, subsequent to which the conclusion is that let the court decide on admissibility. The court decides, my lords, these 2 documents are not admissible in law. That has been, my lords, impugned by the respondents before this court. My lords, at page number, my lords. In 2019, my lords, that writ petitions get decided,
All right.
my lords.
We'll take it at 2:30. Get ready. and
That's
come.
my request.
ಇಲ್ಲಿ ಓದ್ಬೇಡಿ.
I'm just page number miss ಆಯ್ತು.
ಅದು ಲಂಚ್ ಅವರ್ ಹಾಕು ಬಂದ್ಬಿಡಿ.
I'm just requesting, my lords, the matter would be set at naught, my lords, after Thursday.
We'll set this matter at
That's-
naught, don't worry. Yes.
That's my have it on 24th. It's my request. That's I'm
Not this is abuse.
no, it is not so, my lords. I will show, my lords.
We'll
how-
see if I hear you and then come to conclude that you do need time, we'll grant. Yes. Pass over.
89, 88, adjourn 89.
Filed a vacating stay application.
For
The
petition,
plaintiff,
madam.
the petitioner herein is a
Counsel's
defendant.
mother has passed away,
Ibru
madam.
ಹೇಳೋದು ಆಗಲ್ಲ. Yes.
Counsel's mother has passed away, madam. Pray for 2 weeks time, my lord.
For date.
Learned counsel for the learned counsel representing SK Acharya submits that there is bereavement in his family, therefore seeks 2 weeks time. List the matter on 4th July.
Grateful.
Interim order may kindly.
Interim order subsisting will continue till the next date of hearing. Next.
90,
May be permitted to appear for the petitioner, my lord.
It's regarding that execution proceeding.
Yes, ma'am.
Your notes.
Lords may please take page number 53, my lord. Sorry, my lord.
Why are you in VC?
And, there was one matter, my lord, therefore I logged into VC. my lord.
This is also one matter. Come.
Very well,
Yes.
my lord. Afternoon, can I come? my lord?
So afternoon 2:30 will take it. Yes.
P group matter 91.
Yes, Tahir.
Suit for specific performance.
Hmm.
The sale agreement is executed in 2023, 2003 lordship.
Who is the
And the
contesting respondent?
Respondent is 29 to 11, 209 to 11 lordship.
Who represents them?
Today, one counsel met me today in the morning and they said we are filing NOC Vakala.
The
Stay is already there,
That's
it's covered up matter. And
list the matter on 2nd July as the last chance. In the event the respondent would not be represented or the counsel for the respondent would not represent, the matter would be disposed on hearing the counsel for the petitioner. Interim order subsisting will continue to the next date of hearing.
Coordinate page, judgment is page number 56. lord.
At ಬಂದ್ಬಿಡ್ಲಿ ಅವ್ರು. Stay ಇದೆಯಲ್ಲ. Yes.
92,
My lord, this is a matter wherein, my lord, I am the owner of the property. I have not sold the property anytime, my lord. 2003, my father purchases the property, my lord. 2013, my vendor fabricates
ಯಾರು
documents.
ರೆಸ್ಪಾಂಡೆಂಟ್ ಯಾರಿಲ್ವಾ?
ಬರ್ತಾನೆ ಇಲ್ಲ.
Fabricates documents.
ಅಲ್ಲ, that's what they have done, my lord. They have fabricated
ಇಲ್ಲ
documents.
ಏನ್ ಯಾರು ವಕಾಲತೆ ಹಾಕ್ದಂಗಿಲ್ಲ?
ಕಾಪಿನೂ ಸರ್ವ್ ಮಾಡಿ ಸರ್.
ಮಾಡಿದ್ದೀರಾ? ವೆಂಕಟೇಶ್ ಮೇಲ? Heard the learned counsel appearing for the petitioner. Counsel for the respondent is not present, awaiting his appearance. The last chance list on 4th July. In the event he would not be present, the petition would be answered. Hearing the counsel for the petitioner. Interim order subsisting will continue to the next date of hearing. Next. Settlement in.
it disposed. 94, final hearing.
My lords, it's matter pertaining to Nadaprabhu Kempegoda layout, my lords.
Covered.
Covered.
Our petitioner ilva?
In the last date also, he has not appeared. my lords.
ಮೇಡಮ್ ಅದೇ ಯಾವಾಗಂದ್ರೆ ನಾಡಪ್ರಭು ಇದೇನಾ 2:30 ಇದೆ. 2:30 ತಗೊಂತೀನಿ.
Yes, my lords.
ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಆಲ್ ದೋಸ್ ನಾಡಪ್ರಭು ವಿಲ್ ಫಿನಿಶ್.
Lords.
ಎಲ್ಲ ಅದೇ ಅಲ್ವಾ?
Mike, yes.
ಅದೇ ಅಲ್ಲ ಮೇಡಮ್? ವಿಲ್ ಕಂಟಿನ್ಯೂ at 2:30. ಪಾಸ್ ಓವರ್ ಯಾವುದು?
KT1 petitioner ಬಂದಿಲ್ಲ. I apply for the petitioner, my lord. Matter may be taken up at 2:30, my lord.
ಆಯ್ತು, ಪಾಸ್ ಓವರ್ ಅಲ್ಲಿ ಕಾಲ್ ಇಟ್ಟು.
Very well.
Submission, my lord. This 2 serial number 22. It's a section 92 matter, my lord. I'd moved the matter for urgent interim relief.
ಯಾವುದು ಮೇಡಮ್? 90?
This 2 serial number 22.
22.
In that, the office objection is with the council submission, my lord. It may be
ಅರ್ಜೆಂಟ್ ಇದೆ.
there's urgency.
What's the
in the
urgency?
matter. My lord, it's a section 92 petition. I had an interim order operating in my favor. The order is modified to almost to vacate it on the grounds the court doesn't have the time to hear the matter. It's
But
4:20.
KVT ಇದ್ದಾರೆ, they should
My
come.
lord, in fact, they were present in the morning. I told them
Get
I will be
them.
mentioning it
We'll
at
see.
1:30.
Get them, we'll take it.
Lordship, list 2, serial number 20, covered by judgment.
ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಕಂಪ್ಲೈ ಮಾಡಿ ಸರ್.
ಅದು-
ಯಾವ್ದು? ನಾಡಪ್ರಭುದ? ಅಲ್ಲ
KD
ಯಾವ್ದು
Act,
ಬೇರೆ?
29-2.
I filed wakalat, my lord. Wakalat
ಈಗ ಹಾಕಿದ್ದಾರೆ ಬರ್ಲಿ ಎಸ್
My lord, my lord, the-
91 1 minute madam 1 minute 1 minute. Tahir was here. This is what he told, that you met him and told him. It's the learned, what's your name? So and so undertakes to enter appearance for to all the respondents, to all the respondent registry to delete the name of S.A. Kadri and print the name of so and so as appearing for the respondents. Yavattu date ಕೊಟ್ಟಿದ್ದೀನಿ. Second, yes. Second, by then you want to do it.
That's list number 2, serial number 13. That's the officers right, office objection regarding maintainability. That's the
CRP ಬರಲ್ಲ,
CRP is
JMCPC.
maintainable. My lord, so what happened is unconditional leave is granted by the trial court in a summary suit. Now it is converted. Now it is converted into a regular suit. The scope of the suit itself is, my lord's, changed.
ಇದು 13, keeping open the objections square maintainability, list the matter on Friday.
Serial number 15 minutes. Serial number 15 minutes. The matter is posted for on maintainability. My lord, CRP is maintainable minutes.
Same Friday, yes.
My lord, 30 my lord, secondly. Each time.
30.
Yes.
ಏನದು?
That's against the maintainability of the suit application was filed. That was rejected. It's covered by decision because an association, apartment, one of the association, which under Societies Act, cannot maintain.
Maintainability ಹೇಳಿ ಸರ್, ಆಮೇಲೆ JMCPC ನ CRP ನ
Maintainability ಇಲ್ಲ. There's no maintainability.
serial number 13 30 comply with the office objections. Yes.
Each time.
I have already granted.
My lord, serial number 77. Second June ಇದೆ, 4th June ಗೆ.
2nd June ಹಾಕಿದ್ದೀನ?
4th June.
2nd June ಅಲ್ಲ, July.
July.
4th July ಹಾಕಿದ್ದು, 2nd. tomorrow, day after tomorrow ಆಗ್ಬೋದಾ? ಆಯ್ತು ಸರ್. ಏನ್ ತಗೊಂತೀರ? ಸರ್, $330, I will take it. Jute pe jute ಬೇಡ. We'll take it, yes. 330ಗೆ just, sorry, this court of, remind me, 330. We'll take it at 330.
This continue 94.
ಬಸವರ್ ಮಾಡಿ ಇಷ್ಟ.
Orders at 2:30 PM 95.
ಇದೆಲ್ಲ ನಾಡಪ್ರಭುದಂತಲ್ಲ? ಹಾ ಹಾ. ಎಸ್ ಮುರುಗೇಶ್, 2015. ಎಲ್ಲದಕ್ಕೂ ಡೇಟ್ ಬೇಕಾ? ಯಾವ ನೆಕ್ಸ್ಟ್ ಟ್ಯೂಸ್ಡೇ ಹಾಕ್ಲಾ? ವಿಲ್ ಟೇಕ್ ಇಟ್ ಆನ್ 17th. 95 list on 17th at the request of the parties. 24th, sorry, 24th. ಯಾವ್ದ್ರಲ್ಲಿ? 94 ಕವರ್ಡ್? ಮತ್ತು ಅವ್ರು ಯಾರು ಅವ್ರಿಲ್ಲ? ಆಯ್ತು ಸರಿ, ವಿಲ್ ಕ್ಲೋಸ್ ಇಟ್. ಅದು ಯಾವುದೋ ಒಂದು ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿದ್ದೇನಲ್ಲ, ಕೊಡಿ ಅದು. ಕೊಡಿ ಮೇಡಮ್, ಒಳ್ಳೆ ಮೇಡಮ್. ಅದು ಒಂದು ಕವರ್ಡ್ ಅಂತ ಆರ್ಡರ್ ಮಾಡಿದ್ದೀನಿ ಆಲ್ರೆಡಿ. ಅದನ್ನು ಸೇಮ್ ಆರ್ಡರ್ ಮಾಡಿಬಿಡಿ, ನಂಬರ್ ಕೊಡ್ತಾರೆ, ರೇಟ್ ಪೆಟಿಷನ್. ಇದೆ ಮೇಡಮ್. ಅಲ್ಲ, ನಾನೊಂದು ಮಾಡಿದ್ದೀನಲ್ಲ, ಇದು ಫಾಲೋ ಮಾಡಿ. ಯಾವುದದು? ಈ ಆರ್ಡರ್ ಇಟ್ಕೊಳ್ಳಿ, ನಂಬರ್ ಕೊಡ್ತಾರೆ, ಈ ಆರ್ಡರ್ ಪ್ರಕಾರ ಇದೆಲ್ಲ ಮಾಡ್ಕೊಳ್ಳಿ. ನಿಮಗೆ ಗೊತ್ತಿರೋ ಹೆಸರು ಹೇಳ್ಬೇಡಿ, ರಿಟ್ ಪಿಟಿಷನ್ ನಂಬರ್ ಹೇಳಿ. ಎಸ್. ಹಾ, ಡಿಸ್ಪೋಸ್ 94 ಡಿಸ್ಪೋಸ್
96.
ಕವರ್ಡಾ? Covered, you want division bench. Difficulty is that you have to argue the matter. ಆಚೆ ಈಚೆ ಶಿಫ್ಟ್ ಮಾಡಿ ಎಷ್ಟು ವರ್ಷ ಆಯ್ತು? ಅವಾಗಿಂದ ಆಚೆ ಈಚೆ ಸಿಕ್ಕೇ ಇಲ್ವಾ? ಆಲ್ ರೈಟ್, ಒನ್ ಡೇಟ್ ನೆಕ್ಸ್ಟ್ 24th. 97 ಕವರ್ಡ್. ಇದು ಎಲ್ಲ ನಾಡಪ್ರಭುಗಳಿದೆ. ಎಸ್, ವಾಟ್ ಎವರ್ ಇಟ್ ಈಸ್, ವಾಟ್ ಡೈರೆಕ್ಷನ್ಸ್ ಡಿವಿಷನ್ ಬೆಂಚ್ ಹ್ಯಾಸ್ ಗಿವನ್, ಯುವರ್ ವಿಲ್ ಬಿ ಸೇಮ್ ಡೈರೆಕ್ಷನ್ಸ್ ವಿಲ್ ಬಿ ಗಿವನ್. ಅದು ಎಲ್ಲ ಕವರ್ ಆಗಿದೆ ಡೈರೆಕ್ಷನ್ಸ್ ಅಲ್ಲಿ. ಅಕಾರ್ಡಿಂಗ್ ಟು ದ ಡೈರೆಕ್ಷನ್ಸ್ ನಿಮ್ಗೊಂದು ಡೇಟಾ. ಅವ್ನು 4 ಮ್ಯಾಟ್ರ್ ಅದಾವು, ಬಟ್ ಅದು ಯಾವಾಗ ಮುಗಿಸ್ತೀರಿ? ಎಲ್ಲ ಮುಂದಿನ ವಾರ, ಮಂಗಳವಾರ. ಹಾ, ಅವ್ರಿಗೊಂದು ವೆಯ್ಟ್, ಅಲ್ಲಿಗೆ ಬಂದೇ ಇಲ್ವಲ್ಲ ನಾ ಇನ್ನು. ಎಸ್, ಅವ್ರಿಗೆ ಆರ್ಡರ್ ಕಾಪಿ ಕೊಟ್ಬಿಡಿ, ಅವ್ರಿಗೆ ಆ ನಂಬರ್ ಕೊಟ್ಟಿರಿ ಅಷ್ಟೇ. ಎಸ್, 98.
98.
ಇದು ಕವರ್ಡ್ ಅಲ್ವಾ? ಎಲ್ಲ ಕವರ್ಡೆ. ಮತ್ತೆ ಯಾಕೆ ಟೈಮ್ ಬೇಕು? ಸುಮ್ಮನೆ 16th 15th ಎಲ್ಲ ಪೆಂಡಿಂಗ್ ಶೋಸ್ ಎಸ್ ಪೆಂಡೆನ್ಸಿ 10 years ಏನು ಲಿಸ್ಟ್ ಇಟ್ ಅಲಾಂಗ್ ಬಿತ್ತು ಇಲ್ಲ. Tuesday finally I am no more time is granted in that. Yes. No sir, ಬರೋ Tuesday. Yes.
99.
ಇದು ಕವರ್ಡಾ? ನೀವು ನೋಡಿಲ್ವಾ? ಆಯ್ತು ಸರಿ, ಟ್ಯೂಸ್ಡೇ ಎಲ್ಲ ಹಾಕ್ಬಿಡಿ.
100.
ಏನಕ್ಕೆ? ಅದೆಲ್ಲ it's already covered. What is it? Finally, list next Tuesday. It is made clear no further adjournment will be granted in the matter. ಎಲ್ಲ adjournment ಅಲ್ಲಿ ಅದೇ ಹಾಕಿ ಮೇಡಮ್. Yes. 101. We'll close it. Division bench ಏನು ನೋಡಿಲ್ವಾ ಜಡ್ಜ್ಮೆಂಟ್ ನೀವು ಡಿವಿಷನ್ ಬೆಂಚ್ದು? You think I'll hear the submissions all over again? Tuesday, yes.
102.
Finally. ಯಾರು ಇಲ್ವಲ್ಲ? ಬೇಕಾದ್ರೆ ಮೂವ್ ಮಾಡ್ಲಿ ಬಿಡಿ, ಕವರ್ಡ್ ಅಂತ ಕ್ಲೋಸ್ ಮಾಡಿ. Yes.
103.
You want time? Demised when, madam? Finally, next week, will not grant time, otherwise we're going to dismiss it. Yes.
104.
ಯಾಕೆ ಕವರ್ಡ್ ಅಲ್ವಾ? ಏನು 4-5 ವರ್ಷ ಆದ್ರೂ ನೋಡೇ ಇಲ್ವ ಏನು? Yes. 24th, finally. No more time I am granting. Yes.
105.
Statement of objections ಹಾಕ್ಬೇಕಾ? ಹಾಕ್ಲಿ ಬಿಡಿ. ಏನ್ ಬೇಡ. ಎಸ್, ಏನಾರು ಇದ್ರೆ ಮೂವ್ ಮಾಡಿ. ಸೇಮ್ ಕವರ್ಡ್ ಕ್ಲೋಸ್. ಅದು ಕವರ್ಡ್ ಮಾಡಿದ್ದಾರೆ. ಅದು ದಟ್ ಆಲ್ಸೋ ಇಸ್ ಕನ್ಸಿಡರ್ಡ್ ಬೈ ಡಿವಿಷನ್ ಬೆಂಚ್. ಆಯ್ತು, ಟ್ಯೂಸ್ಡೇ 24th ಫೈನಲಿ ನೋ ಮೋರ್ ಟೈಮ್ ಆನ್ ದಟ್ ಡೇ ಅಂಡ್ ನೋ ಸಬ್ಮಿಷನ್ಸ್. ನೋಡ್ಕೊಂಬಂದು ಕವರ್ಡ್ ಇಲ್ಲ ಅಂದ್ರೆ ಮಾತ್ರ. ಮತ್ತೆ ಡೋಂಟ್ ಆಸ್ಕ್ ಮಿ ಟು ಆಲ್ ಓವರ್ ಹಿಯರ್ ಅಗೇನ್. ಎಸ್, ನೆಕ್ಸ್ಟ್.
106.
ಜುಲ್ಫಿಕರ್ ಕವರ್ಡ್ ಅನ್ನು ಕ್ಲೋಸ್ ಮಾಡಿ, ಬೇಕಾದ್ರೆ ಮೂವ್ ಮಾಡಿ. ಎಸ್, ನೆಕ್ಸ್ಟ್.
107.
Yes. Then we'll post it on 24th.
108.
24th.
109.
109. ಶಿವರಾಮ್ ಕಾರಂತ ಇದು. ಎಸ್ ಮೇಡಮ್, ಶಿವರಾಮ್ ಕಾರಂತ್. 24th ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿ. ಲಿಸ್ಟ್ ಆನ್ 24th. ಶಿವರಾಮ್ ಕಾರಂತ್ ಲಿಸ್ಟ್ ಆನ್ 24th ಬೇಡ, ಲಿಸ್ಟ್ ಆನ್ 1st July. ಎಸ್.
110.
ಒಂದು ವಾರ 24th. ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ? ಎಂಟ್ರಿ ಮಾಡಿ ಮೇಡಮ್, ಅಲ್ಲಿ ಮೇಡಮ್ ಎಂಟ್ರಿ ಮಾಡಿ ಎಲ್ಲಿದೆ ಕಂಟಿನ್ಯೂ ಮಾಡಿ. ಆಯ್ತು, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಕ್ಲೋಸ್ ಮಾಡೋಣ. ಎಸ್.
111.
ಎಸ್ ಸರ್. Argued, not covered. After notification. After notification. Gone. No right to question acquisition. No. List on 26th. Next time no time. Yes.
112.
ಇದೇನು ಆಯ್ತು 26th. Yes.
Further hearing. 113.
Huh. You want to sit down? Sit down. Suit for specific performance. Plaintiff yaru?
Petitioners
You
are
are the petitioner.
Petitioners are the plaintiffs.
Based on the judicial agreement of sale, they are taking a contention that agreement of sale is going to be incurred for a sum of 18 lakhs. According to the terms and conditions of the agreement, on the date of agreement of sale, 50 lakhs by way of cash has been paid in favor of the petitioner, and 30 lakhs has been paid on the date of sale. Thereafter, on operation, when they are registered to enforce their contract, they issue a legal notice. Thereafter, suit can be filed. After issue a legal notice, order sheet for that, page 49, page 11.
Come to 51.
Second, the first time was, ವಾದಿಪರ ವಕೀಲರಾದ BSR ಅವರು ಹಾಜರಿದ್ದಾರೆ. ಪ್ರತಿವಾದಿ ಸಂಖ್ಯೆ 1 ರಿಂದ 6 ಅವರು ಹಾಜರಿದ್ದಾರೆ. ಶ್ರೀಮತಿ CS ವಕೀಲರು ಪ್ರತಿವಾದಿಗಳ ಪರ ಹಾಜರಿದ್ದಾರೆ.
Correct.
ಉಭಯದರು ದಾವೆಯನ್ನು ರಾಜಿ ಸಂಧಾನ ಮೂಲಕ ತೀರ್ಮಾನ ಮಾಡಿದ್ದಾರೆ. CPC ಕ್ರಮಾದೇಶ 23/3 ಪ್ರಕಾರ ಸದರಿ ರಾಜಿ ಪತ್ರಕ್ಕೆ ದಾವೆ ಸಹಿ ಮಾಡಿದ್ದಾರೆ. ಉಭಯ ಪಕ್ಷಗಾರರು ತಮ್ಮ ವಿಷಯ ದಾಖಲೆಯನ್ನು ಹಾಕಿಕೊಂಡಿದ್ದಾರೆ. ರಾಜಿ ಪತ್ರದ ಎಲ್ಲಾ ವಿಷಯಗಳನ್ನು ಉಭಯ ಪಕ್ಷಗಾರರು ಓದಿ ವಿವರಿಸುತ್ತಾರೆ. ಉಭಯ ಪಕ್ಷಗಾರರು ರಾಜಿ ಪತ್ರದ ಎಲ್ಲಾ ಸಂಗತಿಗಳನ್ನು ಒಪ್ಪಿರುತ್ತಾರೆ. ವಾದಿಯು ರಾಜಿ ಪತ್ರದ ತಿಳಿಸುವ ಮೊತ್ತವನ್ನು ಈಗಾಗಲೇ ವಾದಿಯಿಂದ ಪಡೆದುಕೊಂಡಿರುವುದಾಗಿ ಪ್ರತಿವಾದಿಗಳು ತಿಳಿಸಿದ್ದಾರೆ. ನ್ಯಾಯಾಲಯದ ಸಮಕ್ಷಮ ಹಣಕಾಸಿನ ಯಾವುದೇ ವ್ಯವಹಾರ ನಡೆಯುವುದಿಲ್ಲ.
ಆಯ್ತು.
ಕಾಲ ಸೊತ್ತಿನ ಸಂಖ್ಯೆಯು ಸಾಲಿನ ಪಹಣಿ ಪತ್ರಿಕೆ ಪ್ರಕಾರ ಒಂದೇ ಪತ್ರದಲ್ಲಿ ಹೆಸರಿದೆ. ಉಭಯ ಪಕ್ಷಗಾರರು ಸ್ವಇಚ್ಛೆಯಿಂದ ರಾಜಿ ಸಂಧಾನ ಮಾಡಿಕೊಳ್ಳಲಾಗಿ ಸದರಿ ರಾಜಿ ಪತ್ರವು ಕಾನೂನುಬದ್ಧವಾಗಿದೆ. ರಾಜಿ ಪತ್ರವು ಯಾವುದೇ ಅಡೆತಡೆ ಇರುವುದಿಲ್ಲ. ರಾಜಿ ಪತ್ರವು ಪುರಸ್ಕರಿಸಲು ಯೋಗ್ಯವಾಗಿದೆ. ಅಂತಿಮ ಆದೇಶಕ್ಕಾಗಿ ಪ್ರಕರಣವನ್ನು ಜನತಾ ನ್ಯಾಯಾಲಯಕ್ಕೆ ವರ್ಗಾಯಿಸಲಾಗಿದೆ.
ಲೋಕ ಅದಾಲತ್ ಕಳಿಸಿ.
ನೆಕ್ಸ್ಟ್ ಡೇ ದಾವೆಯನ್ನು ಅಂತಿಮ ಆದೇಶಕ್ಕಾಗಿ ಜನತಾ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಪರಿಗಣಿಸಲಾಯಿತು. ಉಭಯ ಪಕ್ಷಗಾರರು ಈಗಾಗಲೇ ರಾಜಿ ಸಂಧಾನ ಮಾಡಿಕೊಟ್ಟು ರಾಜಿಯನ್ನು ನ್ಯಾಯಾಲಯಕ್ಕೆ ಸಲ್ಲಿಸುತ್ತಾರೆ. ಮಾನ್ಯ ನ್ಯಾಯಾಲಯವು ಅಗತ್ಯ ವಿಚಾರಣೆ ನಡೆಸಿ ದಾವೆಯನ್ನು ಜನತಾ ನ್ಯಾಯಾಲಯಕ್ಕೆ ವರ್ಗಾಯಿಸಿದೆ. ಆದ್ದರಿಂದ ರಾಜ್ಯವನ್ನು ಪುರಸ್ಕರಿಸಿದೆ. On that day, what is not present?
Which day, sir?
The 17/12/2021.
It is already accepted that you have received the amount so and so. Yeah. No, that's all right. Yes.
I have furnished annexure H also. There are 3 agreements between the parties. Admittedly, the petitioners are also seekers to enter into an agreement of sale. Another matter I have questioned. Award for this property can be acquired by the railway.
ಆಮೇಲೆ ಪ್ರಾಬ್ಲಮ್ ಆಗಿರೋದು.
ಇಲ್ಲ, ಅಲ್ಲೇನಾಗಿದೆ 17/9/2019 the award final award can be passed. And petitioners also seekers to enter into an agreement of sale. And that too, on that day, railway authorities are the owner. Here, in case of
No, as on the date you entered into a compromise.
yes, ma'am.
What is the date of acquisition by railways?
Date of acquisition is 17/9/2019. Another question.
What is the date of this compromise?
Compromise petition is dated
18/12/21.
21.
Page 52.
Acquisition ಆಗೋಗಿತ್ತ ಅವಾಗ?
Acquisition ಆಗಿತ್ತು.
ಆಯ್ತಾ?
ಅಲ್ಲಿ even that has been specific. Please.
Page 47 may be kindly looked into. That is the compromise petition filed by the parties.
ಅದ್ರಲ್ಲಿ ಹೇಳಿದಾರೆ ರೈಲ್ವೆಗೆ ಆಗಿದೆ ಅಂತ ಹೇಳಿದೆ.
ಎಲ್ಲ ಹೇಳಿದೆ.
ವಾದಿಯಿಂದ ಪ್ರತಿವಾದಿಗಳು ಕ್ರಯದ ಬಾಕು ಉಳಿಕೆ ಮೊದಲು 30 ಲಕ್ಷ. ಈ ದಿನ ನಗದಾಗಿ
ಯಾಕೆ ಒಪ್ಕೊಂಡ್ರಿ? ಏನ್ ಡಿನಾಮಿನೇಷನ್ ನೋಡ್ಬೇಕಾಗಿತ್ತ? ಮತ್ತೆ ವಾಟ್ ಇಸ್ ದಿಸ್? ನೋ ಪ್ರಾಬ್ಲಮ್. ಆಯ್ತು. ಈಗ ನಿಮ್ಮ ಅಡ್ವೊಕೇಟು ನೀವು ಎಲ್ಲ ಸೈನ್ ಮಾಡಿದ್ದೀರಾ? ಲೀವ್ ಇಟ್ ಸರ್. ಈಗ parties have all signed. Advocates were present on that day. No, 1 minute. Parties have all signed. Advocates were present on that day. And the indication in the order is that you have received everything out of court. ಹೌದಾ ಇಲ್ವಾ ಹೇಳಿ? ಔಟ್ ಆಫ್ ಕೋರ್ಟ್. ಮತ್ತೆ ನಿಮಗೆ ಆಮೇಲೆ ಜಾಸ್ತಿ ಕಾಂಪನ್ಸೇಷನ್ ಬರ್ತಾ ಇದೆಯಾ? ಅದಕ್ಕೆ ಇದೆಲ್ಲ ಆಗಿರೋದು. ಫ್ರಾಡ್ ಆಗಿರೋದು ಅದಕ್ಕೆ. ಈ ಕಾಂಪನ್ಸೇಷನ್ ಯಾರಿಗೆ ಬಂದಿದೆ? ಯಾರಿಗಾಗಿದೆ?
ರೆಸ್ಪಾಂಡೆಂಟ್.
ಎಷ್ಟು ಬಂದಿದೆ ಅವಾರ್ಡ್ ಅಮೌಂಟ್?
ಎಕ್ಸ್ಪ್ಲೇನ್.
ಒಂದ್ ನಿಮಿಷ ಈಗ ರೀ, 3,35,00,000 ತಗೊಂಡಿದ್ದೀರಾ?
Not yet
ಕಾಂಪನ್ಸೇಷನ್ ಅಷ್ಟು ಬಂದಿದ್ಯಾ?
ಅಲ್ಲ, compensation has been awarded. After the award notice, this writ petition came to be
It's all
filed.
right, sir.
The timing of the writ petition has to
3,35,00,000 determine ಮಾಡಿದಾರಾ?
determined has been that we have agreed also.
Well,
We have in my statement of objections I have specifically mentioned that. And after that, ಅಲ್ಲ,
landowner should get something.
ಅಲ್ಲಲ್ಲ, ಅವ್ರಿಗೆ ಎಲ್ಲ ಕೇಳಿ even after that
80 ಲಕ್ಷ ಇಲ್ಲಿ 3.5 ಕೋಟಿಯಲ್ಲಿ 80 ಲಕ್ಷ ಇಲ್ಲಿ.
No, we after that we have approached the petitioner.
You want to settle the matter now?
It may be referred for mediation. Let the parties be
parties. We will answer merits.
Let the parties be settled.
Disparity. Landowner 80 ಲಕ್ಷ, ನೀವು ಯಾರು ಆಮೇಲೆ ಕಾಂಪ್ರಮೈಸ್ ಆಗಿ 3.5 ಕೋಟಿ 3.5
We are not disputing that aspect. And subsequently, when the award notice has been passed.
See, merits ಮೇಲೆ we will answer if you want. Not a problem. But
let
since
the parties be
huge disparity,
let the parties be
land ಕಳ್ಕೊಂಡವರು 80 ಲಕ್ಷ.
Please, we are not on that.
The petitioners ನಾನು ಮೀಡಿಯೇಷನ್ ಕಳ್ಸಲ್ಲ, ಸೆಟಲ್ಮೆಂಟ್ ನೀವು ಕುತ್ಕೊಂಡು ಮಾತಾಡಕ್ಕೆ ಹೇಳ್ತೀನಿ. No, I am not sending this. These petitions are preferred, calling in question the closure of the suit in OS 191 of 2021 on account of a compromise arrived at between the parties. The learned counsel appearing for the petitioner would vehemently contend that the compromise no doubt was entered into, but the matter was referred to Lok Adalat, and there no party had appeared nor the advocates had appeared. Therefore, there is fraud played. He would allege that there is fraud played. The learned counsel appearing for the respondent would dispute the same, contending that the counsels were present and all the parties to the list have signed on the compromise petition. The learned counsel for the petitioner would now contend that what is paid as amount in compromise to these land losers is 80 lakhs, and the person, the respondent herein has received compensation from railways at 3.5 crores. Therefore, there is huge disparity for the land loser who has got pittance, got a paltry sum from the hands of the respondent as amount of compromise. In that light, I deem it appropriate to direct the parties to sit and explore the possibilities of a settlement owing to the aforesaid disparity. List the matter on 27th. List the matter on 26th. Settlement, if any, shall be reported on the said date. Yes.
The interim order, my lord.
Interim order subsisting will continue till the next date of hearing. To enable settlement. ಇಲ್ಲದೆ ನೀವು ಮುಂದೆ ಬರೋದೇ ಇಲ್ಲ. 3.5 ಕೋಟಿ ಇದು ಅವತ್ತೇ ಹೇಳಿದ್ರೆ ಅವತ್ತೇ ಕಳಿಸ್ತಾ ಇದ್ದೆ. ರಮೇಶ್ ಹೇಳಲೇ ಇಲ್ಲ. 7 ಗಂಟೆ ಆಗಿತ್ತು.
ಅಲ್ಲ, ಅವತ್ತಲ್ಲ,
ರೀಚ್ ಆದ
ಲಾಸ್ಟ್ ಡೇಟ್ Arrogant ಆಗಿದೆ.
ಅದಕ್ಕೆ ನಾಲ್ಕು ಮುಕ್ಕಾಲ್ ಮೇಲೆ ಕೂತ್ಕೊಂಡ್ರಿದೆ ಪ್ರಾಬ್ಲಮ್. ಏನಿಲ್ಲ,
ಅಲ್ಲ,
if this
has been.
ಸಪ್ರೆಷನ್ ಇರ್ಲಿ ಏನಾರು ಇರ್ಲಿ,
We will explore
people
this.
have lost lands.
We'll
80
explore
ಲಕ್ಷ
this.
3.5 ಕೋಟಿ ಹೆಂಗ್
We'll
ತಗೊಂತೀರ?
explore this.
Yes.
Much obliged.
114.
I'm not going to adjourn the matter. Interim order will be vacated, petition will be dismissed. I have already indicated to Dhananjay. Don't play with the court. Yes. Whatever applications you have moved, I'm not going to entertain anything about the NCLT. Could you put a paper still? I'll challenge it if you want. You may file n number of applications, sir. The petitioner is before this court seeking the following prayer. The main petition arises out of the following prayer, page 42, quote Madi. The learned counsel appearing for the petitioner was heard at length and indicated that this court would not entertain the petition, which has in effect interfering with the orders passed by the National Company Law Tribunal. The apex court has time and where is the next judgment? The apex court has time and again indicated that this court, in exercise of its jurisdiction under Article 226 of the Constitution of India, should not entertain the petitions which would in effect stall the proceedings before the NCLT or any orders that of the NCLT. The apex court was upturning a judgment of this court which had and had passed certain orders. The apex court in the case of so-and-so Farooq Ali Khan has held as follows: 2024 SSC online. Subsequent. Finding no merit to entertain the petition in the light of the judgment of the apex court in the aforesaid judgment of the apex court in Farooq Ali Khan, the petition stands rejected. Interim order of any kind subsisting shall stand dissolved. No, sir. Maybe. Take it, sir. Take it to the apex court. No, sir. Yes. I have told Dhananjay on that day itself. Yes. No, sir. No, sir. Nothing. No, sir. I have heard him at length. I have heard him for 1 hour. Then that's not correct. No, sir. No, sir. Supreme Court again says that I am it's a comment on me that I am entertaining the petitions against NCLT time and again despite the order of the apex court. I told him also, Northeast is a very beautiful place, but you should know. Yes. No, I will not, sir. I will not. So look at your prayer, sir. What is your prayer? No, sir. Nothing. Yes. No, sir. The problem is being liberal, entertaining petitions have led to all this. I will not. ಅವ್ರೇನು ಹೇಳಿಲ್ಲ ಜಡ್ಜ್ಮೆಂಟ್ ನ. I am myself aware the apex court has commented on what I did. Where, sir? No problem. Look at your prayer. I am not going to. You take it to the apex court, get it clarified, and come back. Sir, proceed. One nimsha. NCLT pending idea? Alva. It is pending before the NCLT. Now, what you have challenged? What is under challenge, sir? Madam, sir. Yen challenge, madam. Yes.
Based on the very document the NCLT proceeded, the trial court said that it should not rely on any forum. The two civil courts are pending, PMLA proceedings are pending.
Challenge it, sir. challenge it, take an order from the apex court, yes. No, that's why I'm not doing, I'm only, no, sir, I'm not going. No. Learned counsel for the petitioner relies on plethora of judgments to buttress his submission that the petition at the hands of this court is maintainable, notwithstanding the judgment of the apex court in the case of Farooq Ali Khan, quoted supra. I decline to accept the submission, as the judgment in Farooq Ali Khan clearly holds that the insolvency and bankruptcy code is a complete code by itself, and as all remedies to it. Therefore, this court should not entertain the petitions which, in effect, as observed herein above, would stall the proceedings before the NCLT. Therefore, the references being made to the judgments the learned counsel is therefore, the judgments that the learned counsel for the petitioner is now wanting to project. No, sir. No. So and so. The learned counsel for the petitioner seeks to place reliance upon the madam. The learned counsel for the petitioner seeks to place reliance upon the 7 judgments in court madi. ಆಮೇಲೆ ನಾ ಈಗ ಏನು ಹೇಳಿದೆ ಸೆಕೆಂಡ್ ಟೈಮ್ ಅದು ಬರೀರಿ. ಎಸ್ ನೆಕ್ಸ್ಟ್. CBI. ಕೊಡಿ. I asked you to file a convenience compilation along with synopsis, written arguments, judgments ಎಲ್ಲ ಇದೆಯಾ? Reserved. Yes. ಹೇಳಿ ಸರ್. ಸ್ಟೋರಿ ಮೈಕ್ ಯೂಸ್ ಮಾಡಿ.
Page 268.
ಇದೆಯಾ? ಇಲ್ಲ. ಸ್ಫೂರ್ತಿ ಓದಿಲ್ವಾ?
ಇಲ್ಲ ಪೂರ್ತಿ ಓದಿದೆ. ಪೇಜ್ ನಂಬರ್ಸ್ ಇನ್ ದ
ಬೇರೆ ಯಾರು ಸ್ಫೂರ್ತಿ ಬೇಕಾ ಆರ್ಗ್ಯೂ ಮಾಡಕ್ಕೆ?
The page numbers are different, my lord. In this 260 is the page numbers, my lord. The consolidated they have given is something else as 775 statement of Guruva, my lord. He says, he clearly states that at about ಇವರುಗಳು ನೋಡಿದ ತಕ್ಷಣ page number 260. 2 paper books are given. I will just tell him, kindly pass over, my lord. Because that page number here in what I have referred is more, that is at 760.
Weekend ಏನು ಮಾಡಿದ್ರಿ?
My lord, I have read this, my lord. But there are around two paper books and one entire consolidated petition. There are
ಒಂದು convenience compilation ಓದ್ಕೊಂಬನಿ ಅಂತಾನೆ ಕೊಟ್ಟರದವರು.
That was served on Friday, my lord.
And they hold process at the end of the month, holding the body of this deceased. But I want the police forward very categorically. As of that day, he was not there in the farm, but he was working elsewhere. That is there.
Yes, ma'am. For in that regard, my lord, page number 34.
ನೀವು ಅವ್ರು ಒಂದೊಂದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಇನ್ ದಟ್ ರಿಗಾರ್ಡ್ ಅಂತ ಹೋಗ್ತಿದ್ರೆ ಆಗಲ್ಲ, ಓದ್ಕೊಂಡ್ ಬನ್ನಿ. I'll take it at 4:30.
4:30. Yes. Page numbers has to be.
Passed over matters. 15.
Yes, sir. Yes, sir. Correct. Sir. Correct. Sir. Hmm. Hmm. When were they sold, sir? 73. All right. Sir. Hmm. 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 Kodi, sir. Yes, sir. Kodi, sir. Very liberal, sir. Yes, sir. Hmm. When did you file your written statements? When did you file? Somebody andre? Oh, because change of counsel. When did the first written statement come about? Date ಕೇಳ್ತಾ ಇದ್ದೀನಿ ಅಷ್ಟೇ. 17/6/2013. ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದು ಯಾವಾಗ ಸರ್? ಅಮೆಂಡ್ಮೆಂಟ್ 617. 12 ವರ್ಷ ಆದ್ಮೇಲೆ. Where do I issues frame ಆಗಿದೆ ಯಾವಾಗ? (2018 to 24). Yes. 2008 to 2024. 18 sir. 8 ಅಲ್ಲ. You have filed a written statement not in 13, in 2003. Oh, ಮತ್ತೆ ಅದೊಂದ್ಸರಿ 617 ಅಮೆಂಡ್ ಆಯ್ತು. Oh, the second amendment. No, sir. This is not applicable. Supreme Court judgments. ಅದಾದ್ಮೇಲೆ. ಕೊಡಿ ಸರ್. ಕೊಡಿ ಸರ್. Hmm. Hmm. There are 5 judgments after this. Problem is 25 ವರ್ಷ ಆಗಿದೆ suit, 2001 suit. 2000 ಸಿಲ್ವರ್ ಜೂಬ್ಲಿ ಮತ್ತೆ ಎಸ್ ಅದಕ್ಕೆ ಸಿಲ್ವರ್ ಲೈನಿಂಗ್ ಕೊಡ್ಬೇಕಾ ಈಗ ಎಂಟರ್ಟೈನ್ ಮಾಡಿ. ಎಸ್ ಸರ್.
I was for the respondent. I was in the other court.
Will allow the petition.
Lords, I'll make a submission, my lords. Suit of the year 2001, my lords. In 2013, they.
ಹೇಳಿದ್ದೆಲ್ಲ ರಿಪ್ಲೈ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. You saw this judgment, please see. He is relying on several judgments. Notice ಆಗಿದೆಯಾ ಇದು? ಕೊಡಿ ಎರಡು ಅಪ್ಲಿಕಬಲ್ ಅಲ್ಲ, ವಿಲ್ ಡಿಸ್ಮಿಸ್ ಇಟ್. ಏನು ಅಂತ ಇದ್ದೀರಿ? Urge it, sir, at time of arguments. ಈಗ ಅಮೆಂಡ್ಮೆಂಟ್ ಅದಕ್ಕೊಂದು ರೀಫ್ರೇಮಿಂಗ್ ಆಫ್ ಇಶ್ಯೂಸ್, ಆರ್ಡರ್ 14 ರೂಲ್ 5 the application. Yes. Yes, yes, we will allow the petition. Land counsel for the petitioner, after arguing the matter at length, would seek leave of this court to withdraw the petition and urge all these contentions at the appropriate time before the concerned court. Liberty so sought is granted. The concerned court shall, it's needless to observe that the concerned court would consider all the submissions urged by the petitioner at the time, at the appropriate stage. Yes. With the aforesaid observations, petition stands disposed.
18.
Who are the impleading applicants?
18. A request for a password, my lords.
You are in this case also?
Yes, ma'am.
We'll see, yes. Heard the learned counsel appearing for the petitioner. The petitioners are before this court calling in question an order. ಅವರು ಹೇಳ್ತಾರೆ ನೆಸರಿ ಅಲ್ಲ, ಪ್ರಾಪರ್ ಪಾರ್ಟೀಸ್. A lot of difference between the two. Correct? Proper and necessary, both. Short password. ಹಿಂಗೆ ಯಾಕೆ ತೋರಿಸ್ತಾ ಇದ್ದೀರಾ ಅದನ್ನ? Short password, sir. If you show like this, yes, password.
80.
80. Yes, sir. Mic on agillo.
I'm handing over a list of dates because of the checkered facts.
Yes, sir.
Lord, one G.A.G. Acharya was the owner of the property, and Srimati Acharya, they had 2 daughters. Lord, in 1976, G.A.G. Acharya died, leaving behind his wife and 2 daughters. At that point of time, or just about that, the respondent, present respondent and his father, they entered the premises as tenants. Lord, on 27/9/93, respondent and his father, with a malafide intention to knock off the property belonging to the petitioners, created a document, namely an agreement, as if H.G. Acharya had executed in favor of Dr. Radhakrishna. 27/9/93.
Yes.
S.G. Acharya, Bharati and Gayatri, these are mother and two daughters. They filed a suit for partition and separate possession among themselves in OS 311 of 93. My lord, in this suit, my lord, the suit was filed by O. Shambat, the advocate representing the petitioner. My lord, in 94, my lord, in order to take over the property, respondent filed a suit for specific performance against S.G. Acharya in OS 258 of 94. My lord, this suit is filed by O. Shambat, who was representing the petitioners in the suit filed by the petitioners for partition. The same advocate, my lord, one Mr. O. Shambat, my lord, had been, my lord, these are, my lord, the widow and two daughters at that point of time, daughters were, my lord, very young. The old lady, my lord, that situation was taken advantage of, my lord, that suit, my lord, thereafter in 1995. May I read that, my lord?
Really?
Radhakrishna filed another suit in OS 755 of 95 against S.G. Acharya Bharati, claiming that Gayatri had executed the agreement in his favor on 28/4/1994 and thus claimed that he is entitled to receive the usufructs, that is rent received from Bharat Petroleum.
Yes.
Property had been leased in favor of Bharat Petroleum. In this case, Radhakrishna contends that Bharati has also executed an agreement of sale. However, the said agreement is not produced. Further, he contended that Bharati executed a sale deed on 19/5/1994. Curiously, my lord, in this proceeding, my lord, he deletes the name of Bharati. Way back in 95. Well, these are pages I have.
No problems. Yes, you carry on.
The said suit was contested strongly by S.G. Acharya by filing a written statement. In this written statement, sale deed is set up by respondent was disputed. It was specifically contended that Bharati's sale deed dated 19/5/94 is concocted. After filing of the written statement, Radhakrishna deletes Bharati from the array of parties. Now the next. OS 810/96, OS 311 of 93, filed for partition amongst the family members came to be decree. My lord, this here the same advocate who had been, my lord, filing applications, withdrawing, same advocate was acting. O. Shambat appeared for plaintiff in OS 311. Since OS 311 of 93 was decreed in favor of plaintiff, Srimati S.G. Acharya and Bharati preliminary decree was drawn. Final decree proceedings came to be initiated in FTP 1 of 97. In this suit also, Radhakrishna was represented through O. Shambat. OS 755 of 95, filed by respondent against S.G. Acharya, seeking mean profits, came to be dismissed, holding that he has not proved his right in the property. As stated earlier, Bharati name had been deleted here. Court took the note of the factum of deletion of Bharati. It is submitted that respondent deleted the name of Bharati because respondent should prove the alleged sale deed. In order to avoid the same, he deleted the name of Bharati. In this suit also, O. Shambat appears. Next, 11/4/2001. In FTP 1 of 97, final decree came to be passed after appointing a commissioner by order dated 11/4/2001. In this FTP, though allegedly Bharati had signed the petition, she was not made a party. And petition came to be filed in the name of S.G. Acharya against Gayatri, and Bharati was represented by power of attorney holder by name Madhe Gowda, father of respondent. Hence, Gayatri objected for decree, preferred a regular first appeal. Bharati breathed her last on 9/3/2002, and one of the petitioners herein, namely Gautam, came on record as LR of Bharati.
Yes.
9/8/2002. OS 258 of 94 filed by Radhakrishna, seeking specific performance, came to be dismissed. This suit had been filed by again O. Shambat. He was acting in two capacities. One, projecting as if he is protecting the interest of Bharti and the family members. Other side, without this thing, he went on, my lord, filing the petitions after petitions, one suit for specific performance. That suit came to be dismissed. In RFA 526 of 2001, Dr. Radhakrishna came on record as respondent on his own and claimed that there is a sale deed in his favor by Bharti. Please note here,
Yes.
he claimed an agreement to sell executed by my mother S.G. Acharya, and he filed a suit for specific performance. That suit came to be dismissed. I have given the page numbers and all in the paper book.
Yes.
This appeal was allowed and matter was remitted to the trial court, restoring FDP for further action. Here it was observed that if Radhakrishna has purchased any share of Bharti, it was open for him to seek impleadment. Now, for the first time, in the entire suit, he was observing behind. He does not come. Wherever, my lord, he files a suit using my advocate, my lord, as a this thing. My lord, I'm not stating anything because it's a little this thing. He deletes the name of Bharti. The advocate deletes the name of Bharti. So far as specific performance is concerned against S.G. Acharya, that suit came to be dismissed. Though a final decree proceeding was already pending consideration, Radhakrishna files a fresh final decree proceeding. The original 1 of 90 which has been remanded was pending consideration. He files a parallel proceeding in FDP. My lord, Sharda, Santosh and children of Bharti filed an objection in FDP 90. Trial court dismissed the said application. Challenging the FDP filed by Radhakrishna in High Court set aside the said order and only permitted Radhakrishna to make necessary application for revival of FDP 1 of 97. So Radhakrishna was sent back to say that you revive the earlier FDP. In the final decree proceeding, Radhakrishna filed an application under Order 22 Rule 12 seeking decree for possession and mean profits directly. The trial court erroneously allowed this application made by Radhakrishna and held that Radhakrishna has locus and maintained an application. Challenging the said order, Sharda and Santosh preferred a writ petition in writ petition 7063 of 2022. My lord, this honorable court held that if Radhakrishna has really purchased the property, he has to prove the same. Now, in this impugned order, the High Court, my lord, erroneously permit Radhakrishna to proceed. In this proceeding, in the FDP.
High Court has erroneously permitted.
No, the trial court.
Trial court.
Has erroneously allowed the application and held that Radhakrishna's sale deed is proved. Against that, I am before your lordship. I am challenging the finding recorded in relation to that on 3 grounds. One is the sale deed is a concocted sale deed. My lord, he claims that sale deed, my lord, came into picture somewhere in 1994. He does not take any action, does not come forward, and he claims one agreement of sale executed by my lord S.G. Acharya, files a suit for specific performance. That suit was dismissed. Now, here,
everything is captured from 161, page 161 to 164.
Yes, my lord.
165. ನೀವೇನು ಹೇಳಿದ್ರಿ ಎಲ್ಲ ಇದೆ ಅಲ್ಲಿ.
Yes.
And court permitted Radhakrishna to get himself.
Correct. If he has to prove, if he proves the sale deed.
Correct.
Now, in that, evidence was recorded.
Now
in this proceeding,
you are against the maintainability of the application filed by Radhakrishna. Correct?
Where a finding has been recorded now after the judgment of the High Court, the impugned order says that though there were several
Coordinate
orders,
bench itself permitted Radhakrishna to enter the proceedings in FDP 1 of 97. The coordinate bench has permitted Radhakrishna to
and he has to prove the sale deed.
Correct. All right. Now you questioned about the locus of Radhakrishna in entering into this FDP 1 of 97. The trial court holds it is maintainable. following the judgment of the coordinate bench,
No, no, no,
which
here
which held that he has to enter into that only.
No, now enter into it
Then
and recorded a finding that he has proved the sale deed.
that will always be. ಏನಾಗಿದೆ ವಾಪಸ್
That's what, now
ಕಳಿಸಿದಾರಾ?
the impugned order is at 206.
Correct.
Now there, the court holds that the evidence was recorded before ordering this. The evidence, my lord, is found at page.
Now, one issue, maintainability, you have no objection.
I have no objection, I'm just.
Fine. Now, the next is, he has, the court has said allotment of 1/3 share.
1/3 share.
Right
on
to claim 1/3 share allotment, so and so. Now, come back to page 164.
Yes. 164. 165.
165.
I have given my anxious consideration to the order under challenge. If the original plaintiff, namely Bharti Huelgod, has sold the share in favor of respondent number 1.
Even before that, you come to the RFA 526 of 2001 order, which is extracted at page 162.
Yes. Appeal allowed.
However, it is open to the petitioner. Who is the petitioner there?
Final decree proceeding to impede.
No, RFL, ಯಾರ್ petitioner? Your petitioner appellant ಬರ್ದಿಲ್ಲ.
Appellant to Sharda and Santosh.
Respondent Radhakrishna. However, it is open in final decree
Correct.
to implead S.G. Acharya as second so and so, as Radhakrishna has purchased the share of Srimati Bharati. It is open for him to seek impleadment. Correct? 1 minute. Now come to the present order.
At 165.
1/3, no, ಅದಲ್ಲ 1/3 share ಯಾರ್ದು ಕ್ಲೈಮ್ ಮಾಡಬಹುದು ಅಂತ ಬರ್ದಿರೋದು?
Bhartidu.
Sol.
No, the question.
RFL ಬರ್ದಿರೋ ಆರ್ಡರ್ ಬರ್ದಿದ್ದಾರೆ ಮತ್ತೆ ಅಷ್ಟೇ.
No. ಆ ಆರ್ಡರ್ ಬರೆಯಕ್ಕಿಂತ ಮುಂಚೆ ಆ ಸೇಲ್ ಡೀಡ್ ಎಲ್ಲೂ ಪ್ರೂವ್ ಆಗಿದೆ ಅಂತ ಹೇಳೇ ಇಲ್ಲ. See.
Now, straight away go to RFA order.
Yes, my lord. RFA order.
RFA order li, the appellate court, the RFA, the coordinate bench permitted.
Correct.
Permitted. Radha Krishna to come into the picture.
Correct.
Because he had purchased the property from Bharati.
He was claiming to have purchased the property. He has to prove the sale deed.
No, ಅದಕ್ಕೆ
That is why evidence was recorded here in this proceeding. Please see the evidence recorded in this proceeding starts from 167 onwards.
ಸರಿ, ಈಗ ಏನ್ ಪ್ರಾಬ್ಲಮ್ ಆಗಿ ಪ್ರೂವ್ ಮಾಡಿಲ್ವಾ?
Prove according to me. My lord, please see the evidence.
That's all, sir. Need not go beat around the bush. Prove ಮಾಡಿದಾರಾ ಇಲ್ವಾ?
My lord, it is proved.
How?
If I may kindly point out, sale deed was executed on 28/4/1994.
28/4/1994.
Immediately there.
1994. Who is the vendor who purchased
My
it?
lord, vendor is Srimati Bharti S. Kulgol
ಆಯ್ತು.
and purchaser is
Radha Krishna.
Please, my lord.
Radhakrishna.
Please.
Ah.
Along with my IA for vacating the interim order, my lord, I have produced the sale deed, which specifically indicates the circumstances in which Bharti had to sell the property.
All right.
She wanted to relocate.
All right.
As well as the schedule mentions the pendency of OS 311 of 1993.
All right.
And it specifically indicates 1/3 share. Further, my lord, along with my IA, I have produced the order sheet of OS 311 of 93, wherein I filed an IA for impleading into the suit. By virtue of this sale deed, I sought for impleading immediately thereafter, my lord. And a recent order is passed to indicate that second plaintiff has got 1/3 share in suit property since she has executed.
Second plaintiff was Bharti.
Bharti, my lord.
All right.
She was the second plaintiff.
Yes.
As against the first plaintiff, the suit stood dismissed because it was not contested, my lord. So their
So
allegation against that advocate
the contesting plaintiff was only Bharati.
only Bharti, my lord. And my impleading comes to be dismissed, indicating that the outcome of the suit would definitely be binding on me and I would step into the shoes of the plaintiff. This was way back in 1994. Subsequently, my lord, FDP proceedings are initiated, one of 97 immediately after the suit came to be decreed.
Correct.
Further, my lord, they make allegations that erroneously name was wrong as what that was also appreciated by the division bench of this honorable court in RFA, my lord, wherein the court holds that due to a typographical error, plaintiff number 1's name was mentioned. However, petition was signed by Bharti Hulgol. Hence, there's no ground of discrepancy.
That has become final.
That has become final, my lord. It also says they didn't object to this. Further, my lord, Bharti Hulgol initiates final decree proceedings. Subsequently, after that FDP is allowed, only in RFA they take up this defense that there is a sale deed is disputed. Sale deed is never challenged before any court. In fact, my lord, the suits which are dismissed, one suit was filed by me seeking for mean profits, wherein the court held that unless partition is ordered, you cannot seek for mean profits. On that ground, it was dismissed. It is not that it was held that sale deed is null and void. Further, my lord, Bharti has never disputed it. She died only in 2002, my lord.
Now, who the petitioner is Radha Krishna.
Radhakrishna is the person who has purchased the property.
From, no, petitioner is Acharya.
They are the children of Bharti.
All right.
Bharti passed away.
When did Bharti die?
9/3/2002.
9/3?
2002.
It is only after the death of Bharti, the petitioners were brought on record.
1 minute. Sale did 94, Allah?
Please.
Sale did 94.
So,
494.
Bharti never challenged the sale deed.
No, because
yes or no?
no, it was not challenged in the. I'll submit, my lord. I'll submit. There is a reason because the he files a suit claiming, my lord, share in the property, claiming share in the rent. In that, he makes Bharti a party. He deletes her from array of the parties. He deletes her name because at that point of time, Bharti was alive. Therefore, he should have proved the sale deed before the court. Nowhere, no evidence has been adduced in relation to proof of the sale deed except under the impugned judgment, where evidence has been recorded.
Now the children come up and say that whatever mother had executed is concocted.
No, mother had denied the execution of the sale deed in the written statement.
When did Bharati file a written statement where she had disputed the sale deed?
My lord, what?
Just show me that. If Bharati at any time in her lifetime disputed in any of the proceedings.
Please come to page 25.
Not your pleading. Bharati's statement anywhere.
Bharati, there was no occasion for Bharati to know about the sale deed. Please come to page 25, my lord. Page 20. First, please come to page 20, my lord.
No.
This is a suit filed by Radha Krishna.
Which is the first suit, sir?
First suit is OS 755 of 95 filed by Radha Krishna.
Correct. By who are the defendants there?
Defendants were S.G. Acharya alone. He was, Bharti was the defendant, but he deletes her name. Please see that, page 20. Bharti, Kumari Bharti. At that time, she was just then had aged 18. And she was unmarried. And he makes her a defendant and deletes. Therefore, when it was deleted, S.G. Acharya said...
When did she come back into the proceeding? Bharati never came back to any proceeding?
No. There was no... Therefore, they did not allow Bharati to contest the sale deed.
Now, who is the defendant there? Acharya.
Acharya. Acharya denied the execution of sale deed by Bharati. Please see page 25.
During Bharati's lifetime? Or
During Bharati's lifetime.
Where is that written statement?
Please come to page 25.
Suit is instituted by whom?
By Radha Krishna.
Yes. Where is the statement by Acharya?
Yes, my lord. Please come to page 26. After first 5 lines, I will read. Hence, it is incorrect to allege that defendant has 1/3 share in the suit property. In view of this, plaintiff is put to... It is submitted that registered sale deed dated 19/5/94 is null and void. We denied the sale deed itself, and after filing up this written statement, he deletes the name of Bharati.
Bharati was made a defendant.
This was the time when he should have allowed Bharati to contest during her lifetime. She dies in, my lord, 2000.
Correct, 2002.
Therefore, the children, my lord, who were kept away, Bharati who was kept away, got to know about this challenge to the sale deed to be made.
What happened to this?
That was dismissed.
Suit
was dismissed. But 2 suits were dismissed by Radha Krishna. One was, here he claims a sale deed. Other is he claims an agreement to sell from S.G. Acharya.
What is the suit for?
This is for mean profit based on the sale deed.
All right. Now, which is the other suit for?
That is for specific performance against S.G. Acharya. She claims, my lord, what happened was, he claims that S.G. Acharya has executed an agreement to sell. That judgment, the suit is dismissed.
Now, who is Gayatri? Is the daughter of Acharya.
Acharya.
So is Bharati. They are sisters.
Their sisters.
Now Gayatri approached, filed RFA against dismissal of which suit?
No, RFA was never
RFA
filed
526
dismissal
of
any suit.
2001.
It was an FDP. In the final decree proceeding, appeal was only, my lord, appeal dispute was only amongst three
Oh, the final decree.
sisters.
Yes.
This is the first time, my lord, this is almost like a first appeal before your lordship, for the reason that the alleged sale deed executed by, allegedly executed by Bharti has never been tested. Now, in this background, please come to the evidence recorded.
See, by
Now,
1 minute, by the time this division bench rendered this RFA,
yes,
Bharati was no more.
no more.
All right. So this court at page 151, division bench says, it sets aside FDP 1 of 97,
Correct.
permits SG Acharya, Srimati SG Acharya to implead in the proceedings because Bharati was no more.
No more.
All right. And Radhakrishnan has purchased the property from Bharati.
Bharati.
So it was open for him also to implead.
Implead and prove the sale deed. Till then, just by, my lord, I have the sale deed. My lord, I come and present it before court. Say that I have an interest. If you have an interest, go and prove it.
Now the court holds in this FDP proceedings that
Sale deed is
Radhakrishnan
proved.
sale deed is valid.
Yes. I'm agreed by this for three reasons, my lord. Please see the circumstances under which the sale deed has come about. One is agreement to sell. He claims H.G. Acharya in agreement to sell. That was not upheld. That was dismissed by Radhakrishna himself. One family, a tenant, and he claims that there were 4 agreements executed by Bharti. None of the agreement is produced. And the advocate appearing for Dr. Radhakrishna in OS 755, in another suit for specific performance, he is the advocate who was representing us in partition suit.
All right. Yes.
We would go to advocate's office, sign it and come back. That to a widow and 2 daughters. There is no son in the family. These are the persons who are there in possession as tenants.
Yes, you have filed
My lord,
vacating,
your lordship.
vacating stay application.
Yes, my lord.
My lord.
Yes. Tell me, madam.
My lord, if I may request your lordships to peruse annexure D, page 74.
Hmm.
At page 76, my lord. At page 74, it indicates the advocate's name. Both SG Acharya and Bharti Hulgol filed the suit for partition against Miss Gayatri, my lord.
Correct.
Further, my lord, at page 76, defendant appeared, filed a written statement. Plaintiff number 1 is not represented by any advocate. Her suit is dismissed without settling her claim. So the suit as against GAG Acharya is not contested by O Shambat. It comes to be dismissed. Further, my lords, OS 755 of 1995
Yes.
is initiated by Dr. Radhakrishna. That is at page 91. And it is contested by GAG Acharya.
Correct.
It is contested by the mother through another advocate, and his advocate is very much O Shambat. Now, my lords may kindly see, in this suit, my lord, one issue is framed with respect to the sale deed. However, it is not adjudicated. The court holds that it is not necessary for adjudication. Now, my lord, their contention that Bharti Hulgol was never aware of this sale deed is the prima facie cannot be justified, because, my lord, immediately after execution of the sale deed, I filed an impleading application in the suit for partition which was being contested. They are not denying that Bharti had initiated the suit for partition, my lord. That is an admitted fact. Now, my lord, in the suit for partition itself, I have put forth the sale deed back in 1994. Such being the case, my lord, if it was disputed, it should have been challenged. The sale deed ought to have been questioned. Now, her mother has questioned the sale deed. In this suit, he claims that in her written statement, mother has stated that the sale deed is null and void. However, that was of no consequence for adjudication of the instant suit. Hence, the court holds issue number 5 is of no consequence. I will not pass orders on it.
Yes, I'll consider.
Please, my lord. Further, my lord, your lordship may kindly appreciate. FDP 1 of 97, all along until her death, my lord, until the order in FDP 1 of 97 came to be challenged before this honorable court in RFA, there was no dispute raised at all. The suit for specific performance which was initiated an entirely different cause of action, my lord. That is an agreement to sell executed by the mother in favor of Dr. Radhakrishna or his father. That does not contain to Bharti's share or this property. The entire property, my lord, a portion of it has been alienated. Now in that, I sought for specific performance of the mother's share which came to be dismissed. Here, my lord, I am not on any agreement to sell. I am on a registered sale deed which has been acted by the parties, my lord. And it has been acted in 1994. This valid sale consideration which is paid and remitted is also indicated in the sale deed. And sale deed remains unchallenged, my lord, till date. Neither the mother nor the other daughter has challenged it.
Anything else, sir?
Please come to the deposition itself. 173.
173.
This is the deposition recorded. First.
Yaar the deposition is?
This is the deposition of Radhakrishna. Para 5 ಇಂದ ದಿನಾಂಕ 28/4/94ರಂದು ನಮ್ಮ ತಂದೆ ಕ್ರಯಪತ್ರವನ್ನು ಸೃಷ್ಟಿ ಮಾಡಿರುತ್ತಾರೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ನನ್ನ ಹೆಸರಿಗೆ ಕ್ರಯಪತ್ರ ಆದ ಮೇಲೆ ಭಾರತೀಯ ಭಾಗಾಂಶವನ್ನು ನಾನು ಕೊಡಬೇಕೆಂದು ಕೋರಿ ನಾನು ಸದರಿ ದಾವೆಯಲ್ಲಿ ಅರ್ಜಿಯನ್ನು ಅದಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಏನೂ ದಾಖಲೆಯನ್ನು ಹಾಜರುಪಡಿಸಿರುವುದಿಲ್ಲ. He had never filed any application. He had never given any document. ಭಾರತೀಯವರ ಭಾಗಾಂಶ ನನಗೆ ಕೊಡಬೇಕೆಂದು ಯಾವುದೇ ಅರ್ಜಿಯನ್ನು ಸಲ್ಲಿಸಿರುವುದಿಲ್ಲ. ನಾವು ನೆಕ್ಸ್ಟ್ ಮಿಲಾರ್ಡ್, ಈ ಅರ್ಜಿಯಲ್ಲಿ ಭಾರತೀಯವರ ಭಾಗಾಂಶವನ್ನು ನನಗೆ ಕೊಡಬೇಕೆಂದು ಕ್ರಯಪತ್ರಗಳ ಆಧಾರದ ಮೇಲೆ ಪ್ರಾರಂಭದಲ್ಲಿ ನಾನು ಅರ್ಜಿಯನ್ನು ಸಲ್ಲಿಸಿರುವುದಿಲ್ಲ. ಮಿಲಾರ್ಡ್, ಪೀಪಲ್ ವೇಟ್. We do not know. It's a family dispute. One agreement, my lord, he wanted to take over the entire property. The agreement, my lord, he alleges as against H.G. Acharya comes to be dismissed. Here there is a direct sale deed where it is preceded by 4 agreements to sell. Please see his own admission. There is he does not produce those agreements. Please see those depositions.
Page 172 to
174. 175. ನಮ್ಮ ತಂದೆ ದಿನಾಂಕ 5/4/21ರಂದು ತೀರಿಕೊಂಡಿರುತ್ತಾರೆ. ಪ್ಲೀಸ್ ಸಿ ದಿನಾಂಕ 3/5/93, 8/9/93, 27/9/93 ಮತ್ತು 28/9/93 4 ಕ್ರಯದ ಕರಾರು ಪತ್ರಗಳು ನನ್ನ ಸುಬರ್ತಿಯಲ್ಲಿ ಇರುತ್ತವೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಯಾರ್ದಿದ್ದು? ವಾಟ್ ಈಸ್ ದಟ್ ಅಗ್ರಿಮೆಂಟ್? ಕ್ರಯಪೂರ್ವಕ್ಕಿಂತ ಒಂದು ಕ್ರಯ ಕರಾರು ಪತ್ರವನ್ನು ನಾನು ಕೊಟ್ಟಿಲ್ಲ. Please, again 177. ದಾವಾ ಸ್ವತ್ತನ್ನು ಖರೀದಿಸುವ ಪೂರ್ವದಲ್ಲಿ ನಮ್ಮ ವಕೀಲರಿಂದ ಸ್ವತ್ತಿನ ಸ್ವಾಮ್ಯದ ಬಗ್ಗೆ ಅಭಿಪ್ರಾಯವನ್ನು ಪಡೆದಿದ್ದೆನು. ನಮ್ಮ ವಕೀಲರಾದ ಶಾಂಭಟ್ ರವರು ಸದರಿ ಅಭಿಪ್ರಾಯವನ್ನು ಕೊಟ್ಟಿದ್ದರು. ಶಾಂಭಟ್ is acting, my lord, against each other. My lord, this is the first appeal, like it requires to be heard is what I humbly pray. Because first time, the entire documents have been
45 minutes ಏನ್ ಮಾಡಿದ್ದು?
My lord, anyway, I leave it to you. Because the entire document, on the last occasion, this honorable court directed the trial court to pass on all the documents so that I could point out wherever, my lord, those things are there.
Entry ಮಾಡಿದ್ಯಾ?
Entry model.
My lord, it is merely the evidence.
Your lordships have directed the trial court to, my lord, the call for entire records.
ಬಂದಿದ್ಯಾ ಮೇಡಮ್?
Please come to page.
It's here already.
Please come to page 187. The father was the GPA of Bharti.
You file your synopsis and list of dates.
Please
and
come to 180.
authorities also will rehear it on 27th. Yes. Heard the learned senior counsel Chandrasekhar appearing for the petitioner and counsel Srimati Monica Patil for the hearing on 27th at 3:30. Yes.
Interim order will be.
Interim order will continue to the next.
The,
Ah.
the records could be pointed
Here.
out.
Records are here.
Okay.
Everything has come. That is why I said we'll take it
No,
on.
I just wanted to only clip those things which were relevant for your lordship, because your lordships are seeing from my paper book.
So let both of you want to do something.
So that these are the
What do you
original records, so that I may not be stating anything, because I have prepared based on the instructions that has been given to my, that's all.
Take it.
He'll inspect in the office and.
Further reading 3:30 PM, 121. 121.
Yes.
We have filed a note, my lord, for your lordships. Nodi.
Yes, you're ready? No adjournment. Yes.
In this matter, my lord. let
Oh,
me-
in this
let them
matter
come
ಅಂತ
in.
start ಮಾಡಂಗೇ ಇಲ್ಲ.
We will argue on one date may be given because
ಇದು one date ಕೊಡ್ತಾ ಇರೋದು.
we will.
No, sir, this should stop. You are appealing for the Union of India?
I am appealing for respondent number 3 in this.
The Jute Association. Wait.
They are appealing
Yes. You are ready?
Lord, ASG will come.
Get the ASG. Yes. Yes, sir.
Please, my lord. My lord, we have filed a convenience compilation in which, my lord, we have produced the act also, my lord, for my lord's consideration.
Put him in. Compilation. Convenience compilation.
Huh? You haven't filed? What is this? Wait, how many volumes are there? Shall we give them to the other side? What do all this? Last minute they'll say no.
Jute policy reports ada. Yeah. No, this is not given.
Oh, Kotilva. Sorry, my apologies.
It's not in the papers.
Oh, so sorry. Tavu,
No, it's
page 1 nig bani. Jute packing material, compulsory use in packing commodities act of 1987.
Yes.
Please come to my lord, paragraph, serial number, section 4. Sorry, section 3. Power to specify commodities which are required to be packed in jute packing material.
Yes.
Notwithstanding anything contained in any other law for the time being in force, central government may, if it is satisfied after considering the recommendations made to it by the standing committee, will not do all this. Compulsory packaging. Now please look at section 4. Section 4, my lord, says,
Advisory committee.
yes, they'll have to, my lord, look at, my lord, please subsection 2. What is it that they have look at? Existing level of usage of jute material, quantity of raw jute available, quantity of jute material available, protection of interests of persons engaged in the jute industry and in production of raw jute, need for continued maintenance of jute industry, quantified quantity of commodities which in its opinion is likely to be required for packaging in jute material, such other material as a standing committee owns. So, my lord, they'll have to look into all this. Now, if your lordships look at, my lord, the order that has been passed.
Page,
my lord, my first judge, my lord, the order, my lords get that. At, my lord, page 13. Sorry, 1 minute, my lord, I'll tell you, lordship.
order is 26 December 2023.
Correct.
That's page 13.
That's a notification, my lord.
Notification.
Yes.
After that?
After that, my lord, they have gone on extending. My lords, that has gone up to, my lord, the next page, they extended it. Like that, my lord, they have gone and extending it, my lord, and the last was 22nd of April 2025, my lord, where is that?
It is in the amendment application.
Put it in this size. What is it that you are doing? One there, one here. When you have a compilation, my lord, we have filed it with a memo, my lord, amendment only.
It is not in the compilation.
Amendment application jote hakidi.
All right. Yes, sir.
Now, my lord, coming back to, my lord, this, my lord, is carcinogenic. My lord, what they use is in a jute, my lord, bag when they manufacture, they'll have to, my lord, use batching oil. Batching oil is carcinogenic. Please come to my lord, page 19. We have produced, my lord, enough material, abundant material, which shows that, my lord, this is carcinogenic. That means, my lord, it causes cancer.
Jute batching oil.
Correct. They, my lord, jute batching oil is, my lord, used, is, my lord, admitted. Please come to, my lord, page 20. Adral introduction al baratte. I will not trouble your lordships. Ultimately, my lord, they come to the conclusion that, my lord, it is carcinogenic, and that's not disputed by the other side as well. Now, my lord, what they are saying is that we will use only 3% batching oil. My lord, 3 or 1, it is of no consequence. Now, my lord, what has happened is
Now, may I ask? Now, who are you? South Indian Sugar Mills Association.
Correct, my lord.
Who is the third respondent?
Third respondent, my lord, is the Jute Association of Jute.
The beneficiary of this manufacture.
We are a Mills Association. We comprise of all the jute manufacturers.
All right. So jute bags are beneficial to you.
Yes.
Just asking. You are the beneficiary of this.
Yes. I'm only an association of all the manufacturers.
Correct. Jute manufacturers are the beneficiaries of this. That is challenged by the Sugar Mills Association. Yes. How are you impacted by this?
What is the date?
25th April 20.
My lord, 25th of April 2025.
One clarification.
Yes.
How is the Sugar Mills Association impacted by this?
My lord, we are required to compulsorily, my lord, use this. Please come to, my lord, that notification itself, order of the central government.
Page,
my lord, 13, or the compilation. Oh, sorry, convenience compilation.
Yes, sir.
Food grains. Last table.
Food grains, yes.
100%.
Yes.
Sugar, 20%, my lord, compulsorily, my lord, it has to be used.
Oh, for packaging sugar, jute should be used. 20%. So here you are wanting to project that it is carcinogenic, so you don't want to use. Is that the submission?
Section 5, if your lordship sees.
Yes.
3. Where an order has been made under section 3, requiring any commodity class
Implement the relevant provisions of labor law, so and so. Sugar fortified, so and so, with vitamins.
Allah. Page 3, Nalli.
Page 3.
Page 3, section 5.
Oh, sorry.
Sorry, my lord.
Page 3, 1 minute.
That act.
Yes, sir.
Prohibition of packing in any material other than the jute packing material. Where an order has been made under section 3, requiring any commodity, class of commodities, or any percentage thereof to be packed in jute packaging material for their supply or distribution, such commodity, class of commodities, and percentage thereof shall not, on and from the date specified such order, be supplied or distributed unless the same is packed in accordance with that order. So, my lord, we are compulsorily required to, my lord, do it. Now.
So your submission is you're packing carcinoma.
Correct.
Yes.
Absolutely. And if your lordship, my lord, look at the order, please come to, my lord, the order itself at page 14. Very significantly, export, my lord, we can't pack it. 6 ban it out.
Yes, sir. The following may be kept out of the.
Sugar, fortified vitamins, no. Packing for export commodities, no. Small consumer packs of 10 kilograms, no. Bulk packing of more than 100 kilograms, no. Sugar packed for export, but which could not be exported on the basis of assessment and recommendation of by the Department of Food and Public Distribution. So, my lord, export, no. Foreigners, my lord, they can't have cancer.
So, illi matra sugar pack madake jute bag use madbeku.
Then, secondly, my lord, what also happens is when we, my lord, jute bags, my lord, are porous.
Correct.
Water, my lord, can, my lord, do. As far as food grains are concerned, my lord, it is washed. But as far as sugar is, we can't wash it. If it is washed, gone. Sugar is gone. Therefore, this, my lord, when we pack it in sugar, my lord, jute bags, it is, my lord, has a very limited shelf life. 1, it's carcinogenic. 2, 3, my lord, that, my lord, it's hygroscopic, my lord. Therefore, my lord, the water percolation, all that is there. And contamination, everything, my lord, is there. Now, my lord, if your lordships come to, my lord, even the please come to, my lord, running page, we have filed a
Now,
memo.
this is, sorry, 20% of your sugar,
Entire production of lot.
entire
all
production,
across India.
20% of the entire production, you are supposed to use jute.
Correct.
What about the other 80%?
Other
What do you
malad,
do?
we'll use malad polythene bags.
Is that not carcinogenic?
No malad, no. It is malad specific malad, use malad of carcinogen. Malad. Even in this, what they say is use, polythene, inner material. That's
No,
what they are saying.
correct, no problem. Now, if you are saying that, yes, we are export or transporting carcinoma by the jute bags because batching oil contains
Correct.
carcinogenic material, plastic also?
No malad. Plastic malad is not, because plastic is not carcinogenic. Plastic malad may have an impact on the ecology, but it is not carcinogenic.
All right, yes, very. Yes.
Then we have produced malad. If your lordships come to malad, there is an acute shortage of jute. Please come to malad. The memo that we have filed on 29/4/2025. 1 minute. Oh, you should have put it in the convenience company.
29/4. Amended first. Which memo?
What is this? Have you filed this?
Yes,
When
it's
you
filed.
have filed?
27th, 29th.
Memo on short one, Malad. You have an extra copy? Just give the extra copy if you have. Malad,
Copy
one extra copy.
Yes.
Malad, please come to page 7.
Oh, toxicology report.
Yes, yes.
Yes.
That, please come to Malad, running page 11. Sorry,
Yes.
page Malad 12 Bani.
Yes.
Summary. Jute batching oil is carcinogenic due to its high content of polycyclic aromatic hydrocarbons. Multiple studies have shown that prolonged exposure to JPO induces benign and malignant skin tumors in animal models, confirming its role as a tumor initiator and promoter. Presence of potent carcinogenic pH and benzopyrene directly contributes to its carcinogenic effects. Therefore, JBOP poses significant health risk and conclusively classified as carcinogenic. Then, please come to Malad. More important is, please come to Malad, page 19. Indian Oil Corporation, Malad, Indian Oil, Malad, manufactures Malad, this batching oil. Its website of Indian Oil Malad Corporation. Please come to Malad, end use anta barata. Second paragraph. Since jute materials are used for packing food material, presence of heavier oil, which may contain carcinogenic compounds, are not desirable. They themselves, Malad, say.
Yes.
Then next page, if you allow us turn to production of jute bags. Jute commissioner says, please look at Malad, what is Malad the availability. Total Malad is 933.4. Now, if you allow us Malad, compare it with Malad the page 356 of the convenience compilation. I'll tell you lots why.
Page
356 of the convenience compilation.
Yes, sir.
366.
366, my lord. I'm sorry, I stand correct.
366.
Yes, please. If your lordship sees, this is, my lord, a report.
Requirement. Correct. And supply.
Correct. This is, my lord, by the Ministry of Textiles itself, Government of India. If your lordships come to, my lord, 2023, otherly tabular column, 21-22, my lord, the total percentage of bags supplied for 51%, my lord, for food grains. 100% should be food grains. What is available is only 51% is available. 2022-23, my lord, it's 55.94.
So your suggestion is there is short production.
Absolutely shortage.
No,
and my lord, they import, my lord, jute from Bangladesh. We have shortage, so my lord, we import from Bangladesh, and then my lord, we anyway.
So now,
and
one more clarification.
Yes.
You are aggrieved by the imposition of jute packing or short supply.
My lord, both. Both, my lord. And if your lordship look at my lord,
No, if you are aggrieved by the short supply, does it mean that you are accepting jute
no,
supply?
no, my lord, no.
Jute packaging?
We are, my lord, showing before your lordships two things. One is, my lord, it is carcinogenic.
Yes.
Therefore, my lord, its use, my lord, is health hazard. Secondly, my lord, it is hygroscopic.
Even if it is taken that we will accept it, there is no supply. Is what you're.
No, second is, my lord, hydrographic. Therefore, my lord, it's use, my lord, use of jute bag for packing sugar is, my lord, detrimental to, my lord, the content of the sugar itself.
All right.
Storage and content and all that. Thirdly, there is shortage. And now, my lord, please come to, my lord, that memo, page 21. As on 22-23 production, as your lordship saw, is, my lord, 14. As on, my lord, 24-25, total, my lord, at the top, your lordships get that.
Yes.
Total is, my lord, 933.4.
The production has come down.
Yes. And, my lord, as it is, my lord, in 22-23, there was a shortage of 55%, my lord, even for food grains. Sorry, 45%. 55% was what all that was available.
Yes.
And where is that? Backlog. Please come to, my lord, page 25 of the memo.
Yes. Jute commissioners.
Yes, report. Saying, my lord, there is a tremendous amount of backlog, even, my lord, for the jute bags, for the sugar. Now, my lord, coming back to, my lord, the act. If your lordship
So
sees,
if the supply is increased, now you are saying about supply backlog and other things.
Correct.
The supply is increased. Would it be that you have no objection
No, my
to
lord,
pack?
no.
Carcinoma is still there.
Carcinoma is still
Yes.
there, my lord. Problem with the storage, my lord, is there. All that is there. Not only that. Can I persuade your lord to look at, my lord, the act? There must be application of mind. There's absolute no non-application of mind would be my submission.
Page, sir.
Page, my lord, 4. 3.
Of the
But the act compilation, convenience compilation.
Yes.
Everything in one place.
Section?
Standing advisory committee shall, subsection 2 of section 4.
Yes, sir.
They'll have to look into, my lord, the quantity of raw jute available, quantity of jute material available, protection of interests of persons
So,
engaged in the.
before imposition, all these should
All these
be.
must be taken into account, my lord. Nothing is taken into account. State level, my lord, they say that this is. Therefore, my lord, there's absolute, my lord, there's total arbitrariness. In fact, on an earlier occasion, the committee itself, my lord, that advisory committee said, for sugar, don't use. Yes, but I'll point out. Where is that? Earlier order. It said that, See.
30th SSC, sir.
Page in the convenience compilation.
In 30th meeting is 373.
373 ताव बंद रहे. Not 373, I say. Well, Lord, sorry, it's not 373, my lord. I'll point out. Please come to my lord.
378, I guess.
Correct. 377, my lord.
All right.
30th meeting starts at 373.
That's what. Sorry. No, it's 378. 31st meeting or 30th?
ಇಲ್ಲ 30th meeting ಬರುತ್ತೆ ನೋಡಿ.
30th meeting.
373, 21st of July.
30th meeting starts at 373.
Yes, my lord.
Yes.
Please come to my lord. Running page 377. They, my lord, consider various aspects. D. In my lord, page 377.
Sugar may be exempted completely.
Completely. Notwithstanding that, government, my lord, says, I impose this. My submission to your lordship says,
yes, sir.
Various aspects, my lord, are to be taken into account, my lord, by the committee. Committee, my lord, says it should be exempted. Notwithstanding that, my lord, they passed the order which your lordship saw. Thereafter, my lord, there has been, my lord, continuous decline in the production itself. Food grains itself, my lord, there is 45% shortage. Though, my lord, 100% has to be packed in jute bags. None of this, my lord, is taken into account by, my lord, the committee. And committee, my lord, passes that, and then, my lord, government, my lord, keeps on, my lord, extending the order.
Imposition.
Correct. Therefore, my lord, we are before your lordships. My submission is, in this regard, my lord, I have given one compilation of judgments. Idu carrying coal to Newcastle anta agutte. In fact, Gujarat High Court.
Madam. Judgments.
Where is it? In fact, there are reports of, my lord, the text, my lord, in fact, very significantly, I must also tell your lordships, the textile ministry, my lord, says it must be. The food, my lord, the food ministry says, no, 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 you can't use, you should not use it. Anyway, my lord, your lordship, my lord, just take. There have been, my lord, other reports also, my lord. Where is that in the convenience? My lord, convenience, before your lordships take, please convenience volume your lordships have, my lord. 430 if your lordships come to 430. There was, my lord, a committee constituted.
Yes, sir.
Permanent committee.
Yes.
Where exactly do you get this in this?
Pricing policy for
yes,
jute.
444. Section 8 only at the bottom. 444.
Yes, JPM Act has
Correct.
created.
Has created assured demand of jute sacking, but it has also acted as a barrier to technological advancement, production diversification. Commission reiterates its earlier recommendation to review JPM Act to reduce the mandatory packaging requirements in a phased manner so as to ensure adequate supply of raw material for other diversified jute goods. And my lord, as I pointed out, 45% shortage even for food grains, though 100% has to be, my lord. Therefore, all this, none of it, my lord, is taken into account.
Yes.
451 also, if your lordship sees.
Yes.
Point 1.14.
Yes, sir, I am there.
Indian jute sector is heavily dependent on government demand for food grains and sugar packing. Compulsory packing of food grains in jute material was increased from 90% to 100% with effect from 2018, 30th of November. JPM Act 19 under JPM Act 1987. Requirement of the government for jute sacking bags has increased significantly due to higher production of procurement of food grains. It is evident from chart 1.4. Share of sacking in total jute consumption has risen from 73% to 80.4%, while share of hessian and jute manufacturing products has declined significantly during the period. Continued high reliance on sacking by jute mills has been the major impediment to diversification, modernization, and technical upgradation of jute industry. Therefore, to revitalize the jute sector and to enhance income to the jute farmer is essentially to gradually reduce the compulsory packing of food grains and sugar, thereby freeing up capacity for production of value-added diversified products. The textile ministry itself says all this. 487, my lord, if your lords is come to. .18. In order to meet the growing demand of diversified jute goods in the domestic and international market and to improve export earnings, there's an urgent need to review the JPM Act and reduce compulsory jute packing requirements in a phased manner so as to ensure that the captive demand for jute sacking does not crowd out the supply of raw jute for other diversified jute goods. There's a need to focus on diversification jute products. In spite of all this, Lord, the government, Lord, simply, Lord, keeps on, Lord, extending it without, Lord, application of mine. Would be my submission.
Well, here
384, Lord, there was one more committee, Rangarajan committee.
384.
Yes, Lord. They, Lord, 392, Lord, if your lords come. Para 11.
11 and 13.
Yes, yes, yes. Where, my lord, the committee, my lord, which was constituted by, my lord, the government itself, says, don't insist on packing of sugar in this. Para 11. Therefore, my lord, my submission to your lordship says, there has been total application of mind. And then, my lord, now, my lord, in fact,
It is not accepted.
in fact, Coca-Cola, all these multinationals are, my lord, refusing to take, my lord, sugar, my lord, because they are also, my lord, heavy consumers. AP, Andhra Pradesh, Punjab, my lord, we have produced that also, my lord, for your lordship's consideration. Please come to, my lord, running page.
What have they done?
They say that no, not in jute bag for sugar. Please come to, my lord, running page. 236.
AP and?
AP and Punjab. This is, my lord, tender by the Andhra Pradesh government, 236 only. 245 if your lordships come to. This is Andhra Pradesh, my lord, government, calling for tenders, my lord, for 245, 6.2.1 and 6.2.2. They are insisting on, my lord, polythene packs, not, my lord, sugar, I mean, in the jute packs.
In the tender itself.
Yes.
Yes.
And
Half kg polythene, yes.
557, if your lot has come to, my lord.
Yes.
This is from Coca-Cola, my lord, saying that, we don't want, my lord, all that, my lord, we have produced all that. Ultimately, my lord, there was a judgment of the Gujarat High Court. Can I persuade your lord? Just look at, my lord, that
page.
Please come to, my lord, convenience compilation kotra, Saibri.
Judgments compilation.
Howdu.
Yeah.
You are not given, is it?
Kotpidi. Sorry.
Huh?
Kotil.
You haven't filed it. What is this? Don't do all this.
Nimatra idea? You have it?
Copy kotra.
Yes.
Please come to, my lord, running page 11, my lord. This was argued and, my lord, this judgment was given, Gujarat High Court.
Yes, sir.
Please come to, my lord, page 11. In that, please come to, my lord, page 32.
Yes.
Sorry, page 14 first, my lord. Page 14. I'll tell you, lordships, why. 1-4.
Yes.
Sorry. My lord, para 14, my lord, not page 14, my lord. I'm sorry, I stand corrected. Please come to, my lord, paragraph 14 at page 22. All the aforesaid views by different constituents of the committee made a stream of strong view and was culminated as advisory, advised by this statutory constituted committee. This advice has been brushed aside by the central government while issuing the impugn notification, keeping in mind the extraneous factors. Adverse impact of batching oil used in the jute packaging material. It has been stated in detail by the jute commissioner that batching oil used in jute packaging material contaminates edible products, though through contact, while with the packing material, resulting in direct impact upon the health of persons who are consuming food grains and sugar. The monsoon seasons also, it absorbs moisture and contaminates the edible products packed in jute packing material. In response to this, it is stated by the learned advocate for the respondent, Union of India, that recently the government has restricted 3% usage of batching oil in the production of jute sacking material, packaging material. Therefore, there will not be any contamination. Looking to the facts and circumstances in the present case, I am of the opinion that the jute packaging material contains batching oil and it affects the health of the people at large and contaminates the food grains. For export of the food grains and sugar, jute packing material is not compulsory, meaning thereby for citizens and residents of this country, jute packing material, though it contaminates food products, 100% production is required to be packed in. That was, my lord, at that time, my lord, 100%. Now they are reduced to 20%. In a jute packing material, this is not in public interest. Scope of the judicial review, my lord, and they refer to all that. And ultimately, my lord, the Honorable Gujarat High Court has held that, my lord, it's not proper to use.
Yes, sir.
Lord, that also you have to give a copy, I said. In fact, there is a petition filed in the Calcutta High Court, my lord, after this petition by respondent number 3. And see, my lord, what is it that the government itself has filed? Textile Ministry. Please come to, my lord, running page. Page numbers. Have we filed page numbers or not? Don't do on this, I say. Otherwise, you give it to me. I will do it. Please. God help me. My lord, paragraph 5, 3, 5, and 7. Page, my lord, this is the objection statement filed by, my lord, the Union of India. Sorry, Ministry of Consumer Affairs, my lord.
Union of India.
Yes. Please come to para 3. It is submitted, my lord, para 2, my lord, 20% to the production of sugar in this. Submitted, the sugar has inherent properties that make it susceptible to moisture absorption. Jute bags have a higher tendency to attract and retain moisture, which poses a significant risk to the quantity and quality and integrity of sugar stored with these bags. Moisture can lead to clumping and caking of sugar, rendering it unfit for for human consumption. Then, my lord, paragraph 5. It is submitted that considering the above representation, Standing Advisory Committee, Ministry of Textiles requested by its letter dated so and so to exempt sugar from mandatory packaging of jute packing.
Yes.
Then, my lord, 7, 9. Para 9, my lord, if your lordship sees. UP, my lord, State Cooperative Sugar Federation, Tamil Nadu State Cooperative Sugar Federation, other sugar mills have floated tenders, but no bidder submitted their bid to supply so and so. Para 7, my lord, is shortage, which is also, my lord, referred to by the 3, 5, 7, 9 odd numbers, my lord. Union itself says all this.
Without the full cost title, very difficult to make out who is this respondent. First respondent appears to be Union of India. Full cost title, so I don't know who that.
Would your lordship come to, my lord, page, last page. I, Sunil Savarkar,
Under Secretary, Directorate of Sugar and Vegetable Oils, Department of Food and Public Distribution,
Public
Krishi
Distribution,
Bhavan.
Krishi Bhavan, New
Union of
Delhi.
India.
No, but it would be helpful to know who exactly is the 5 and 6.
Yes.
No, who has filed, because I'll have to take instructions on this. This document is
On this, we'll see. You are ready otherwise.
I'll need some time. I mean, the several documents are filed today, 600 pages of judgments.
Nothing, convenience compilation ashte.
Adala, today, I mean, this document has now been given 600 pages of judgments.
That's right.
And I think Jan also.
600 pages of judgments alli. First Gujarat High Court bitre. In all arbitrance, right from Indian Express till the latest.
If my learned friend is not going to place reliance on them, then it's.
No, reliance on the irad ashtene adralli. Ella arbitrariness.
If it was
Indian
given in
Express.
advance, I could have read it. If
Ivat kotradu antana.
If he makes a statement before my lords that he's not going to place reliance on
Why will he not place reliance?
then I need some.
Lord, all the time.
I wish I'm not.
No, I think those judgments are all of arbitrariness, right from Indian Express.
Absolutely, my lord.
AI can process it in 2 seconds.
Lord, my
ASG
learned friend
also
is
can process
better
it
than
in
my
2
lord, AI, my lord. I'm sure, my lord, his office is AI.
Yes.
Both as a private practitioner and my lord as the
Yes.
SG.
All right. Yavat, sir. Thursday? Friday, all right. Heard the learned senior counsel, Shri Uday Holla, appearing for the petitioner, who has completed his submissions. The learned additional Solicitor General, Shri Arvind Kamath, seeks time to go through the judgments, submissions, and also seek instructions with regard to a memo now handed over during the proceedings with regard to an affidavit filed before the High Court of Calcutta, before the High Court of Calcutta. List the matter at 3:30 p.m. for the hearing.
Please.
Yes. Shravan, ನೀವು ಮುಗಿಸ್ಬೇಕಾವತ್ತೆ ಏನಾದ್ರು? ಹಾ, yes. ನೀವು ಯಾರು ಸರ್?
Serial number 330 list number, not
120, 330. Wait.
7A.
1160 now, date 121 goes.
11? ಆಯ್ತಾಯ್ತು, ಕರಿತೀನಿ ತಾಳಿ. 120.
120. 330.
ಏನದು? ಆಯ್ತು, so what? We'll call it. Don't. All right. 116 in the career remand.
Further hearing, 116.
ಸ್ಫೂರ್ತಿ ಜಗದೀಶ್ ಇಲ್ವಾ? ಜಗದೀಶ್ ನಾಟ್ ದೇರ್. ಅಲ್ಲ, ಇವರು ಇಲ್ಲ ಬಿಡಿ. ಲಿಸ್ಟ್ ಪಾಸ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇರುತ್ತೆ.
117.
ಎಸ್ ಕುಮಾರ್,
The petitioner.
ರೆಡಿನಾ? ಎಸ್ ಸರ್.
senior is leading us, my lord, but I'll make a bid. Lavraj.
That's early bidding. Yes, pass over.
No, no, I'll start. Lordship.
Hmm.
For
Wait. Let him come. 118, Kalyan Basuraj. Yen 7 ena?
No demand, no acceptance, no trap question.
No case.
Okay, sir.
ಇದರಲ್ಲಿ ಅಬ್ಜೆಕ್ಷನ್ ಐಪದ R2
Hmm.
ಅದರಲ್ಲಿ ಕಾಂಟ್ರಾಕ್ಟ್ ಅಲ್ಲಿ ಪಿಟಿಷನ್ ನಂಬರ್ ಚೇಂಜ್ ಆಗ್ತಿದೆ ಸರ್.
Petition number change ಆಗಿದೆಯಾ?
ಪೇಪರ್ ಇತ್ತಲ್ಲ
ಸರಿ, ಕೇಸ್ ಏನ್ ಹೇಳಿ?
ಕೇಸು 7 ಮೇಲೆ ಡಿಮ್ಯಾಂಡ್ ಓವರ್ ದ ಫೋನ್ ಮೇಲೆ
Demand
ಓವರ್ ದ ಫೋನ್
out of 4.
ಫೋನ್
Demand over phone. ಆಮೇಲೆ
ರೆಕಾರ್ಡ್ ಇದೆ ಸ್ವಾಮಿ ಮೇಲೆ ಶುದ್ಧ ಥಿಂಗ್ ಇಸ್ ದಟ್ ಮೇಲೆ
ಟ್ರ್ಯಾಪ್ ಯಾವಾಗ ಲೈವ್ ಮಾಡಿದ್ರಿ? ಟ್ರ್ಯಾಪ್ ಆಗಿಲ್ವಾ?
Recording with
Sir, I have rendered 7 judgments latest.
Latest.
The thing is, your honor, I see the conduct of the petitioner in this case. When I was the FIR was filed on 4/12/2019, my lordship. Adagi within a week he filed the charge sheet, my lord. Within a week he filed the charge sheet in the main case.
Which case ಅಲ್ಲಿ?
And the crime number.
ಯಾರು? Who is he?
He is the police sub inspector, my lordship.
Oh, PSI. All right.
Really, the complaint was dated on 4/12/2019, my lordship. He filed the charge sheet on within a 1 week on 13/12/2019.
ಏನು offense ಏನು ಅದರಲ್ಲಿ?
324, my lordship.
324.
He has demanded 1 lakh rupees as a bribe from the accused, my lordship.
From the accused?
From the accused to file a big report.
ಬಿ ರಿಪೋರ್ಟ್ ಹಾಕಿದ್ರೆ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ರು ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳಿ.
big report ಹಾಕೋದಕ್ಕೆ 1 lakh ಡಿಮ್ಯಾಂಡ್ ಮಾಡಿದ್ರು. The FIR was registered in the ACB. They after yes filed the charge sheet.
Lord, recording with respect to
ಒಂದು ನಿಮಿಷ.
please.
ಯಾವ ಕ್ರೈಮ್ ಬಗ್ಗೆ ಹೇಳ್ತಾ ಇದ್ರಿ ಇವರು?
Lord, earlier, my lord, there was one crime was registered against the accused.
You were the IO?
Yes, my lord, I was the IO.
All
Against
right.
the second respondent. Lord, he has approached
Against the complainant?
Against the complainant. Lord, he has approached the accused number 1, who is a constable, my lord. There was a conversation took place
between the constable and the complainant.
And he has demanded 1 lakh, my lord, over the phone.
Yeah, constable demands 1 lakh.
Demands 1 lakh. What you are stating in a complaint, my lord, regarding the voice recording. And my lord, and he has complaint has stated in his complaint that he has met me and I also demanded the amount, not over the phone, in the station. But on Ali's date of incident, my lord, I was not in Bangalore, I was in Hyderabad on another case, my lord. I went to Hyderabad. I have produced a case diary.
No trap was laid?
No trap, no recovery, no demand, nothing, my lord.
ಇದರಲ್ಲಿ the conduct ಏನಂತಂದ್ರೆ
completely covered by what I have written. ಇದು ಸಬ್ ಇನ್ಸ್ಪೆಕ್ಟರ್.
Totally misused his power, my lord.
ನಿಮ್ದು
ಅಲ್ಲ ಏನಾಗಿದೆ ಅಂತಂದ್ರೆ he has misused his power. ಇವಾಗ ಇದಲ್ಲದೆ
who has misused the power?
The IO has misused the power.
Now what is that he is saying? ಒಂದು ವಾರದಲ್ಲಿ ಬಿ ರಿಪೋರ್ಟ್ ಹಾಕಿದ್ರ?
No, my lord. Charge sheet has been filed, not in 1 week, my lord.
Which is that crime number?
Lord, crime number, my lord.
173 of 2019.
173 of 2019, my lord.
173 of
2019.
2019. You filed charge sheet.
In crime number
offense is 324.
341, 324, 506, read with 34.
341.
324. 506, read with 34 of IPC.
All right. Second respondent ಯಾರು ಅದರಲ್ಲಿ?
Is the complainant in the
Is the accused, my lord.
Accused.
Complainant is
accused in that case.
173 of 2019.
Yes.
ನಿಮ್ಮ ಹತ್ರ ಡಿಮಾಂಡ್ ಮಾಡಿದ್ರಾ?
Yes, madam.
1 ಲಕ್ಷ.
1 lakh.
ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಕ್ಕೆ?
ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲ, big report ಹಾಕೋದು.
ಬಟ್ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ದಾರೆ.
ಅಲ್ಲ ನಾವು ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಲ್ಲ, ನಾವು ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದಕ್ಕೆ big ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ದಾರೆ ಇದರಲ್ಲಿ. big report ಹಾಕ್ತೀನಿ ಅಂತ he has demanded, my lord.
ಯಾವತ್ತು ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ರಿ ಸರ್?
4/12/2019 is the complaint.
ಇದು ಒಂದು ವಾರದಲ್ಲಿ ಚಾರ್ಜ್ ಶೀಟ್ ಡೇಟ್ ಆಫ್ ಕ್ರೈಮ್ ಹೇಳಿ. 173 of 2019.
Date of crime is on 1/10/2019.
1/10/2019.
39, sorry, my lord. 39/2019.
39/2019. Charge sheet filed on?
Charge sheet is filed on 13/12/2019.
30/12/2019. ಒಂದು ವಾರ ಅಂದ್ರೆ
ಅಲ್ಲ, ನಾನ್ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟ ಮೇಲೆ ACB ಗೆ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿರೋದು 4/12/2019.
4/12/2019.
13/12 he has filed a charge sheet after lapse of 9 days.
ಏನು
ಅಲ್ಲ, ನಾನು
ಔಟ್ ಪಾರ್ಟ್ ಅವ್ರು ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ದಾರೆ.
ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದಾಗ ಇವಾಗ ಕೈಲಿಸಿ ನನ್ನ ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲಿ ಪಿಟಿಷನ್ ನಂಬರ್ ಚೇಂಜ್ ಆಗಿದೆ.
He says that he has conducted the investigation. 4/12/2019 we have given the complaint, my lordship. And 2010.
4/12 ACB ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ರಿ ಆಯ್ತು.
As per the investigation, my lordship, he has conducted the merger on 21/10/2019.
21/10 ಸರಿ.
ನಾವು ಆರ್ಟಿಐಲಿ ತಗೊಂಡಿದ್ದೀವಿ. he was on leave from 2010/2019 ಇಂದ 24/10/2019, my lord. He was not at all in the police station. He says that he has been investigated the matter, he has drawn the merger and he has recorded the statement of witnesses.
ಯಾವತ್ತು
21ನೇ ತಾರೀಕು ಸ್ವಾಮಿ, 21/10/2000.
ಅದು ಹೇಳಿದಾರೆ ಅವತ್ತೇ ಮಾಡಿದ್ದೀನಿ ಅಂತ?
it is there.
ಯಾವ್ದ್ರಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ?
ಅದು cash ಅಲ್ಲಿ ಇದೆ.
ಸರಿ, ತೊಂದ್ರೆ ಇಲ್ಲ.
But he is not at all in the station, he was not at all in the headquarters, my lord. He has left the headquarters on 20/10/2019.
ಕರೆಕ್ಟ್. ನೀವು ಯಾವತ್ತು ಟ್ರ್ಯಾಪ್ ಮಾಡಿದಾಗ he was not at all in Bangalore, he was in Hyderabad. ಅದಕ್ಕೇನ್ ಹೇಳ್ತೀರಾ? ಅದಕ್ಕೇನ್ ಹೇಳ್ತೀರಾ?
ಅದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ the complaint he says that further statement ಅಲ್ಲಿ the complainant is stated that ಅದು ಡೇಟ್
ನೀವು ಕಂಪ್ಲೇಂಟ್ ಅಪಿಯರ್ ಆಗ್ತಿರೋದಾ?
and also
ಓ, ಈ ವೆಂಕಟೇಶ್ವರ ಭಟ್ಟಿ ಲೋಕಾಯುಕ್ತ ACB ಗ? ಎಸ್ ಸರ್.
ಇದರಲ್ಲಿ ಏನಂತ ಡಿಮ್ಯಾಂಡ್ ಮಾಡಿದ್ವಿ ಸರ್, he was not at all in the station ಅಂತ ಹೇಳ್ತಾರೆ. Even while he was recording the statement and drawing the merger, he was not with the
ಕಾನ್ವರ್ಸೇಷನ್ ಇವ್ರ ಜೊತೆ ಇದೆಯಾ?
ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ ಕಾನ್ವರ್ಸೇಷನ್
It is a clear case of wreaking vengeance
not like
of you filing the complaint. Anything else, sir?
nothing. ಅಲ್ಲ, ಇದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ he has misused, totally he has misused his power, my lord, filing the
To
charge.
file the charge sheet.
Yes, my lord.
Where is misuse of power if he is filing charge sheet? Be report ಹಾಕ್ಬೇಕಾಗಿತ್ತಾ?
ಅಲ್ಲ, ಬಿ ರಿಪೋರ್ಟ್ ಹಾಕೋದು ಅಂತ ಹೇಳ್ತಿಲ್ಲ, ನಾನು ಸ್ಟೇಷನ್ ಅಲ್ಲೇ ಇಲ್ಲ, ನಾನು ಇದು ಮಾಡಿದೀನಿ ಅಂತ ಹೇಳ್ತಾರೆ.
ಅದನ್ನ ಅವ್ರು ನೋಡ್ಕೊಂತಾರೆ ಬಿಡಿ, ತೊಂದ್ರೆ ಇಲ್ಲ. ಅದೇನ್ you cannot contend all that.
ಅಲ್ಲ, ನಾನು ಹೇಳ್ತಿರೋದು after ನಾನು ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟು ಇವಾಗ ಮೈ ಕಳಿಸಿದ್ದಾರೆ. The complaint dated is on 30/9/2019.
ಅದು ಹೇಳಿದ್ರಲ್ಲ, ಬರ್ಕೊಂಡಿದ್ದೆ.
ಹೌದು. ಅದಾಗಿ
3 ತಿಂಗಳಾದ್ಮೇಲೆ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿರೋದು.
3 ತಿಂಗಳಿಲ್ಲ ಸರ್.
ಹೌದು ಸರ್.
ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿರೋದು ಬಂದ್ಬಿಟ್ಟು
30/12/2019. ಐ ಥಿಂಕ್ 3 ತಿಂಗಳೇ ಆಗಿದೆ ಅಲ್ಲ?
2 ತಿಂಗಳು 13 ದಿವಸ.
ಪರವಾಗಿಲ್ಲ.
ಬಟ್ ನಾನು ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟು ಒಂದು ವಾರಕ್ಕೆ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕ್ತಾರೆ. ಒಂದು
ಪರವಾಗಿಲ್ಲ.
ಎರಡನೇದು ಬಂದ್ಬಿಟ್ಟು ಇವನಾಗ ಕಲಿತಿದ ಮಾಜಲ್ ನೋಡ್ಬೋದು. ಅದು ಹಾಗೆ
ನೀವು ಕಂಪ್ಲೇಂಟ್ ಕೊಡದೇ ಇದ್ರೆ ಬಿ ರಿಪೋರ್ಟ್ ಆಗ್ತಾ ಇದ್ರಾ?
ಅಲ್ಲ, ಬಿ ರಿಪೋರ್ಟ್ ಹಾಕ್ತೀನಿ ಅಂತಾನೆ ನಮ್ಮ ಹತ್ರ ಡಿಮ್ಯಾಂಡ್ ಮಾಡಿದ್ರು.
ವೆರಿ ವೆರಿ ವೀಕ್ ಕೇಸ್. 7A ಅಲ್ವೇ ಅಲ್ಲ. Where is demand? Where is acceptance?
Demand is by accused number 2, my lord.
The demand is not by him at all.
Demand ಆದ್ಮೇಲೆ the complainant has met the IO and informed that ಈ ತರ ಆಗ್ತಾ ಇದೆ ಅಂತ ಹೇಳಿದಾಗ he said that ಅವ್ರು ಏನ್ ಮಾತಾಡಿದ್ರೆ ಅವ್ರು ಕೊಟ್ಬಿಟ್ಟು ಬಿ ರಿಪೋರ್ಟ್ ಹಾಕ್ಸ್ಕೊಂಡು ಹೋಗಿ. ಬಿ ರಿಪೋರ್ಟ್ ವಾಸ್ ರೆಡಿ ಆಕ್ಚುಲಿ. ಬಿ ರಿಪೋರ್ಟ್ ರೆಡಿ ಇತ್ತು ಸ್ವಾಮಿ. ಅದಾದ್ಮೇಲೆ ಯಾವಾಗ ದುಡ್ಡು ಕೊಡಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ in the open station he has been told the
ಬಿ ರಿಪೋರ್ಟ್ ರೆಡಿ ಇದು ಅಂತ ಹೆಂಗ್ ಗೊತ್ತು ನಿಮ್ಗೆ?
ಸ್ವಾಮಿ, ದುಡ್ಡು ಕೊಟ್ಟ ಅಂದ್ರೆ ಬಿ ರಿಪೋರ್ಟ್ ಇದು ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳಿ it been shown to the complainant. ಯಾವಾಗ 1 ಲಕ್ಷ ಕೊಡೋದಕ್ಕೆ ಇದ್ ಮಾಡ್ತಾರೋ ಅಲ್ಲೇ ಬಿ ರಿಪೋರ್ಟ್ ನ he has been shown in the open station, my lord. It has been
ಬಿ ರಿಪೋರ್ಟ್
ಅದಾಗ್ತದೆ ಅಲ್ಲೇ ಸ್ಟೇಷನ್ ಅಲ್ಲಿ. It has been bring to the knowledge of
Why did you tear the B report, sir?
Everything has been
ಯಾವ್ದು ಫಿಲ್ಮ್ ಇದ್ದಂಗೆ ಇದೆಯಲ್ಲ ಇದು?
ಎಲ್ಲ ನಡೀತದೆ ಸ್ವಾಮಿ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್.
ಹೌದು, ಕರೆಕ್ಟ್.
ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಏನ್ ಬೇಕಾದ್ರೂ ನಡೆಯುತ್ತೆ. ಈಗ ಅವು ಗಜದಲ್ಲಿ ಇದ್ದಾಗ 20ನೇ ತಾರೀಕಿಂದ 24ನೇ ತಾರೀಕು ಹೋದ್ರು. ಈ ಸೆನ್ಸರ್ ಐ ಕಂಡಕ್ಟೆಡ್ ಎಂಟೈರ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಅಂತ ಹೇಳ್ತಾರೆ. ಇವಾಗ ನಮಗೆ ಕೈಂಡ್ಲಿ ಸಿ ದಟ್ ಅಬ್ಜೆಕ್ಷನ್ ಐ ಫೈಲ್ ಮೈ ಎಂಟೈರ್ ಅಬ್ಜೆಕ್ಷನ್ ಮೈ ನೋಟಿಫ್
ಹಾಕಿದ್ದೀರಲ್ಲ?
ಹಾಕಿದ್ದೀನಿ. ಅದು ಇದಾಗ್ಬಿಟ್ಟಿದೆ. ಫೈಲ್ ಎಲ್ಲೋಗಿದೆ ಅಂತ ಗೊತ್ತಿಲ್ಲ. ಕೌಂಟರ್ ಹಾಕಿದೆ ಸ್ವಾಮಿ.
ಕೌಂಟರ್ ಹಾಕಿದ್ರೆ ಇಲ್ವಾ?
ಪಿಟಿಷನ್ ನಂಬರ್ ಚೇಂಜ್ ಆಗಿದೆ ಸ್ವಾಮಿ.
ಓ, ಬೇರೆ ಯಾವ್ದಕ್ಕೆ ಕೇಸ್ಗೆ ಹೋಗ್ಬಿಟ್ಟಿದೆ. 14A ಹೋಗಿರುತ್ತೆ. ಎಸ್,
ಇದು ಕೇಸ್ ನಂಬರ್ ಚೇಂಜ್ ಆಗಿದೆ.
ಎಸ್ ವೆಂಕಟೇಶ್
ಆಗಿದೆ. 51
entire records and places.
ಮೂರೇ ಕ್ವಶನ್.
Sanction is yes.
Sanction is granted. Sanction grant ಆದ ತಕ್ಷಣ it does not ಎಲ್ಲ ಪಾವಿತ್ರತೆ ಕೊಟ್ಬಿಡಲ್ಲ ಎಲ್ಲದಕ್ಕೂ.
ಮುಂಚೆನೇ ಬಂದಿದೆ sanction 23.
ಅದಿರ್ಲಿ. 3 questions. Did he demand?
Yes, it is there.
ಯಾರು?
His petitioner is A2. His demand is there.
Petitioner is A2 ನಾ? ನೀವೇ ಕಾನ್ಸ್ಟೇಬಲ್?
No, PSI. Constable is accused number 1, my lord.
But you are A2.
A2 is PSI.
A2
accused number 2, my lord. I am myself is accused number 2, PSI.
PSI A2.
A2 is demanded.
Yes.
ಎಲ್ಲಿದೆ?
The
Conversation.
complaint ಅಲ್ಲಿ ಇದೆ, then voice
Conversation ಎಲ್ಲಿದೆ?
everything.
Trap master ಎಲ್ಲಿ?
Facil, trap ಅಲ್ಲಿ, trap was, it didn't go to that stage. Demand is there, demand is proved.
ಎಲ್ಲಿ proved?
ಅಲ್ಲ, proved in the sense FSL report.
ಯಾವ್ದು ನೀವು ಫೋನ್ ರೆಕಾರ್ಡಿಂಗ್ ಮೇಲೆ ಎಲ್ಲರದ್ದು ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಸ್ಟಾರ್ಟ್ ಮಾಡ್ತೀರಾ ಅಥವಾ ಏನೋ ಟ್ರ್ಯಾಪ್ ಅಂತ ಮಾಡ್ತೀರಾ?
Demand is there. Trap
ಎಲ್ಲಿ?
is not.
ಡಿಮಾಂಡ್ ಇದೆ, ಆಕ್ಸೆಪ್ಟೆನ್ಸ್ ಎಲ್ಲಿ? ಮತ್ತೆ
7-8 is covered by that explanation.
What, sir?
Explanation.
The latest, you see that Amit Nange's judgment, latest, if demand is there, no acceptance, no crime. If acceptance is there, no demand, no crime. What is this?
Explanation.
Explanation ಗೊತ್ತು. Presumption section 20 ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ದಾರೆ. 2025, sir.
Yes, I've seen that judgment. Has to be. Yeah, both have to be there, both have to be this stage. Not at this stage. Not
Either ಇಲ್ಲ ಅಂದ್ರೆ neither ಇಲ್ಲ.
It could be.
Could be ಮೇಲೆ crime register ಮಾಡಕ್ಕಾಗತ್ತಾ? No, sir, it is not departmental inquiry. Preponderance of probability ಅಲ್ಲ.
Crime is registered before the trap. That is why not.
The crime is registered before the trap.
Yes. So that.
Where is the trap?
Not at that stage, not.
Where is the trap?
But I understand. But at that stage, not I understand the trap is not successful or.
How do you prove 7A, sir?
But 7A, the demand is.
Where? Demand is there.
Yes.
Acceptance.
But accept it.
Sir,
did not.
provision itself is says, accepted illegal gratification towards a particular work. Work ಏನಿಲ್ಲ ಈಗ ಬಿಡಿ ಸೀತಾ ಸೊರೇನ್ ಪ್ರಕಾರ no work is ಅದು ಬೇಕಾಗಿಲ್ಲ. Acceptance ಅಲ್ಲಿ.
That is where the explanation your lordship has.
What explanation? Somebody else accepts. Who has accepted here?
But on behalf of A2 only.
Who has accepted?
The other accused, A1.
A1 has accepted 1 lakh?
Yes. No, sorry. Not the demand itself is not through the.
Where is the acceptance? Either A1 or A2?
But the acceptance is not.
ಇದೆಯಾ ಇಲ್ವಾ ಅಷ್ಟೇ?
Acceptance illa.
Anything
that
else?
is where that explanation your lordship have to consider. 7A
Sir,
explanation.
7A explanation demands on behalf of somebody else, but that does not wipe out acceptance. See Neeraj Datta's clarification does not wipe out. Ye ಒಂದ ಎರಡು ಎಷ್ಟಿದೆ? What is this, sir?
Sir, I'm sorry, but your lordship has clearly dealt with it.
Yes,
But only
sir.
that explanation and not the illustration to the explanation. Your lordship may have to not. I'm just.
I have already dealt with that.
The illustration.
Illustration of the explanation also.
Then I'll.
Explanation cannot control the provisions. It only explains what is the circumstance.
But it cannot be ignored also, is not in same in Neeraj Datta. Not.
Sir, why you come to Aman Bhatia?
Yes, ma'am. Your lordship has.
Where is Aman Bhatia? 1013, 2025 SEC online.
I'm not. It's there in the other.
See paragraph 51 to 65.
But yes, I've seen that. There, the illustration to 7M is what I'm.
Illustration is also considered in those paragraphs.
That illustration of that 5,000 rupees. May I just read that illustration?
Read. Illustration ಇದೆ sir. Aman Bhatia ಅದು consider ಮಾಡಿದ್ದಾರೆ. The apex court says proof of demand and acceptance is sine qua non for any proceeding under section 7. What do you mean sine qua non? Without which you cannot do anything. Not that probably ಇರ್ಬೋದು ಅದಿರ್ಬೋದು. See, I have dismissed 4 cases of 7A last week. In those cases, though there was no demand like he was not holding it in his hand, 2 lakhs was in the car where the complainant was holding and this man was sitting in the front. Why would he get it? So I have dismissed it. In another case, in his house when it was searched, 2 lakhs was on the teapoy. Why would they keep it? So these cases I have dismissed. ಇದರಲ್ಲಿ ಏನಿದೆ? Demand ಇಲ್ಲ, acceptance ಇಲ್ಲ. This is clear case where ಬಿ ರಿಪೋರ್ಟ್ ಹಾಕ್ತೀನಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿರ್ಬೇಕು. ಅದಕ್ಕೆ ಇವರು ಕೋಪ ಒಂದು ಹಾಕಿದ್ರು ಕಂಪ್ಲೇಂಟ್. ಇನ್ನೇನಿದೆ ಇದರಲ್ಲಿ? An accused hunting the IO. If the accused is permitted to hunt the IO like this for whatever reason, there will be no end to it.
Not like that, my lord. Telephone conversation is there, my lord. Telephone conversation.
ಈಗ A2 ಡಿಮಾಂಡ್ ಆಗಲ್ಲ ಸರ್ ಆಕ್ಸೆಪ್ಟೆನ್ಸ್ ಅಲ್ಲಿ.
Yes, my lordship. ಅದ್ ನಾನು ಹೇಳ್ತಾ ಇದ್ದೀನಲ್ಲ.
ನೀವು ಹೇಳ್ತಾ ಇದ್ದೀರಾ ಅಂತ.
Accused is hunting the IO ಅಂತ ಹೇಳಿದ್ರಲ್ಲ. Then how can he get the evidence, my lordship, to that extent?
Which evidence, sir?
ಫೋನ್ ಅಲ್ಲಿ ಮಾತಾಡಿದಾಗ
ಇವ್ರು ಮಾತಾಡಿದಾರ? ಇವ್ರು ಮಾತಾಡಿದಾರ? ಇವ್ರು ಮಾತಾಡಿದಾರ?
No, my lordship. In this case, my lordship, ಇವಾಗ ಮಾತಾಡಿದ.
ಇವ್ರ ಪರವಾಗಿ ಅವ್ರು ಮಾತಾಡಿದಾರ?
ಪರವಾಗಿ ಅವ್ರು ಮಾತಾಡಿದಾರ.
ಅವ್ರನ್ನ you proceed against him.
Yes, my lord. Thereafter,
all right, yes.
Thereafter, my lordship, it has been bring to the knowledge of the IO, my lord. I file my objection on adjournment ಮೇಲ್ಗೆ. ಅದು ಇದಾಗಿಲ್ಲ.
ಇಷ್ಟೊತ್ತು ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಯ್ತಲ್ಲ ಇನ್ನೇನು.
I file the record ಹಾಕ್ಬಿಡ್ತೀನಿ ಸ್ವಾಮಿ, ಅದ್ರಲ್ಲಿ ಏನೇನಾಗಿದೆ ಅಂತ.
ಕರೆಕ್ಟ್ ನಂಬರ್ ಹಾಕ್ಬಿಟ್ಟು ಹಾಕಿ.
Yes, ma'am.
ಲಿಸ್ಟ್ ಆನ್ ಥರ್ಸ್ಡೇ.
ಮಚ್ಚವಲ್ಲ ಇಲ್ಲ.
ಅಷ್ಟೇ ಇದ್ರಲ್ಲಿ. You look at Aman Bhatt.
Friday ಮೇಲೆ.
Thursday.
Friday ಮೇಲೆ.
Thursday.
Out of I'll be out.
ಇಲ್ಲೇ ಇರಿ. Yes. Thursday.
Just pass on the investigation records.
ಕೊಡಿ. Yes, next.
The interim order to be continued.
Interim order subsisting will continue till the disposal of the petition. ಅಲ್ಲಿ ಹರ್ಡ್ ಸೊ ಅಂಡ್ ಸೊ ಅಂತ ಹಾಕಿ ಅವರ ಹೆಸರುಗಳು ಹಾಕ್ಬಿಟ್ಟು. Next is.
119.
Arbati sir, look into those judgments and come and look into what I have rendered in the last week. Yes.
Last week, those judgments are already there.
ಏಳು ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ.
Facts, your lordship said that your lordships are dealing on facts.
ಕರೆಕ್ಟ್. ಆ ಫ್ಯಾಕ್ಟ್ಸ್ ಇಲ್ಲಿ ಸ್ಟ್ರೈಟ್ ಅವೇ ದಟ್ ಈಗೇನೋ ಕೊಟ್ರಲ್ಲ ಇವರು ಅಂತ ಅವ್ರಿಗೊಂದು ಕಾಪಿ ಕೊಡಿ. ಅರ್ಬಟಿ ಸರ್ ಒಂದು ಕಾಪಿ ಕೊಡಿ. ಅದು ಪೊಲೀಸ್ ಸಬ್ ಇನ್ಸ್ಪೆಕ್ಟರ್ ಸ್ಟೇಷನ್ ಬೇಲ್ಗೆ ಅನ್ಬಿಟ್ಟು 50,000 ಡಿಮಾಂಡ್ ಮಾಡಿದ್ದಾರೆ. ಎಸ್. offense is 353 and 326. ಸ್ಟೇಷನ್ ಬೇಲ್ ಎಲ್ಲಿ ಬರುತ್ತೆ? That's the problem. Yes.
119.
ಇಲ್ಲ ಅಂದ್ರೆ ಪಾಸ್ವರ್ಡ್ ಮಾಡಿ.
120.
Petitioner in this case will
Interim order ಇಲ್ವಾ? ವಿಕೆಟ್ ಮಾಡಾಗ ತುಂಬಾ ಅರಿಯಲ್ಲಿದ್ದೀರಾ. ಎಸ್.
It is an alleged.
Kindly have it on.
It is an offense under section 7A. I was seeking for a quashment of the FIR.
Constitution of India 1915 ಸ್ಟಾರ್ಟ್ ಮಾಡ್ಬಿಡಿ. ಏನ್ ಗ್ರೌಂಡ್ ಹೇಳಿ.
Millards ಇದರಲ್ಲಿ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಇಲ್ಲಾಂದ್ರೆ FIR ಅಲ್ಲಿ there is no mention of the name of the
ಇರ್ಬೇಕು ಅಂತ ಕಾನೂನು ಇಲ್ಲ. ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಫಸ್ಟ್ ಟೈಮ್ ಬರ್ಬೋದು, ತೊಂದ್ರೆ ಇಲ್ಲ.
Millards ಬಟ್ ಇಲ್ಲಿ ಡಿಮ್ಯಾಂಡ್ ಮಾಡಿರೋದು ಇಲ್ಲಾಂದ್ರೆ ಅಕ್ಸೆಪ್ಟೆನ್ಸ್ ಬಗ್ಗೆ ಎಲ್ಲೂ ಇಲ್ಲ Millards. ಅಲ್ಲಿ A1 ಕೊಡ್ತಾರೆ. Yes Millards. I am the A2. ಅಲ್ಲಿ ಬ್ಯಾಕ್ ಕೊಡ್ತಾರೆ. ಅದು ವಿತೌಟ್ ನೋ ಇಂಟೆನ್ಷನ್ ಅವ್ರು ತಗೊಂಡೋಗಿ ಡಿಕ್ಕಿಯಲ್ಲಿ ಇಡ್ತಾರೆ ವಿತೌಟ್ ನೋಯಿಂಗ್ ದ ನಾಲೆಡ್ಜ್. And being the knowledge with at 3:40 p.m. he goes and keeps that in the bag in the dicky. At that time he's been trapped for the offense of keeping 7,50,000 rupees in the dicky ಅಂತಿರೋದು Millards.
ಸುಮ್ನೆ ಡಿಕ್ಕಿಗೆ ಯಾಕೆ ಇಟ್ಕೊಂಡು? ಅದಕ್ಕೆ ಇಂಟರ್ಮ್ ಮಾಡಿದ್ರೆ ಅರ್ಜೆಂಟ್ ಮಾಡಬಾರ್ದು. ಈಗ ಹೋಯ್ತು ಕೇಸ್, ಮ್ಯಾಟರ್ ಆಫ್ ಟ್ರಯಲ್ ಅಲ್ವಾ?
The thing is Millards, he is a driver.
ಸುಮ್ಮನೆ ಸ್ಟೇ ಇತ್ತು,
ಹೋಯ್ತು.
ಎಸ್ ಸರ್. If it is in the boot of the car which you are driving, it's a matter of trial.
But he didn't have the intention or he does not know what is there in the bag. Whatever the higher authority has followed the order.
Mensri is not applicable in 7A proceedings.
Millards, he is a subcontract driver, is not at all fall within the jurisdiction of Lokayukta Millards. Subcontract driver Millards.
Oh, ಸರಿ ಆಯ್ತು. ಆಮೇಲೆ ಪಬ್ಲಿಕ್ ಸರ್ವೆಂಟೇ ಅಲ್ಲ.
Public servant ಅಲ್ಲ Millards. 7A is very clear with regarding the provisions Millards.
Yes sir.
Taking advantage to influence public servant by corrupt or illegal means by exercising personal influence.
ಅಲ್ಲಿ ಎರಡು ಎಕ್ಸ್ಪ್ಲನೇಷನ್ ಇದೆ ನೋಡಿ, ಅದನ್ನೇ ಹೇಳ್ತಾ ಇದ್ದವರು. ಅದಕ್ಕೆ ಪಬ್ಲಿಕ್ ಸರ್ವೆಂಟ್ ಬೇಕಾಗಿಲ್ಲ.
ಪರ್ಸನಲ್ ಇನ್ಫ್ಲೂಯೆನ್ಸ್ ಎಲ್ಲೂ ಮಾಡಿಲ್ಲ. There is
ಡ್ರೈವರ್ ಇನ್ಫ್ಲೂಯೆನ್ಸ್ ಮಾಡಬೇಕಾಗಿಲ್ಲ. Yes.
And those allegations are not even made by the complainant in this regard Millards. It was made only on the accused, that is A1.
All right, sir. Anything?
Kindly have it on 25th my lord.
Sir, yes. Objection ಹಾಕಿದಿರಲ್ಲ?
Objection already.
ಓಯ್ ಮತ್ತೇನೇನು reserved? Yes. Interim order subsisting will continue till the disposal of the petition.
Accused number 2 accept ಮಾಡ್ಕೋತಾರೆ. So accused number 1 ಬಂದ್ಬಿಟ್ಟು
ಏನ್ ಬಂದ್ಬಿಟ್ಟು
ಚೀಫ್ ಜನರಲ್ ಮ್ಯಾನೇಜರ್ ಇರ್ತಾರೆ. ಸೊ
ಚೀಫ್ ಜನರಲ್ ಮ್ಯಾನೇಜರ್
ಬೆಸ್ಕಾಂ. ಸೊ
ಅವ್ರ ಪರವಾಗಿ
ಇವ್ರು ಎಸ್ಕೊಂಡು
ಅವ್ರ ಪರವಾಗಿ ಇವ್ರು ಬೂಟಲ್ಲಿ ಇಟ್ರ.
ಅಕ್ಯೂಸ್ ನಂಬರ್ 1 ಕರೆದು ಹೇಳ್ತಾರೆ ಇವರಿಗೆ ಅಕ್ಯೂಸ್ ನಂಬರ್ 2 ಗೆ ಸೊ ಈ ಅಮೌಂಟ್ ನ ಇವ್ರ ಹತ್ರ ಕೊಟ್ಟೋಗಿ ಅಂತ.
ಅಕ್ಯೂಸ್ ನಂಬರ್ 1 ಏನಾಯ್ತು?
ಸೊ
ಅಲ್ಲ ಅವ್ರೇನ್ ಪೆಟಿಷನ್ ಹಾಕಿಲ್ವಾ?
ಪೆಟಿಷನ್ ಹಾಕಿಲ್ಲ. ಸೊ
So currently I have it on 23rd or 25th,
Sir,
my lord.
ಸುಮ್ನಿರಿ ಸಾಕು, yes. He's ತುಂಬಾ ಹರಿಲಿದ್ದಾರೆ ಅವರು. Your hurry will turn into worry now. Yes. Yes. Reserved.
122.
ಇದು ಕೊಡಿ ಸರ್.
Medical.
Jugular vein. Yes.
One report I am filing, my lord, with respect to.
ಕೊಡಿ ಸರ್.
Victoria Hospital report, my lord. In that, I directly go to the third para where why they have inserted, instead of right jugular vein, right jugular catheter, it was inserted to the left, means why it was. Nurse
Sir,
noted page number 15, page number 7, my lord.
Any amount of explanation you should know.
Yes.
The person has died.
Yes.
Because of your wrong insertion of IV tube, catheter.
Catheter. Temporary catheter which was inserted.
Catheter temporary, permanent illa.
ಇಲ್ಲ permanent HD ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಅದಕ್ಕೋಸ್ಕರ ಅವ್ರ ಆಪರೇಷನ್
ಯಾವ ಡಯಾಲಿಸಿಸ್
ಅಲ್ಲ ಡಯಾಲಿಸಿಸ್ ಗೋಸ್ಕರ HD ಗೆ ಇನ್ಸರ್ಷನ್ ಮಾಡಕ್ಕೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಅವ್ರ ಫೋರ್ಟಿಸ್ ಗೆ ಅಡ್ಮಿಟ್ ಆಗಬೇಕು. ಅದರಲ್ಲಿ
hemodialysis permanent catheter, all right.
permanent catheter, this is a temporary catheter negligence itself, because it was not.
No, there are two kinds of dialysis, one hemodialysis and peritoneal dialysis. Peritoneal dialysis ಅಲ್ಲಿ permanent ಆಗಿ ಅಲ್ಲೇ ಇರುತ್ತೆ.
ಈಗ permanent dialysis, permanent
This is hemodialysis.
Why it was inserted instead of right, why it was inserted to the left?
All right. ಏನು vein ಸಿಗ್ಲಿಲ್ವಾ?
ಅಲ್ಲಿ there was an obstruction which was being present in the right jugular vein. The report is at page number 7, my lord, point number 4, my lord. Nurse noted at page number 15 reveals that the patient received from first floor to OT at 3:45 PM. Right permanent catheter insertion by the vascular surgeon was abandoned due to the presence of Thomas in the right jugular vein, which was informed to the nephrology. They went. It was suggested that it was a principle that always the right side of the jugular vein, the catheter will be inserted.
Correct. Permacath, that is permanent catheter, is necessary for all CKD patients.
Yes.
Chronic kidney disease patients who are undergoing dialysis, no doubt. But you will have to take care as to which vein you will have to insert it.
Yes.
All right.
The
Now,
only the only thing which comes against the doctor is that the catheter inserted towards the left side was not exactly to that means to the angle. That angle.
The angle change.
The word
I'll get back to you.
When she was means when he was shifted to the first Fortis hospital from which hospital at Fortis hospital in the emergency lifting itself, that catheter has come out on 4/4.
ಈಗ ಇನ್ಸರ್ಟ್ ಮಾಡಿದಲ್ಲಿ ವಿಕ್ಟೋರಿಯಾ ಹಾಸ್ಪಿಟಲ್
ಅಲ್ಲ ವಿಕ್ಟೋರಿಯಾ ಹಾಸ್ಪಿಟಲ್.
ಮತ್ತೆ
Victoria Hospital, the matter was
referred for negligence.
DM hospital, the catheter was inserted. That catheter has come out in the shifting the patient from GM hospital to Fortis hospital. In the Fortis hospital, outside the hospital itself, the catheter has come out due to the slip itself.
All right.
Shifting ಮಾಡಬೇಕಾದ್ರೆ ಅದನ್ನ that operation they have conducted on 5/4/2024.
ಎಲ್ಲಿ Fortis hospital.
There they noted that the catheter which was inserted was the rupture, the vein was ruptured towards the right side, and
Where did he die?
He died after 10 days in the Fortis hospital.
In Fortis hospital.
Fortis hospital conducted the operation at 5 PM, noting down that there was a rupture. That rupture was fixed, and the HD catheter was inserted. HD catheter, that is the permanent catheter, was inserted to a subclavial veins. Subclavial veins towards the right side. But it while inserting itself, that the punch and inserting itself, the patient has gone to the coma due to the anesthesia, and he died on 15/4/2024 after 11 days of the operation. After the operation was successful, but still the patient went to the coma because of the
Ade classic operation success, patient died.
After because of the cardiac
You
arrest.
heard, operation is successful, but patient is no more.
After operation was successful at 5:15 PM, but after
Sir, ನಿಮ್
the
ಪ್ರೊಸೀಜರಲ್ ಅವ್ರಿಗೆ ಬೇಕಾಗಿರೋದು ಪೇಷಂಟ್ ಉಳಿದಿದ್ದಾರೋ ಇಲ್ವೋ ಅಂತ.
patient would tell, and he has suppressed some of the materials, like he was a renal patient also. Previous to
Renal patient and CKD.
And my lord, renal patient kala. First he was admitted, renal patient ಮುಂಚೆನೇ ಆಗಿದೆ. First he was admitted for the APC.
CKD ಅಂದ್ರೆ renal patient. Renal failure ಆದ್ಮೇಲೆ
That is further, my lord. First he was inpatient for CPD, my lord.
CPD.
Ergoplasma congenital treatment. At
It's heart.
Fortis Hospital. For fixing of some of the ruptures which are in lungs and gastrointestine. ಹೊಟ್ಟೆನಲ್ಲಿ lungs ನಲ್ಲಿ.
Reason for death ಏನಿದೆ? What is the report?
Cardiac arrest and excess bleeding in the means
where-
brain ಗೆ.
Yes, coronary thrombus ಏನು?
ಇಲ್ಲ, hyper.
The reason for death was something known as pneumothorax. He went into cardiac arrest. Lordship may kindly take that memo that.
Pneumothorax is a
Yes,
well-known
pneumo.
complication of internal jugular vein
Please.
catheter insertion.
Lordship may take that memo which my learned friend just passed on. There are 5 instances I can point out in this wherein there is some sort of lapse. Lordship may kindly see.
Who is the doctor?
The doctor, the persons
Two
against
doctors.
whom I want to.
Allah,
proceed.
ಇಲ್ಲಿ they are not parties here.
They are not
They are
parties
not.
here because my respectful submission is in a pre-FIR stage, the proposed accused have no right of audience.
That is correct.
That is why.
What is the stage of the proceedings?
Now, this is a writ for mandamus.
Mandamus for what?
I had filed 2 complaints before the police, the respondents herein.
Hmm.
Now, they have not registered an FIR. They've issued an endorsement which I have impugned before your lordship. That is at annexure E1 at page 207. They issue an NCR, and then on 208 at annexure E2, they say you go to the consumer forum. Now, what I am aggrieved by is that they have not followed the drill of the 3 judgments by the Honorable Supreme Court. That is Jacob Matthew, Martinez D'Souza, and Lalita Kumari. They had to conduct a preliminary inquiry, place this at the hands of a medical board or a doctor, and then take a report and then see whether an FIR is to be registered or not. In fact, partially this Honorable Court granted me relief on 13/9/2024 by calling upon the respondents to conduct a preliminary inquiry. As a result of that, the matter was placed at the hands of Victoria Hospital.
This is the preliminary inquiry.
This, and now if your lordship were to kindly see what the Victoria Hospital opines. The last page of that memo, lordship would please see, and how to manage this improperly positioned IJC situation can be obtained by vascular surgeon. Now I am given to understand that this again has been placed at the hands of Jayadeva Hospital now. Now my respectful submission is, if your lordship were to kindly consider Lalita Kumari, it says preliminary inquiry to be done in 6 weeks, in 15 days, at best 6 weeks. Now the complaints I preferred before the respondents was on 18/6/2024 and 26/6/2024. Till now, no action has been taken at all.
Anyway, preliminary inquiry is now conducted. There is
Partially seems to have been conducted.
there
Now
is
again, it is now.
some sort of negligence.
Some sort
has
of
emerged.
negligence only in the angling of the left side jugular vein. Some sort
So
of.
no crime.
No.
Consumer forum.
It's not a recklessness. It's an angle which has been made, and shifting ಆಗ್ಬೇಕಾದ್ರೆ ಅದನ್ನ ಎಳೆದಿದ್ದಾರೆ. ಅದು it can't be said that it is done by somebody exactly to the doctor.
I will not labor this court with much. This memo that my friend has filed, my learned friend has filed.
Yes.
Lordship, to please see, somewhere in the middle of the page, the sentence commences with at MICU. At MICU, the word uses ectopic position of the left eye. Ectopic means abnormal. Now, my respectful submission, this could not have happened in usual course if reasonable care was exercised.
All right, we'll consider.
And furthermore, there is no recklessness, and the judgments what he is referring in that judgments itself in Lalita Kumar itself.
Jacob Matthew.
Jacob Matthew, para number 52 maybe, recklessness.
In fact, one other development has happened after the filing of the petition. Now, if your lordship were to please see my petition at page 20241. This is a notice issued by the Karnataka Medical Council. Now, Karnataka Medical Council, under the provisions of the Karnataka Medical Registration Act 1961, is parallelly proceeding.
Right.
Now, they have recently, on 10th of June, I'll just pass on this memo.
What have they done?
They have said it's a prima facie case of negligence, as a result of which they have called on for full inquiry.
That's before the forum.
After, if they conclude the proceedings. we will
Now,
log this
I'm
by
just bringing this to
3 or
Lordship's
4
notice. These two are distinct. They are separate. They cannot be dovetailed is my respectful submission.
All right, we'll see. Heard reserved. Yes.
Judgments, and there's a brief note that I have filed
I saw.
on 10th of
In
January.
Jacob, para number 52 itself, Lalita Kumari, 20.6 and 7. I rely on that.
120.6.
That was the
Not
review.
20.6.
That was a review that had taken place, Lordship.
120.6 and 127. 6 postulates in 120.6 where preliminary inquiry is required.
So
Yes.
therefore, even if now Jayadeva were to consider, my respectful submission is some time-bound consideration. And again, if it is placed at their hands, they should not further delay is my respect. That's my only apprehension.
We'll see.
This is one judgment.
Kodiko.
Para number 20, 21, 22.
20, 21, 22 ಬರ್ಕೊಂಬಿಡಿ ಮೇಡಮ್.
ಬರುತ್ತೆ.
ನಿಮಗೆ ಬರ್ಕೊಡಿ 20, 21, 22. Yes, heard. Is okay. Heard so and so. Interim order ಇದೆಯಲ್ಲ?
There was no, the only order that was subsisting was the order dated 13/9/2024.
That is preliminary inquiry.
There, otherwise I had not sought for any interim.
That's all right. Yes. So and so.
If I just want to bring to a Lordship's notice one judgment of this coordinate bench of this honorable court. So there are two compilations. In memo of citations number 2, your Lordship, to just take, I will not take too much time. Memo of citations volume 2 filed in the counter on 13th of January 2025. Sorry, memo citation volume 1. There is a detailed judgment penned by this honorable court, coordinate bench, wherein it states that you have to issue directions to deal with cases of this kind. Lordship, to kindly come to page 71. Memo of citations volume, memo of citations anta ide.
Hmm. 71.
Page 71, bari memo of citations anta ide.
Correct, ಅದರಲ್ಲೇ ಇದೆ.
Page 71, the judgment commences from.
Justice Panindra ಅವರದ.
Please, please.
All right.
Here, his lordship has detailed what are the guidelines that have to be laid down and what are the directions that the state has to pass to deal with cases of this kind.
All
Lordship, to please see 74, para 11. Though the Honorable Apex Court has set down certain guidelines in the case of so and so, state government appears to not have issued any statutory rules or executive instructions incorporating certain guidelines as noted in the opposite decision. Particularly, the learned High Court government pleader appearing for the state has not brought any guidelines, rules or executive instructions issued by the state government in pursuance of the judgment of the Honorable Apex Court. And then subsequently guidelines are laid out.
All right. We'll see. Yes.
230 more matter.
ಎಷ್ಟಿದೆ ಮೇಡಮ್?
Tanap Bharti.
Lord, in this matter, this honorable court directed me to
AG
to be appear. AG is
Just
on,
one submission, not,
because he is
let the AG appear. No objections. Not, this review is not moved.
ಇಲ್ಲ ಈಗ that tender is not taken forward.
ಇನ್ನೊಂದು ಹೊಸ ಟೆಂಡರ್ ಮಾಡಿದ್ರೆ that your lordship will find.
ನೀವು ಬಿಟ್ರೆ ಇದೇ ಮಾಡೋದು. This is the whole
Lordship will find,
problem.
not page 19.
That is why all of them said continue this only.
Kindly have a look at page 19, 19. ಒಂದು ನಿಮಿಷ ತೋರಿಸ್ಬಿಡ್ತೀನಿ ಎರಡೇ ಲೈನ್.
Page
19 my lord. ಬೃಹತ್ ಬೆಂಗಳೂರು ಮಹಾನಗರಪಾಲಿಕೆ ಸೋ ಸೇವೆಯನ್ನು ಸಮರ್ಪಕವಾಗಿ ನಿರ್ಮಿಸಲು ಮರು ಟೆಂಡರ್ ಆಹ್ವಾನಿಸಲು ಸರ್ಕಾರ ಅನುಮೋದನೆ ನೀಡುವ ಬಗ್ಗೆ ಏನ್ ಮಾಡೋದು. ಮೋಸ್ಟ್ ಇಂಟ್ರೆಸ್ಟಿಂಗ್ ಥಿಂಗ್ ಅಬೌಟ್ ದಿಸ್ ಇಸ್ ನಾಟ್ ಪೇಜ್ 25. ಐ ಆಮ್ ಸಾರಿ, ಪೇಜ್ 27 ಮೇಡಮ್. ಸಿ ಅಂಡ್ ಡಿ ಮೈ ಕೈಂಡ್ಲಿ ಬಿ ಸೀನ್. ಸದರಿ ನಿರ್ವಹಣಾ ಕಾಮಗಾರಿಯನ್ನು 33 ಪ್ಯಾಕೇಜ್ಗಳನ್ನಾಗಿ ವಿಂಗಡಿಸಿ, ಅದು 89 ಇತ್ತು, 4 ಮಾಡ್ತೀವಿ ಅಂತ 33 ಮಾಡಿದ್ರೆ ದಟ್ ಮೇ ನಾಟ್ ಕೆಟಿಪಿಪಿ ಕಾಯ್ದೆ ಸೋ ಕೆಟಿಪಿಪಿ ಕಾಯ್ದೆ ನಿಯಮ ಸೋ ಕೆಟಿಪಿಪಿ ಪೋರ್ಟಲ್ ಮುಖಾಂತರ ಕೈಗೊಂಡು ಟೆಂಡರ್ಗಳಿಗೆ ಸರ್ಕಾರ ಆದೇಶ ಸಂಖ್ಯೆ ಸೋ ರಂತೆ ಸಕ್ಷಮ ಪ್ರಾಧಿಕಾರಗಳಿಂದ ಅಗತ್ಯ ಅನುಮೋದನೆಗಳನ್ನು ಪಡೆದು ಕೈಂಡ್ಲಿ ಹ್ಯಾವ್ ಲುಕ್ ಅಟ್ ದ ನೆಕ್ಸ್ಟ್ ಲೈನ್. ಅನುಮೋದನೆ ಪಡೆದರೂ ಕೆಟಿಪಿಪಿ ಆಕ್ಟ್ ಅಲ್ಲಿ ಇದೆ, ಪಡೆದು ಇಲಾಖಾ ಸಚಿವರ ಅನುಮೋದನೆಯೊಂದಿಗೆ ತುರ್ತಾಗಿ ಅನುಷ್ಠಾನಗೊಳಿಸಲು ಆದೇಶಿಸಿದೆ. ಈ ಇಲಾಖಾ ಸಚಿವರ ಅನುಮೋದನೆ is nowhere found not in the KTPP Act.
ಇಲಾಖಾ ಸಚಿವರು ಯಾಕೆ ಬಂದ್ರಿಲ್ಲ?
That's what not. But I can understand not what happens behind the scene, not these kind of things not being written.
Petitioner, a respondent in so and so.
Day after tomorrow.
One ನಿಮಿಷ, I will give you day after tomorrow. The petitioner is the respondent in WP 2935 of 2023. The writ petition comes to be disposed by an order of this court dated 28/5/2025.
No, I'm sorry, 22/4.
22/4/2025 by the following directions.
Page 232.
Page
232.
The copy paste ಮಾಡಿ.
Serial number 4.
Hello, full page. Para 15. On the submission of the learned advocate general appearing for the respondent then, this court who had assured that if a timeline is drawn by this court, the tender that was notified during the subsistence of the said petition would be taken to its logical conclusion. The respondents and the learned senior counsel representing the few tenderers had objected to the same on the score that the BBMP has no interest to continue the tender. They will issue a new tender. The apprehension of the counsels who had objected to disposal of the petition of this kind has now come true. No, the tender that was notified during the subsistence of the petition is not taken forward, but altogether a new tender is notified on 26/5/2025. Therefore, there is breach of the undertaking given by the Advocate General before this court, which is recorded and the petition was disposed. In that light, all further proceedings pursuant to so and so shall remain stayed till the next date of hearing.
All the points. Tomorrow, day after tomorrow, it may be taken, my lord.
ಯಾವತ್ತು ಬೇಕು?
Day after tomorrow.
List day after tomorrow. Day after tomorrow ಬೇಡ, Thursday.
Thursday.
List on Thursday. ನೀವೆಲ್ಲೂ ಹೋಗ್ಬೇಡಿ ಸರ್.
Hello.
ಕ್ಯಾಲೆಂಡರ್ ನೋಡ್ತಾ ಇದ್ದೀರಾ?
ಅಲ್ಲ 19 minute few criminal appeals for not list on. Yeah, I'll be here.
Yes.
Orders, Raghuram Kadam.
ಏನ್ ಕೋಟಕ್ ಬ್ಯಾಂಕ್ ಇದು ಐಡೆಂಟಿಕಲ್ ಸ್ಟೇ ಮಾಡದ್ನಲ್ಲ ಒಂದಲ್ಲಿ ಇಲ್ವಾ?
ಇಲ್ಲ ಇದಲ್ಲ.
What is the problem with Kotak Bank now?
No, I have a problem in that I have to get my money. My lord, my learned friend is the plaintiff's counsel is on caveat.
You have to get your money.
Yes, LC is issued. I have to, my lord, be paid. He files a suit and gets an injunction saying that not to act upon the LC without asking for money. My lord, in November itself, he sent an email to the other side, to his, my lord, counterparty, saying he'll file a suit for recovery of damages. Thereafter, in March, he files a suit and obtains an injunction against the LC. Now, my lord, I move the court. Court passes an order in April saying that the interim order be kept in abeyance. Union Bank, which is my correspondent bank, has to pay me money. I write to them, they have not paid me. My lord, in the fight between him and, my lord, his trading partner, I am, my lord, stuck. Now, predicament is I will end up having to declare Union Bank of India.
No. In the fight between 1 and 2.
Yes.
You and 3 are stuck.
Yeah, my lord. Ultimately, 3 is not stuck in as much as I have to get the money.
Has to pay you something.
No, the difficulty is I'm now in a situation where I'll have to declare, my lord, Union Bank of India and NPA.
Perfect.
I wish I could.
High time the banks are declared. How much you trouble the borrowers. So sometimes let bank also be troubled. Yes, sir.
Roll back to another, it will be a.
So what, sir? Sometimes some things will happen for the first time. Yes.
So we have to rush to your lordship to develop. Order is kept in abeyance by the court. Despite that, my lord, the proceedings are going on. Ultimately, we've asked for.
Yes, Surgeon.
There is a solution to this.
No, that's in the lighter way.
No,
yes.
I know.
There's a solution, my lord, if it's acceptable to your lordship and my learned senior. My lord, I am the buyer. I had a dispute with my seller. He was refusing to release the goods. I, my lord, sought injunction. Ex parte ad interim order was granted. Subsequently, my lord, they placed certain judgments and the trial court felt that such an order could not be granted. It was kept in abeyance. Then, my lord, on clarification, etc., it's been adjourned, my lord. They've not got their money. In the meantime, my lord, my seller, who is the defendant number 1 in the suit, has himself filed a copy of an email where he instructed, my lord, that shipping agent to give me the goods. So therefore, my lord, now I can take the goods. My lord, I really have no objection in the banks.
So you will take the goods, you take the file.
I'll take the money thereafter. My lord,
close
given me a copy.
Shall we close this? Or
yes, my lord, your lord. He's agreeable to having the interim order dissolved. If that is so, my lord.
Yes, Surgeon.
Yes. Please be kind enough to see page 3 of the memo my learned friend just tendered, my lord. Paragraph 4, B and C. That is what, my lord, I am seeking for.
And A I am seeking.
In fact, possibly after this, I may not be a necessary party to the suit, but anyway, that will resolve in the trial court. I don't
A
want to
and D,
trouble you. Page 3, 4B and 4C. I don't know. Subject.
4D, B and C.
B for Bangalore and C for Calcutta. Please.
Yes, yes. Hmm.
My lords, and A as well, my lord.
No, of course. I mean,
A
is
for,
between
A
him
for
and-
anta kelala, don't.
But now, had I been a A student, I would have asked him.
My lord, A is, my lord, now that seller has filed a memo before the learned trial court saying he has given instructions. So, my lord, let him be bound by that. Let me take my goods, and then, my lord, banks may give each other the money, be deleted from the suit. I'll pursue, my lord, I'll seek damages against.
So all is well that ends well. All right, yes.
Insofar as the banks are concerned, my lord,
Correct.
with my
No, let
seller,
him
I will
call
have.
him. Of course.
But you missed the chance of Union Bank being declared NPA. The petitioner.
So tempting as it is, I'll have to pass this time.
The petitioner, the defendant.
I was defendant number 3. Man.
Defendant number 3 in commercial OS.
420 of
Commercial OS 420 of 2025. Adilla bidiga.
I know.
IPC matra. BNS in the only change is no 420.
Number.
Yes.
Plaint is at
420,
page
that
7.
is different
Of
now.
course.
Yes. A petitioner is before this court calling in question the order of the concerned court dated 16/11/24, 25/11/24 and
No,
10.
madam, I'm sorry.
Allah, what is
Those
the
are the
order?
dates of the letters of credit.
Order dated
Order date 13/6 and
13/6/25 and 3/5/25. During the subsistence of the petition, the certain subsequent developments are placed by a memo by the counsel representing the first respondent. The memo reads as follows. The memo is the contents of the memo would speak for itself. The issue that went before the commercial court was a dispute between the defendant 1 and defendant 2, where they had certain
Plaintiff and defendant.
plaintiff
Number 1.
issue that went before the commercial court was between the plaintiff and the first defendant. In the crossfire, the third defendant and the defendant number 2 appear to have been caught. The issue between plaintiff and defendant number 1 was with regard to payment of money on release of LCs. During the subsistence, as observed here in above, the parties to the list appear to have resolved the dispute, and the
Sorry, Lord. It
1
may
and
not be a
2.
resolution, Lord. It is that D1 has written to them or placed an email saying they have no objection to them collecting the goods. Possibly.
Since the plaintiff was before the commercial court on account of the first defendant not permitting collection of goods on account of the problem with the LC, has now communicated by an electronic mail that the plaintiff can collect the goods and there would be no obstruction to the same. Therefore, the obstruction to the same, in that light, the plaintiff is now satisfied with the email communication and would submit that the entire suit subject goods be handed over to the petitioner as found in the email. Should we not hear the first defendant?
My lord, he's filed a memo before the trial court, my lord, saying that he has given instructions that I can take it. Of course, my lord, the dispute that I have with him, my lord, would not be rendered nugatory with this. Now have to sue him for damages, my lord.
No, that's a different thing. Now that he is sure, there's no necessity to hear.
Can I just?
Was he represented by a counsel?
Yes, sir, he was, my lord.
Can I
And
just
he's filed
persuade
a
your
memo.
lordships to please see the order where the interim order is kept in abeyance? A judgment of
that's
the
all
Supreme
right.
Court is
You-
noted saying LC is a separate transaction.
That's all right.
I bowed.
You serve the counsel.
I
and
bowed
get
on
it.
that.
I'll take it tomorrow.
Please. I bowed. The only thing tomorrow is that is the 90th day for intimation to RBI. That's the only.
90th day. Not for-
I bowed. He may not have an objection insofar as B and C.
Then
I'll
I'll
leave
take,
it. Madam, we'll
then
serve
I'll
him.
take it day after tomorrow. Intimate to the RBI.
ನಾಳೆನೇ ಬರ್ತೀನಿ. I'll come.
Yes. Tomorrow. Let's get the counsel.
Yes.
Tomorrow he should not say orders are passed
I bowed on
without
that. It's
hearing
not-
me. Yes. Let him confirm the email because he is represented by a counsel.
My lord, the council has filed that email
He
before
filed
the
it
court.
at the
Let
memo.
him comment.
But nonetheless, let him. We'll serve him as well as my lord Union Bank's counsel. We'll serve both.
Whatever. Get them here, we'll pass an order after
Great.
this. Preliminary hearing, yes.
So great.
Tomorrow. Even if it is not in the morning session, at 2:30 I will take it.
Great.
4:30. ಯಾವ್ದು ಮೇಡಮ್? ಎಸ್ ಸ್ಫೂರ್ತಿ ಓದಿದ್ರಾ?
Page number.
11:15.
My lord, initial charge sheet was filed by the Dharmasthala police itself, my lord. Thereafter, COD has filed a charge sheet. Both are on a similar footings that after the complete investigation, they have filed, my lord. I directly go to, I don't take around 10 minutes and more.
All right.
I directly go to the statement of the Guruva at page number 788 of the petition, my lord. Petition may be looked into.
Do it. I'll take it tomorrow, Mayur. This one, 5:15 I have to get up. 5 past hour ಏನಿದೆ. Shruti madam, ನಿಮ್ದು ಯಾವ?
Well, seal number 81 is passed over.
2:30 tomorrow morning.
I will do ನಾಳೆ reference ಇದೆ 4 o'clock. If you take 10 minutes, we'll
10 minutes.
10 minutes, 2:30.
My lord, serial number 87
1
was
minute.
passed.
Yes, ma'am.
My lord, I had an interim order operating in my favor, which was passed on the 2nd of May. The order, the operative portion of the order is found at 174. It's a public trust, my lord. It's section 94 suit.
All right.
In that, a committee is formed.
Section 92 suit.
92 suit. A committee is formed and ad hoc committee is formed, and their respondent numbers 1 and 5 are directed to place reports every day before 5 p.m. before the court regarding the functioning of the trust.
All right.
On 6th of June, that order comes to be extended. On the 11th of June, the court records stating that it is now 4:20 p.m. There are many witnesses that at that time it was 4:20 p.m. There are witnesses present in court. Evidence needs to be
ಅಲ್ಲ ಆ ಟೈಮ್ ಅಲ್ಲಿ
recorded.
ಪ್ರಾಬ್ಲಮ್ ಆಗ್ತಿರೋದು. Yes.
So, and the court says that it has, respondent number 3 has passed across the bar the case status of writ petition I had filed, and states that by virtue, another writ petition 16223 of 2025, in which I had sought for amplification of the order of 26/2025, wherein I had stated that there were insufficient guidelines with respect to the
Now
action
what
and
has happened?
functioning.
Now
of the-
what has happened?
So it's, the court states that merely by virtue of the fact that I filed that writ petition, the interim order is extended, save and except to the extent that I have challenged it in the writ petition, and also accepting the daily reporting requirements. In effect,
Exempting.
I mean, it accepts that portion of the interim
Alright.
order and extends it. Effectively, it has completely hollowed out that interim order because of the fact that I had brought it to the attention of the court repeatedly, that it was not, the order was not challenged.
Now what do you want? Stay of that order?
The stay of the modification portion, because it was extended.
Can both matters be taken up tomorrow?
Oh, you are here.
I have a filed caveat for the respondents.
But my only submission
So
is.
why all this? It should be
What has
vacated.
transpired is that order itself is unsustainable because miscellaneous is yet to be allowed. Suit itself is not on board.
My lord, that does not lie in their mouths because they've
No order
acquiesced,
can be
they've
passed.
acquiesced in that
Lie with him
order.
ಅಂತೇಳಿ. Yeah, lie in the mouth. Yes.
That order does not, sorry, that argument does not avail to them for the reason that they've acquiesced in the order dated 2/6/2025. From page 178 to page 200 are
So if
all
it-
reports that they have filed.
So if there is no suit
My lord.
and an MA is sprung from a no suit, whether he acquiesces it or not is
No,
of
my
consequence.
submission is this, my lord. Application for leave and application for IA numbers 1 and 2 were being heard. They were heard over almost 1.5 months. Then on the eve of the summer vacation.
Let both the matters come up together.
My only,
Number
my-
ಕೊಡಿ.
16 to 23.
my only submission, my lord, is that this stands on a separate footing because in the guise of extension of the interim order was passed by predecessor court.
No,
And without
even
hearing
according
the
to
parties.
even according to you, one is the offshoot of the other,
Please.
or the other is the offshoot of the original.
No doubt, my lord. I'm only asking, I'm only submitting this much. An interim order, right or wrong, good or bad, was passed after hearing all parties. In the guise of extending that interim order,
We'll take it day after tomorrow.
my lord would
ನಾಳೆ
have
ಇದೆಯಾ
to.
ಏನಾದ್ರು?
My lord,
Matter is there tomorrow?
No.
Nothing is.
My
Day after
lord-
tomorrow in preliminary hearing. Tag, list this petition along with writ petition so and so, not tagging but in seriatim. Yes.
Well, C number 82 was passed
Password
over.
ಕರೀತಾರೆ. ಇನ್ನೊಂದು next. 81 ನಾ?
Please, my lord.
81 and for the respondent, my lords. Idralli, to the main writ petition, my lords, I'll file my objections. The IA for stay, what they filed now does not survive. Because the reasoning what they've given in the IA is that.
ಏನ್ ಬೇಕು ನಿಮ್ಗೆ?
My lords, I'm pressing for interim order in this matter, my lord.
Ah.
My lords, ಏನಾಗಿದೆ ಅಂತ ಹೇಳಿದ್ರೆ, suit, money recovery suit was filed against me. I filed my written statement and also an application under section 8 of the Arbitration Act for referring the matter to arbitration. Since the original of the LLP agreement was not with me, but with the custody of the respondent, I filed an application to seeking a direction to them to produce the same before the court. They do not dispute the existence of the agreement, my lord, the original agreement. What they say is, if the agreement is produced before the court, I am likely to misuse it. And this contention of the
ಇನ್ನು ಮುಗ್ದಿಲ್ವಾ ನಿಮ್ dispute?
ನಡೀತಾ ಇದೆ, my
Husband and
lords.
wife dispute.
Please, my lords.
Lords, if I may
The
submit.
trial court accepts this contention and says that they need not produce the original. My IA is
That order being dismissed, not direct application
Yes.
being dismissed.
Anyway,
subject matter.
we will take it on Friday, you come. List the matter on Friday. Till then, let
Their
the
IA,
court.
my lords, does not
proceed.
survive now, if I may read out.
Yes,
Very well.
list the matter on Friday. Matter would require consideration. Therefore, the further proceedings before the concerned court shall remain stayed.
grateful.
My lords, a stay, my lords, cannot be granted at this stage. Their IA
Why
itself,
cannot
my lords, is
be
infructuous.
granted, sir? Challenge it. Yes.
My lords, my lords, please see the reasoning in the IA. They say that the IA, the order, section 8 has been reserved for
Yes,
orders.
yes.
That, my lords,
Friday.
the wrong order has been passed now.
Appearing for the respondent.
This is a matter that's where morning.
Serial number and
before
madam.
the- It's before the lunch, that's supposed to be 2:30.
Oh, dictate ಮಾಡ್ಬೇಕಾಯ್ತು. ಏನ್ ಕೇಸ್ ಇಲ್ಲ ಅಂತ.
That's, I have to make.
IA number 92.
IA number 92, my lords, I have a case which I can bring out, my lords, based on the judgment relied upon by the respondents, my lords. My lords, I won't take more than 5 minutes, my lords, to take my lords to all the papers, my lords, to show that, my lords, the application I have filed is under order 16, my lords, at the outset. My lords, even in their judgment, it goes on to say that, my lords, plaintiff, it's not a blanket rule. I have to show a special circumstance as to why I need to summon a person, that too an opposite side of mine. I am a defendant here, my lords, they are the plaintiff in
Sir,
the
you are the defendant, you are wanting to summon plaintiff.
Yes, my lords, and my lords, I am entitled to do so. My lords, I am even supported by the Supreme
As your,
Court.
as
Yes,
your
as my
witness.
witness, as my witness. My lords, I can do so. I have the provision, my lords, under the CPC, followed by, my lords.
What to do, sir? The provision is interpreted against you by so many judgments.
That, my lords, that very judgment, my lords, goes on to say that I have to establish a special circumstance. My lords, I'll be able to establish the special circumstance in less than 2 minutes, my lords, to show that, my lords, that special circumstance would entitle me. In fact, my lords, by the leave of this court, I filed this application. I can demonstrate, my lords.
We'll take it on Fridays.
My lords, Friday better.
Yeah,
That's I.
Oh. Yes. ಮತ್ತೆ ಆಮೇಲೆ ಸ್ಯಾಟರ್ಡೆ ಮನೆಗೆ ಹೋಗ್ಬೇಕಲ್ಲ.
Could we ask it for preliminary?
ಆಯ್ತು. 24th. Yes. 24th ಅಲ್ಲ 23rd Monday. An extended after party. Yes, 25th. Yes. Preliminary hearing. Less than preliminary hearing on 25th. Interim order subsisting will continue to the next date of hearing. Yes.
90.
Binu. Withdrawal of money.
It's not, that's not the way it is. I'll show my lord the order. My lord, award is passed in my favor. Subsequently, they file an application under section 34. I had deposited.
Wednesday preliminary hearing.
Please, ma'am. No, I will not withdraw any money, my lord. That I'm orally telling.
Should I record it?
No, I'm telling.
Ajesh will not. Yes. Yes.
Please, ma'am.
List day after tomorrow preliminary hearing.
Please.
Last or 18.
1-8. Second list.
I'm appearing for respondent number
One,
Ah.
this I am not the owner of the land. Probate is granted in 1990. Allegedly in 2008, he enters into an agreement with me. In 2024, he files a suit for specific performance. In the plaint, he makes a averment that he pays me money to clear the title. He makes other family members also a party to the suit for specific performance. He does not ask or seek an alternative relief.
When is the next date?
2/7.
When are you coming back? You said you're going out on 30th. List on 30th.
Acha.
Yes. Shana? ಇವರಿದ್ರಲ್ಲ ಇಲ್ಲಿ ಸಂದೇಶ್ ಚೋಟ. It will repeat. ನಾಡಿದ್ದು ತಗೊಂತ.
Except 19th ಒಂದು ಬೇಡ ಸರ್.
ಅವತ್ತು ಒಂದಿನ ಮಾಡಲ್ಲ. ಆಯ್ತು ಸರ್. Party in person, what happened?
I have filed 4 interim applications.
Correct. Office objections comply ಮಾಡಬೇಕಲ್ಲ.
The office objections are can be overruled.
Can be overruled. I saw it. It is impossible to overrule all that.
If you can give me some time, I'll give you the reasons for that. One among them is in IA number 7, in page number 206, the Sessions Court judge has put a wrong order and rule under that.
Oh, Sessions Court ತಪ್ಪಾ?
Yes, my lord. He has put under for amendment. He has put order 8, rule 1A. It is actually order 6, rule 7A. He has put it as wrong, and I can show you that.
ಆಮೇಲೆ.
And in boxes under CT, my lord. In cost title, I have put some boxes, and they have raised objections for that.
Why did you box them?
My lord, 2 writ applications I have filed before.
ಆಯ್ತು,
They didn't
ಆಮೇಲೆ.
raise any objections.
ಆಮೇಲೆ.
At the
ಆಮೇಲೆ
11th
next.
And some of them are overlapping, and they have raised objections that it has not been stitched, but they haven't left sufficient space there. But I will provide you the certified copies of those documents separately, and added to that, even the Sessions Court judge has copied and pasted them in all the orders.
Come on Wednesday morning. Office objections overruled. List in preliminary hearing on Wednesday.
And also stay proceedings at
ಇನ್ನು ನಾನು ಕೇಳೇ ಇಲ್ಲ ಏನು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಸ್ಟೇ ಮಾಡೋಕ್ಕಾಗಲ್ಲ.
not the office objection, my lord.
ಈಗ ಬಂದಿರೋದು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಅಲ್ಲಿ. ವೆಡ್ನೆಸ್ಡೇ ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್. 1 by 1. Uh, 37 ಸೆಕೆಂಡ್ ಇದು ಬರ್ಕೊಂಡ್ರಲ್ಲ ಓವರ್ರೂಲ್ಡ್. ಆಮೇಲೆ learned counsel submits office objections have been complied with office to verify and post the matter of preliminary hearing on Wednesday. ಏನ್ ಮೇಡಮ್ ಯಾರು ಅದು ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಫ್ ಪರೋಲ್
Matter pertaining to Dharwad bench.
ಫೈಲ್ ಬಂದಿದೆಯಾ? ವಾಟ್ ಈಸ್ ದಿ ಒಫೆನ್ಸ್? ವಾಟ್ ಈಸ್ ದಿ ಒಫೆನ್ಸ್? ಸಿರಾಜುದ್ದೀನ್ 302 ನಾ? ಎಷ್ಟು ವರ್ಷ? ಎಷ್ಟು ದಿನ ಕೊಟ್ಟಿ? 30 days. ಬ್ಯಾಕ್ ಟು ದ ಗೋಲ್. Extension of parole format. Yes. Same conditions. 60 days. 90 ಬೇಕಾ? 30 days remaining. 30 days. Yes. What happened?
Day after tomorrow. Gudashila.
ನೀವು ಯಾಕೆ ಸರ್? Cell number 19. So what, sir? ಅದು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಅಲ್ಲಿ ಇದೆ. ಕಂಪ್ಲೈ ಮಾಡಿದ್ರೆ ಬರುತ್ತೆ. ಕಂಪ್ಲೈ ಮಾಡಿ. ವೇರ್ ಇಸ್ ಇಟ್? ಏನು ಅರೆಸ್ಟ್ ಇಲ್ಲ. ಎಸ್
Madam, submission, my lord, list number 2, seal number 38.
Yes, yes, Kumar.
Well, list number 2, seal number 38, my lord. Office objection may be overruled, my lord, because The offence is written under Excise Act, my lord. So I need to mention rank of the parties.
No, no, that's coming for the third time, sir. I will not do it. Yes. Sure.